Yes.
Yes.
Extension of income.
Yes.
Another application.
Application, yes. Yes.
Group 1 lordship appeal application.
Yes. My lord, Group 1 appeal and application.
My lord, for inclusion in the list.
For what? What is the heading?
For inclusion lordship.
Inclusion for what purpose?
Lordship for hearing.
Yes.
For hearing, my lord.
Yes.
My lord, injunction application and section 5.
My lord, opposite
For
party.
hearing matter, my lord.
My lord,
Group 1.
Wait.
my lord, my clerk, I have sent my clerk to serve the notice, but the opposite party lawyer told my clerk that he is nowhere in this brief. That's why I am telling your lordship, this is a fact. So my respectful submission, in the meantime, I will serve the notice to the respondent concerned.
Directly.
Grateful lordship.
Do that. Hand it over.
Grateful, yeah.
Group 1 application. My
Yes.
Application.
Can't hear you.
Application in connection
Application.
matrimonial appeal, another hearing.
For hearing.
Yes.
My lord, application.
For hearing matter.
Yes.
My lord, application. My lord,
Hearing matter, my lord, group 1.
my lord, my lord, application. Group 1 here. Application, my lord.
My lord,
Application.
Yes.
my lord, for application here.
No, so I was under one predicament, my lord. My appeal arises out of a dismissal of a Order 9 Rule 13 proceeding arising out of a matrimonial suit. Whether I'll be mentioning here before
Matrimonial, now we have determination.
but it arises out of a dismissal of a Order 9 Rule 13 proceeding. That matrimonial.
Ordinary Rule 13, there is no other bench for that.
No, there's not.
If it's matrimonial, then we have determination. Yes. Call on the list.
I'm grateful. Mentioning upon notice, my lord, for inclusion, hearing. Lordship.
Yes. Call on the list.
Much obliged.
My lord, I'm appearing for the appellant husband.
I'm for the opposite.
Your appeal is against what? Your suit dismissed or their suit
My
dismissed?
lord, my suit was dismissed.
Divorce suit dismissed. Can you send it for mediation?
Yes, sir. We have no objection.
Let us have a try at
My
mediation.
my
The
lord.
present appeal arises out of the dismissal of the appellant husband's suit for divorce. Full stop. Learned counsel for appearing for both the parties, comma, on instruction, comma, submit that they have no objection if the matter is sent for mediation. Full stop. In fact, comma, since the matter arises out of a matrimonial dispute, comma, this is a fit case for mediation. Full stop. Accordingly, the file be sent to the Calcutta High Court Mediation Committee for the purpose of resolution through mediation.
Lordship.
My lord, a big copy on the my lord.
পরে ফাইলটা রেডি করে রেখে দিন, ফাইল ডাকবে না দিয়ে দেবেন। ইয়েস।
May I please, Your Lordship? Your Lordship, on the last occasion, that is on 11th of the last month.
Notice was directed.
My lord, we had said that we did not have any problem to go for mediation, my lord. The last order was passed on 11th. On 12th itself, we posted the letter, my lord, but right now it is stuck in Islampur. So, my lord, if my lord can kindly take it up on Thursday or Friday, by that time it will be served.
Learned counsel for the appellant submits that although notice was sent to the respondent, comma, the service is not yet complete. So on the prayer of the appellant, comma, let the matter stand adjourned till August 21, 2025, when it will be listed under the same heading. Thursday.
Grateful.
Thank you. Give your name, please. Yes. Yes, Mr. Mitra.
Pursuant to last order, my lord, I
Notice.
sent notice, but till late that has not been served.
We'll
Yes,
keep it
yes.
next Monday then.
Next.
Learned counsel for the appellant submits that the service of notice is not yet complete. So accordingly, let the matter stand over till August 25, 2025. Pinaki Mitra, Mr. Pinaki. Do you have a Ranjan between your Mr. Pinaki Ranjan Mitra? Yes, next.
Whether it was, I am for the appellant. Whether it
Yes.
was taken on last 11th.
Right.
Whether I have already served notice to the on 11th, but tracking report is not available.
Same order, Monday. It will appear on Monday. Give your name, please. Yes. Monday.
I sent a communication, my lord, that has been received on 16th of August.
If they don't appear, we'll send it for mediation, Mr. Paul. What is the matter arising out of your
Yes.
dismissal of it?
Only one thing, my
file
lord.
a- file
May I
a-
file affidavit of service within some time? Right? It has been delivered on 16th, Saturday. Within some time, I'll, my lord,
But
inform.
during today, you can file it.
Yes, within some
Give
time.
you that liberty.
Yes, my lord.
Learned counsel for the appellant submits that service has been effected. Service of notice has been effected on the respondent. So, on the prayer of learned counsel for the appellant, leave is granted to the appellant to file the affidavit of service during the course of the day. Full stop. At the time of call, the appellant is represented, but none appears for the respondent. Full stop. Since the matter arises out of the dismissal of a divorce suit of the appellant husband and pertains to a matrimonial dispute, we are of the opinion that this is a fit case for mediation. Full stop. Accordingly, the file will be sent to the Calcutta High Court Mediation Committee for the purpose of mediation. উনি affidavit of service ফাইল করলে তারপর ফাইলটা পাঠিয়ে দেবেন আজকের মধ্যে ফাইল করবেন উনি
Yes. Great.
do it as early as possible so that
Yes,
we can-
within half an hour, my lord.
yes. None appears for the appellant at the time of call, nor is any notice, nor is any affidavit of service filed as per previous direction. Full stop. Let the matter be listed under the same heading on August 20, 2025. 20th August. পরেরটা ready করো। Same order. আগেরটা। Respondent.
Your Honor, I am for respondent.
Appellant, led by Mr. Chitra Ghosh.
Your Honor,
Kindly be asked.
I did not found appropriate petition copy. I just found one page.
Notice was to be given for the
Yes.
purpose of ascertaining whether this can be sent for mediation.
I got notice.
So
and-
mediation, we are sending it for mediation. Let us have a chance at mediation if it can be resolved by mediation to the High Court Mediation Committee. If it's not solved, come back to court.
Your Honor, I do not found appropriate petition copy.
Yes, what do you say?
My lord, I am led by Mr. Chitra Ghosh. My lord, last occasion there was a direction for affidavit of service. My lord, it has not been affirmed.
Since the respondent is represented to, please give your name. Since the respondent is represented through counsel, the matter is taken up for hearing. Full stop. Next para. Learned counsel for the appellant submits that the affidavit of service has not yet been prepared. Full stop. We dispense with filing of such affidavit in view of the appearance of the respondent. Full stop. Next para. The conspectus of the appeal is a challenge in respect of a matrimonial dispute where there is an allegation of mental ailment, that is obsessive compulsive disorder within bracket OCD against the respondent, which is of course denied by the respondent. Full stop. Since a perspective of psychological allegations are there, we are of the opinion that the matter may be resolved by resolution. Full stop. For such purpose, let the file be sent to the Calcutta High Court Mediation Committee to have the matter resolved through mediation, by appointing at least one psychologist from its panel as a mediator. There will be at least one psychologist in the panel to assess also your. It is found out, if it is found out you don't have obsessive compulsive, then it's all right for you. But let it be done by mediation. If you fail, come back to court. Next. Here. Mr. Ghosh's junior. We don't know your name. Sorry.
Priyanka Shaha. Priyanka Shaha.
Ms. Shaha, please ensure that all the copies of the memo and the application are served on him. Take his address and give her copies.
Great.
It will be easier for the mediation to take place. Thank you. We're not putting it in our order, but do it.
Great.
This is item 10. 10. Neither the neither is the appellant represented, comma, nor is any affidavit of service filed. Full stop, none appears for the respondent as well. Full stop, accordingly, let the matter stand adjourned till August 20, 2025. দীপঙ্কর একটা এফিডেভিট অফ সার্ভিস দিয়ে যাবে, ওটা যেন ঠিক জায়গায় ঢোকে, অনিমেষ পাল দিয়ে যাবে, ঠিক ফাইলে যেন ঢোকে, তাহলে জীবন আর পাবে না।
Lordship, I am appearing for item number 11 and last
এফিডেভিট অফ সার্ভিস
service is not yet been served, Lordship. That is.
Learned counsel for the appellant submits that the notice has not yet been served on the respondent. Let the matter stand adjourned till August 21, 2025, Thursday.
August 21. Obligement.
Thanks. Give your name, ma'am. Ma'am, advocate, please give your name. Yes.
My lord, this is my application.
Yeah, your application.
Yes.
This is the affidavit. What is this?
Affidavit of service.
Yes. Yes, Mr. Pan.
Now, my lord, this is against the, my lord, admittedly.
They have been served properly?
Yes, we have served properly. My lord, admittedly, I am the wrath under section 4, under section 4.
Right.
I've prayed for conversion of the land to Vastu to commercial Vastu. That was done by the collector. I became the owner by virtue of a scheme of amalgamation approved by this honorable court. Now, my lord, when I applied for the correction of record of right, now, my lord, the wrong name was recorded. Subsequently, I sought for correction of the record of right. Then, my lord, during keeping pending that thing, my lord, I was directed, treating me as a lessee under the state, I was directed to apply for the lease under section 4 capital B of the West Bengal Land Reforms Act 1955. Against that, my lord, I moved before the tribunal.
Yes.
My lord, tribunal found that that claim for under section 4B is illegal and not founded by any law. Then, my lord, my lord, he directed the collector and directed the BLRO, in spite of the fact he admitted that he is duty bound to do the correction. Now he directed the, my lord, the BLRO to consider my representation.
BLRO said the collector.
And BLRO, on the contrary, BLRO is saying, when unheard of, that while passing the order under section 4C, collector was wrong. Collector was wrong. Well, this is the situation, my lord. If you will kindly turn to the impugn order. Well, unnecessary, I have been, my lord, I have been, my lord, put into the hand of the BLRO. My lord, kindly turn to, my lord. The impugn order. The impugn letter is at page 80 and page 79 of this petition. Then, my lord, Joseph,
Starts from 176.
inner page 13, my lord, your lordship will find inner page 13. That is the findings of the tribunal. The very existence of letters and except if referred to above suggests that the state authorities have taken recourse to administrative solicitation policy to cover up the order of conversion. The next, my lord, in fact, the state authorities have been preserving the order of conversion as precious treasure, and at the same time, they have challenged the legality and validity of such order of conversion by filing an affidavit in opposition against the original application. The BLRO is challenging this. Actually, the state authorities have been blowing hot and cold at the same time. However, fact remains that the order of conversion being such and such issued by the collector land reforms Hooghly is still in force. Still in force.
Nobody has challenged that also.
Nobody.
For a proper forum.
No. And if you lordship kindly turn to, my lord, the turn to on the basis of that conversion order, your lordship will find the conversion order at page, my lord, at page 74. Can you turn to, my lord, page 74, the order of conversion? In exercise of power conferred by subsection 2(3) of section 4C of the West Bengal Land Reforms Act, the change of classification of land as per schedule described below the purpose of commercial vastu is hereby allowed with effect from the date of this order in favor of Shalimar Wares Industries Limited, which is petitioner before your lordship. Now, based on this, my lord, I applied for the correction of record of right at page, my lord, 76.
Let us come back to the impugned order once.
Yes.
Let us continue from page 13 where
Yes.
to stop.
Then, my lord,
It is undisputed.
it is undisputed that the BLR of Shirampur Uttapara has not yet disposed of the representation in 24 filed on behalf of the applying company. 1 year is going to be elapsed very soon. Inaction on the part of the BLR of Shirampur Uttapara in the matter of disposal of such representation rights large from the attending facts and circumstances coming out from the materials placed on record. The BLR of Shirampur is under obligation to dispose of such representation in accordance with law after giving due opportunity of being heard to all interested parties. Disposal of the aforesaid divisional merit falls in the domain of the BLR of Shirampur, so we refrain ourselves to enter into the merit of the representation. My lord, kindly see, nothing left. Then, my lord, the state authorities have exercised advisory jurisdiction which is not known to law.
No, that is in your favor. They say it's optional on your part too, because state has given advice.
So, my lord, state
What
has
was the advice given?
Yes, that kindly turn to, my lord. That kindly turn to page, my lord, at page 79. Page 79.
This was, apply করলাম স্যার উত্তর এইটা বলুন।
But when I applied for, without dealing to that, then, my lord, in connection with the memo under reference, you are
Formal
asked to
proposal
submit
of lease in terms of amended provision of section 4B.
4B. Kindly
What
see.
connection is there between this and conversion?
Nothing. For conversion, if your lordship kindly turn to, before that, kindly turn to section 4C once.
Yes, yes.
Kindly turn to 4C once. 4C prescribe permission for change of area, character of use of land. A riot holding any land may apply. Your lordship has got it.
Yes,
A
yes.
riot land may apply to the collector for change of area of character of such land and for conversion of the same for any purpose other than the purpose for which it was settled or was being previously used for, or for alteration in the mode of use of such land. Now, my lord, after receiving this, their subsection 2 says, on receipt of such application, the collector may, after making such inquiry as may be prescribed after giving the applicant to the person interested in such land or affected in any way an opportunity of being heard by order in writing, either reject the application or direct a change of conversation, which exactly has been done in our case.
What is 4B of amendment?
And 4B, my lord, 4B prescribed, my lord, after amendment 4B, if you like to kindly turn to 4B, maintenance and preservation of land. Every riot,
So two has been inserted.
2 has been inserted.
No, one also, yes.
Yes. In every riot holding any land,
There's no connection. We have seen this. This has no connection with.
no connection. And ultimately,
But the question of any formal proposal for lease under 4B even. We don't
Nothing.
find it.
Because, my lord, I tell your lordship, my lord, lease only if I covered under the West Bengal State Acquisition Act and I was a lessee under the my lord, earlier.
That's a different concept.
Different concept altogether.
Where such retainer.
Or either I am holding any land in excess under section 14M. There is no such finding. And tribunal also
Even
held
under
so.
4B2 deemed to hold such land as lessee, even if it, the other conditions. Date of listing.
And I am
There's no scope of any.
no
formal
question
deed
of
being-
yes 4B.
So this was the advisory so-called you wanted
Yes.
to set aside.
Yes. This was the SRE followed by, my lord, the earlier, this was done on the recommendation of the, my lord, the additional secretary. That is the next page of 80.
So this you wanted to set aside.
Set aside.
And conversion, both.
And, my lord, for the purpose of recording my name.
Conversion is obvious.
Nothing to be left out.
Conversion to be carried out.
And my lord, my application is, my lord, kindly see what is
Sector good service, Mr. Chaudhary.
Good service.
good service.
Despite service, none appears.
Hey, appear for the
appear.
state.
Yes, what is your answer?
I'm in a very bad situation in this, my lord.
Yes, you are actually on merit.
Yes, yes, my lord. My lord, may I say this, my lord? We have talked to the officers, my lord. Now, subject to, my lord, the challenge, they should be have challenged the order of the.
There is no challenge
Collect-
against conversion
Exactly.
held by tribunal. There is no scope of further hearing.
And that has also been, my lord,
and
admitted by the
4B,
state.
that
Department.
first
Does
of
not
all,
come.
4B does not contemplate any formal lease deed.
It comes out the
Second,
riot.
it's a different proposal. And
It's above the
4B,
riots, my lord.
4B is circumscribed by 4C.
Yes, sir.
Subject to 4C.
Subject to
4C
4C.
has been complied with you.
Yeah.
So we are setting it aside. What did your officers say? That's a curiosity we have.
No, lord. They didn't say, my lord, we want to have some discussions, my lord. May I?
Have it after regarding the appeal against our order, SLP order.
Now, my lord,
Affidavit of service filed to be kept.
my lord, excuse me, my lord, one more part is there.
Will direct the
May-
conversion to be effected immediately.
No, may I?
The modification to correction to be effected immediately
Excuse me, may I
in
say
terms
this,
of
my
the
lord?
conversion.
Lordship, may I say this, my lord? I have been led by Mr. Shishano Bandyopadhyay.
Maybe we are
Now,
not
lord,
interested.
yes, my lord. What happens, my lord? May I give the, my lord, instruction? Sorry, my lord, it is marked.
No, keep your instruction with you. You have not directed you. Your instruction is privileged knowledge.
No, my lord.
We won't keep anything on record which is not a part of the pleadings.
No, my lord. Our instructions, my lord.
Yes, what is that?
Yes, my lord. Firstly, my lord, there is no iota of, my lord, that say that they, my lord, that this has been, my lord, our contention is this, my lord, they are the, my lord, lessee. They are the lessee.
What does it have to do with conversion?
No, the conversion has
They
done.
seek a conversion. They have
Yes.
got a conversion. Sorry,
Yes.
you have allowed that. That order stands unchallenged. They seek a mutation, correction of the records of right in terms of that conversion.
Yes, my lord.
What remains? Where is the question of 4B? Where is the question of advisory? Whatever.
Yes, my lord.
Where is the question of anything? Whatever has been discussed here.
Totally agree, my lord. But my lord, there is a
Then whenever our officer comes up, why are you disturbing her? You complete your submissions at one go. Whatever we are saying, you are saying no, my lord. Then whenever the dictation is started, you are saying something. You complete your submission. What is your submission on merits?
my lord, there is also provision in section 54, my lord.
54 has not been discussed anywhere.
No, my lord. Because they, by own motion, my lord, they can change. The collector can change.
It's a loose motion on its own motion in this case. There is no such motion at all.
Yes, my lord.
That's a provision of law. We are interested in the provision of law. How does it apply here? The land has been converted by you, by the state. Formal order they have annexed. That is not denied in tribunal's order.
No, that has been not only been denied, but my lord, there is a
Feel that's not good.
no, my lord. There can be challenge. They could have challenged. That has not been done. My lord, also by motion, by own motion, they can change.
Show that.
Yes, my lord.
Now, before my learned friend,
No. Mr. Pal,
my
not in this.
my
Only if we need a reply, we'll ask you.
yes, my
Section 54 of Land
54.
Reforms Act,
Yes, my lord.
which is appeals.
Yes, my lord.
for the
This is a provision for appeal.
yes.
Yes, my lord.
Where is the own motion concept?
My lord. 54.5. Yes, my lord. 54.5, my lord.
Yes.
Notwithstanding anything contained elsewhere in the Act, the state government may, on its own motion, correct any erroneous decision passed by the revenue officer
Revenue officer.
or by any officer in appeal. My lord, revenue officer.
Have you done it?
No, my lord. That's what we are intending to.
You cannot know.
My lord, one more thing, my lord. Kindly excuse me, my lord. Now to give me to come under the purview of section 4B, what they did, the mischief. If your lordship kindly turn to once, my lord, page 91. This was the wrong recording in a LR recorder, right? Page 91. In the column 6, Montopo, nothing. Meaning thereby I am a riot. Now, my lord, what they did for the purpose of coming into, my lord, to take the advantage of section 4B, page 87. Can you turn to page 87? This time, what they inserted this acquisition proceeding. State Acquisition Act. Although, my lord, I am covered by the Bengal Tenancy Act, and I was a Dakholkar, and that entire thing has been set aside by the tribunal. Now, this is the deed this is the wrong thing they have done. So, did the mischief in the record of,
If you are governed by 6.3, suppose.
and I am not. I tell you,
If you are governed by 6.3, what effect does it have on the
then, my lord, they
conversion?
have the conversion, my lord, conversion won't be done because I will be the lessee then. Conversion cannot be done because lessee cannot apply for section 4C. So this was done intentionally. So can you set aside this part also? This is also all the challenge.
Mr. Bandyopadhyay, are you apprised of the matter?
Yes, ma'am.
Now, conversion order was passed on 20th of December 2021.
Fine.
I'm sorry, not that, prior to that.
January 2018.
January 2018. Now, this correction of the insertion in the remarks column regarding 6.3
My lord.
at page 87 was dated 18th of March 2024. 6 years after that conversion order was passed.
Yes.
So how can you, revert back to a position which, after the conversion order?
For the conversion order to be passed under 4C,
Yes,
first of all, the petitioner had to be a riot.
he was recorded as a riot.
But that was the wrong recording.
Now, subsequently
that is the
negate
law.
negate what you cannot do directly, Mr. Bandyopadhyay, the conversion you did not challenge.
Lord, the 4C conversion which has been given on 2nd of January, that itself is without jurisdiction.
You have never challenged it.
Lord, our order passed without jurisdiction is a nullity. Lord. It has no value in the eye of law.
No, you cannot render it a nullity by a subsequent factual insertion in the Khatiyan.
Lord, by my stance, right or wrong stance, that they are a riot and 4C is applicable to them, but the entire history of transactions cannot be erased.
No, but you cannot do
there
that
was
after you have granted conversion.
But
And
there
not
was a
challenged it.
retention under 6.3 read with 6.1G. And my lord, if that is applicable, and today the position is that, my lord, they are only possessors of the land. They are only possessors of the land, and that is.
Right, did you give them any notice or any hearing?
No, my lord, it was for some reason, my lord, done absolutely suo moto, my lord, without any reason. Kindly see the language of 4C. Without them being a riot, my lord, it could not have happened.
But this you thought only after 6 years from allowing the conversion. And why didn't you challenge the conversion, Mr. Bandyopadhyay? If that was done without notice,
No,
it
ought to have been done. It ought
has
to
not
have
been done. What is the effect? After 6 years, can you negate an order already passed by you by virtue of an insertion in the records of rights?
Malad, I'll rather, Malad, intend to argue otherwise. That, Malad, by passing that order, Malad, I cannot make him an riot. His transactions, his documents, what happened prior to 2nd of January 2018 must show that he's a riot.
Unless the conversion order is
Today, he only
there's
has
a provision of appeal.
He only has a possessory right. And Malad, after the 2017 amendment comes in the West Bengal Land Reforms Act, Malad, they have the right to be a lessee under the state.
And where is the scope of any? They're asking for a formal deed of lease. 4B, does it permit it?
No, Malad, 4B
asked for that.
in my reading, automatically they become a lessee.
Then you have asked in that.
Automatically they become a lessee.
You have asked by that page 79 communication that you are asked to submit a formal proposal for lease.
Yeah, Malad, kindly, Malad,
that can
automatic they are a lessee, as per my understanding, Malad.
But this recording in the yes, 54.5 we can understand. Your friend was arguing that, your friend on your side. But notwithstanding anything, 554.5, this correction of erroneous decision will read some right of prior hearing into this. A notice at least had to be given to the person whose name is being changed. You cannot change my fate without giving me a hearing. And if that has been done here, apparently that has been done. This is bad, this subsequent recording. And this correction of record of right, conversion order, that was amenable to challenge. You could have
Yes,
challenged
I
that
could have challenged it, my lord.
on that ground itself.
Yes,
That you are.
I could have. I agree, my lord. But my lord, at the same time, my lord, your lordship will kindly consider whether at all an order, any authority can pass any order, my lord. It has to be seen whether the order, if the order is beyond jurisdiction.
90 days limitation.
That is what we say, Mr. Bandyopadhyay. 6 years after you have inserted something only by virtue of your recording, correction in the record of right, that this is being rendered a nullity.
May I put it in this manner, my lord?
Yes.
Whether they are a riot, whether they are an intermediary, whether they are having only a possessory right, which is being converted after the 2017 amendment to the LR Act as a lessee under the state. These are all by operation of statute.
Yes.
My action cannot be held as an estoppel against the statute. But if the flow of the rights under the statute is in A channel, my order of 2nd of January cannot take them to B channel.
This is a mixed question of fact and law. Whether they are governed by section 6.3, that is a mixed question of fact and law. Operation of statute, definitely you are right on that. Operation of statute would come in if they factually satisfy the criteria of section 6.
But retention has been allowed.
There is nothing.
Retention has been allowed. And my lord, the record of rights will say that the retention has been allowed to them.
That was done only on 18th of March 2024.
That was done in 1964.
No, the correction was done only on 18th of March. Page 90.
My lord.
See, the Khotiyan Toiri Tariq is 18th of March 2024. And Jomidari, this is shown reflected for the first time. And if we come to the next page, it was not there.
This is 9220. Malad, this is Khotiyan number 9220. I'll explain the situation, Malad.
Yes.
Malad, 9220 was the new LR Khotiyan which was created only for the other plot, only for 2.0 so and so acres of land. This is not 4162 by 1. 4162 by 1 was the original LR plot number. But kindly see page 90 top. It is Khotiyan number 9220.
Yes.
It was only created for that part.
That part of
That is 2.0, which is reflected in 2nd of January 2018.
No, that part of which Khotiyan?
4162 by 1. That is the original ROR for Shalimar Wire Industries. But I have brought but I have brought 4162 also. And your lordship will find at all these pages, starting from 87,
Yes.
are all 9220.
So therefore, if it's 9220, what is the link between 9220 and these plots at page
4162 was converted to 9220, which was the new plot number given to that. And the original record of rights suggests it is 4162 by 1.
Conversion was allowed on 2nd of
January 2018 for 2.092 acres of land only.
Yes.
Out of their prayer of 2.1 acres.
So regarding that land, that there in respect of that already conversion was allowed. And
yes.
on that date,
Only for that.
Only for that they're asking for a for the correction of the records to reflect that.
Yes,
That
only for
conversion.
that.
Only that.
On the basis of this conversion, which we
Yes.
say is without jurisdiction, which we say is a nullity in the eye of law.
No.
That too by an way of
Cannot
an
do that by
affidavit without
way of
any challenge.
subsequent correction in the records of rights suo motu.
Then Malad, kindly allow me to produce the other RORs. Kindly hear it finally on the affidavit.
Other RORs showing what?
That of the 4162, that the original retention, they are denying the retention itself. The retention of
Mr.
1964.
Bandyopadhyay, tell us this. On 2nd of January 2018, was it reflected anywhere in the records of rights that this was this fell under 6.3? It was not. Because your date of correction is 18th of March 2024. Post facto, you are trying to introduce something in the records of rights, thereby negating your earlier order without preferring a challenge. So you are doing indirectly what you cannot do directly.
That's what the tribunal held.
Malad, this old one
Yes.
reflects on the right hand side 6.3 as a noting.
This is CS right. How this can be a
This is which
60
page,
over
Mr.
there?
Bandyopadhyay?
Malad, these are
CS
pretty
right.
old records, Malad.
This
Just
CS
tell us the page.
CS record of right.
That's with you, a different.
Yes.
There can be 6.3.
Well, the old ones are at 129 on, but I have the same one in my instructions also. Yes, Murad. Your lordship will find the reflection at page 131, right hand side bottom. So mostly it is illegible, my lord, but right hand side bottom, your lordship has found, my lord.
Yes.
Vumio so and so, my lord. In the last line, kindly see 63 has been noted.
60 has been noted. This is which Khotiyan? Where do you get the Khotiyan? At the top, it's.
So this appears to be of 1960.
Yes. Prior to, has to be prior to that.
No, intention was of 1964. So this recording is after 1964. Matlab date is recorded, but it is illegible. 21st of June.
Just show us that
21st of June.
No, this is in respect of some other Khotiyan probably.
Well, this is 21st of June 1967.
All right, but what is the Khotiyan number?
Matlab this is 3972.
This is CS Khotiyan, RS Khotiyan.
Yes.
This is CS Khotiyan prior to State Acquisition Act.
No, 1967.
These are all inserted.
Kindly see the date.
Kindly see the Dakhal
21st
card.
of June
Kindly see the
1967.
Dakhal card. Dakhal card does not come under the purview of the West Bengal State Acquisition Act. Settled principle of law.
Shalimar Industries Private
Dakhal
Limited.
card does not come under the my lord.
Vociferousness does not work in this.
Sorry.
Yes.
Well, this document is of 21st of June 1967. Shalimar Industries Private Limited. Recording the earlier vendor's name is also there, my lord. Ganges Valley Bone Mill Company. Therefore, 63 was recorded prior to that. Long before. Even, my lord.
It's an admitted question that this was the previous Khotiyan number of the same Khotiyan.
Yes. There is
So that's why they have annexed here.
That's why they have annexed and their name is reflected here.
Name is reflected here.
This has been
No,
annexed.
they may have several properties.
Next one is that, my lord.
Next one. This is annexed by the state, not by me.
135.
This
Next is
is
135.
the annexed.
But this pertains to the same Khotiyan.
Pertain to the same Khotiyan. I will make myself.
It was recorded previously then. It was missed out initially in the LR Khotiyan.
So, my lord, it's not that it came for the first time. My lord, your lordship has found page 135. Right hand side bottom, same place your lordship will find. I have got the colored copy also, my lord, of the ROR if your lordship desires to see it. But it is also 21st June 1967. Then, yes, then kindly takes 137. Again.
So there has been consistently, it has been recorded
that their retainees under 63 because they were operating a mill. Now, if your lordship takes this amendment, 2017 amendment, they say that all those who are having a factory mill, except for tea garden, whatever is mentioned in 14Y, and as a retainee under 61G read with 63, they will be converted as a lessee under the state. This is what the intent was of the letter. Maybe wrongly they asked for a lease deed, etc. But that was the they were, my lord, on that pretext I am saying.
Therefore, the tribunal has relegated it for a consideration upon hearing sides.
I found that order to be in their favor.
They would get in your favor because you would get an opportunity to explain.
They
sought an outright correction of the records in terms of the conversion.
Yes, that has been converted to a hearing and thereafter following
If you
steps.
say the conversion was a nullity, then on that you may have a hearing before the
Now, if your lordships feel that I will not go into so many facts, then the only other alternative is to send it back to the authority who will
retain the order.
Who will go through the document.
Retain the order. To retain the tribunal's
order. And that is why, my lord, it may be my wrong
So if
understanding.
it was previously recorded, then the complexion changes subject to hearing.
This
Mr. Pan.
denial, they coming with a vociferously and saying there was no retention under 61G and 63, but that is not correct. And if it was 61G and 63, they could not be a riot under 4C. They were intermediary.
All right.
That was my point, my lord, that they cannot, 4C cannot apply to them.
So
It's the order
previous
of the
recording
jurisdiction.
changes the complexion. If the recording was for the first time in 2024, we would take a completely different.
You know, that was, I was also a bit taken off guard because I saw it somewhere that the old records are there.
Pan has also been taken off guard, so let him. Mr. Pan, why shouldn't both of you be heard?
Yes.
Then it would. It's arguable whether it would be a nullity.
Now, my lord, kindly see. My lord, this is CS record of right.
Pardon?
CS record of right.
Yes.
Prior to application of West Bengal State Acquisition Act 1953.
The act has been recorded there.
Kindly see, my lord, cannot be. Because I subject your lordship correction. Kindly
If
see
that
the
has
Dakhol card. Kindly see, my lord, the Dakhol card.
Yes.
This was inserted subsequently. Because this, after considering this, whether I come under the purview of the West Bengal State Acquisition Act or not, but if Dakhol card does not come under the question about the West Bengal State Acquisition Act 1953, then question of insertion of subsection 3 of section
So
6
what is
does
the
not
date
arise.
you say? This is dated what?
This is, my lord, this is dated, they have annexed, this is, they are dated, my lord, 62 or something like that, they have noted this.
67.
But this cannot be noted in a CS record of right, because on that day, RS record right was prepared. On that day, RS record of right was prepared. Because Dakholkar, against the Dakholkar, cannot be a noting that covered under subsection 3 of section 6. Because Dakholkar is prepared in a CS record of right. And after State Acquisition Act came into force, my lord, there will be a RS record of right.
So next page, there isn't any RS record.
No RS record. That exactly they have, my lord, they are mischief. They have.
These are to be decided by the authority on the
No,
representation.
my lord, kindly see, my lord, this has been dealt with by the
won't
tribunal
interfere with
itself.
tribunal's
Tribunal itself, my lord, dealt with this particular aspect.
Where?
Tribunal, yes. Kindly see, my lord, I have relied upon the relevant judgments. And tribunal has dealt with all these things. Kindly see. Yes. Yes. My lord, page 179 onward. My lord, I have argued that. And the tribunal
You
held
can refer to the internal pages, Mr. Pan.
internal page 4. Internal page 4 of the judgment. Internal page 4. The record of right issued to the applicant Salimarware Industries Limited, Khatiyan number such and such, contains an incorrect statement in column 6 thereof to the effect that the said lands are subject to section 63 of the West Bengal State Acquisition 1953. Such recording patently incorrect. No such recording in column 6 was there in the copy of the record of rights issued in respect of such land prior to rectification of name. In fact, Salimarware of Industries had acquired non-agricultural tenancy right from the erstwhile owner whose name was recorded in their RS record of right. On the date of purchase, that is on 24th of May 1962, the transferor who were non-agricultural tenants were entitled to transfer the said land. The predecessor interest Salimarware Industries Limited thus has acquired valid title in respect of the land. Subsection 2 of Section 3 of the West Bengal Land Reforms Act provides that a non-agricultural tenant holding in the khas possession any land to which provision of subsection 1 of section 3A are applicable shall, subject to other provision of the Act, retain the said land as a riot subject to the provision of section 14A prescribing the ceiling limit. In case of applicant Salimarware Industry, there was no question of application of the allowing retention in excess land either under section 14J2 of the West Bengal Land Reforms Act or section 61G read with section 63 of the West Bengal State Act 1953. as the land of Shalimar was as well as below the prescribed ceiling limit. Section 4 of the West Bengal land also provides that a riot shall be the owner of the plot of land with heritable and a transferable right. Non-agricultural tenants were kept outside the purview of the West Bengal State Act of 1953. In view of the settled law regarding the non-applicability of the West Bengal State Acquisition and to the non-agricultural tenants, there is no manner of application of Section 4B2 of the West Bengal 1953.
But these questions were required to be decided then by the tribunal at least.
Tribunal decided, my lord.
Is that decision?
Yes, tribunal decided and held in our favor. That's why,
That
my lord,
decision-
they have take this resolution.
Decision starts from page 8.
Yes, my lord, in your page, my lord,
8.
my lord, can you see? Decision. The learned advocate for the applicant company has submitted that a Shalimar Wade Limited purchased a non-agricultural land measuring acre such and such, Hooghly from one Messrs. Company, now strength of the registered deed of conveyance, date ato. Next, the learned advocate for the applicant company has submitted that the petition in interest of the applicant company was guided by the West Bengal Non-Agricultural Tenancy Act in respect of the such and such. So, according to the learned advocate, the applicant company, like its petition interest, is also guided by the West Bengal Non-Agricultural Tenancy Act 1949 in respect of the aforesaid land, and therefore question of application section 461G and section 63 of the West Bengal State Acquisition in respect of the said land purchased by the applicant company does not arise. Learned advocate has further contended that the law is well settled regarding non-applicability of the West Bengal State Act 1953 to non-agricultural tenants, and the provisions laid down in section 4B2 of the West Bengal Land Reforms Act is no way applicable to that land owned by the applicant company. In support of his concern, learned advocate cited following judgment of the Honorable Court. Then, my lord, I cited this judgment. Then learned applicant company has urged that an order of conversion was issued by the collector under section 4C of the West Bengal in respect of the subject plot of land, that the order has not been challenged till date by the state, and therefore BLRO concerned is bound to give effect of such order of conversion in the relevant record of rights. Next point raised by the learned advocate for the industry is that state has no right to ask for the applicant company to submit a pair for lease, particularly when the order of conversion is to the relevant points of land has been issued by the collector and BLRO Hooghly. The learned advocate has pointed out that the affidavit in opposition has been affirmed by the BLRO Sirampur, Uttarpara, and being a subordinate officer, he has criticized the order passed by the ADM BLRO Hooghly. Referring to deed number such and such, learned government representative has submitted that nothing emerges from the said deed which goes to indicate that either the transferors themselves or organization was a non-agricultural tenant under the West Bengal Non-Agricultural Tenancy Act 1949. Next, the government representative has submitted that while determining the nature of tenancy, the purpose of which the right of tenancy was originally acquired shall have to be considered. According to the government representative, tenancy in the land in question was Malik's and Lakhesdar, as it appears from the finally published ROR, and there is no documentary proof that such intermediate tenancy was put to a lawful end, and any new type of tenancy was created under any lawful agreement and or contract with the erstwhile proprietors who were the superior landlord. Learned government representative has further added that non-agricultural land also stood vested, when he marked this post, vested to the state. The combined operation section 4 and 5 of the West Bengal State Acquisition Act on and from the date of vesting. In support of this submission, learned government representative placed reliance on the decision of this honorable court on the honorable such and such. Referring to section 46 and 47 of the West Bengal Non-Agricultural Tenancy Act, the learned government has pointed out that not a single scrap of paper has been filed on behalf of the applicant company showing payment of rent as non-agricultural tenant. Learned government representative has submitted that applicant company was never a riot prior to the amendment section of 442 of the West Bengal Land Reforms Act. On the other hand, the instant applicant company was a conditional retainer under section 6.3 West Bengal State Acquisition Act, and after insertion of section 4B2 of the West Bengal Land Reforms Act, the applicant company has become a deemed lessee, and such section 4C of it is not applicable in respect of the instant application company. Learned government representative further submitted that it is unfortunate to note that order of conversion was passed in favor of the applicant company in contravention of the statutory provision, and the order was passed by the authority without having any jurisdiction to pass such order. In fact, according to the learned government, the quasi-judicial
Question was not decided by the tribunal at all.
This has been decided. Well, that's why he has said.
Tribunal bypasses that. Tribunal says
Similar, they have said,
we have gone through the original application, affidavit in opposition, etc. it is obvious that instant original is an application for inaction, and then centers around that collector's order of conversion was never challenged, and therefore. But if that other argument is correct, the tribunal at least had to see the previous records of right and to ascertain prima facie as to whether it was actually came within the purview of section 6.3. That recording is there in the records of rights, previous records of rights also, prior to your conversion order.
Not subject to your lordship correction. My lord, what they did, if your lordship kindly turn to the annexure, that is the annexure at page, I shown to your lordship that particular record of right, which was done, for which I sought for correction in the name of the.
Now, page 90 is not the first time that this is being said.
No.
Because there are previous recordings also, like page 129, 130, those pages.
But this was recorded in the wrong name, instead of my Salimar Industries Limited.
Yes, but the property was, if it is recorded that section 6.
But that was not recorded. Kindly see, my lord, that was not recorded. Subsequently, that was inserted.
Oh, no, 129, 130, 131, these were much previously recorded.
But kindly see, my lord, kindly see. Kindly
Page
turn to my lord,
129.
page 91. Page 91 once. This was, my lord.
Yes.
This was under, my lord, subject to your lordship correction. In the CS of record of right, there cannot be any reflection of any provision of West Bengal State Acquisition 1953.
We don't have the arrest record, so we don't know what happened there.
I don't know.
That
But
was to be inquired
LR
into.
record of right is there. Kindly direct them to produce the arrest record of right. Because the document which they are relying upon cannot be relied upon and cannot be said that this was done after the coming into force of the State Acquisition 1953, since this is a CS record of right, and I was described as a Dakholkar. And if I am a Dakholkar, my lord, that any provision, no provision of a State Acquisition will apply to me. No provision. That is a settled law up to Supreme Court. Up to Supreme Court, my lord.
Cost of interruption, my lord, may I suggest, my lord, these records have been described as arrest records at page 114, which is my opposition before the tribunal.
Might have, you have described yourself as opposition, but
114,
record does not reflect so. You may say so many things. If BLRO is challenging the order of the collector without preferring appeal and in an affidavit in opposition.
No, one thing, if it is recorded in the arrest records as like this 6.3, then Mr. Pan.
Yes, if there is
then it would be a nullity.
I cannot. I tell you.
Because of lack of jurisdiction, inherent lack of jurisdiction.
Can you see, my lord? Page 91. They had the opportunity. They have annexed the CS record of right. They had the opportunity to submit the RS record of right, but they have not.
They had argued at length, but the tribunal did not consider these.
My lord, they have, tribunal has considered their submit. Well, kindly turn to page 91.
Recorded their
page 91. Page 91. Kindly turn to page 91 once. Well, kindly turn to page 91.
Mr. Pan will direct the concept, they remand it to the tribunal itself to consider the stand taken by the state. This has to be ascertained whether if it is not a nullity, then they definitely they have to be directed to correct the records of rights. But if it was a nullity, it has to be ascertained whether what was the position in the arrest records. And since they say that these are the arrest records, so we cannot, without going through the originals, we cannot look into it.
Well, kindly direct.
We will not relegate ourselves.
Kindly instead of remanding back, your lordship knows, date are being given after 1 year. Then in this matter, in view of your lordship's intervention, the matter was disposed of. We moved before your lordship, and your lordship was kind enough to direct the tribunal to dispose of this thing. Now, because I cannot run the business because of this. So, my lord, kindly do one thing, my lord, kindly direct them to produce the record. Because all the records are with them. And kindly
we will relegate ourselves to the fact
and we will lose a forum also.
No, kindly see, my
lose a forum also.
Kindly see, my lord. Your lordship is concerned only with the arrest record of right. If it is the arrest record, because they have not produced it, they have produced CS record of right. There is hardly any chance.
No, if Mr. Bandyopadhyay is correct in saying
115 bottom.
115
bottom. They must have rejoined it to it. They must have said I am wrong. Kindly see 115 bottom. That is my opposition. They were having knowledge of that.
Yes.
Finally published RS Khotians. Yes. That is annexure 1, which I placed. Pages so and so.
Yes.
They must have used a rejoinder saying that.
Yes, I have filed a reply to that. And that is also annexed in the reply. Yes.
What is your answer in your reply? What is your reply?
Yes, kindly turn to my lord, page 171. Page 71.
1 or 171?
171. They are saying about this is the finally, I have said.
Right.
That with difference that I say that the deponent has failed to understand the true spirit and scope of section 4, 5, 6 and 44 2A of the West Bengal State Action Act, and also failed to understand the applicability of section 4B of the Land Reforms Act concerning the facts of the case and the issue involving the instant act applied. In this connection, I further say that the having regard to the admitted fact related to the tenancy of the applicant company and in view of the recent judgment of the Honorable High Court Calcutta such and such, there could be no application of section 4.3. I have said so.
Don't deny that it's a arrest record.
Arrest record not denied.
Never say it's CS record.
But they have, well,
Never say. If these are the arrest records, then they have a point in saying it was already there. Just because they
Because, well,
omitted, they have a power under section 54(5).
no, but there is a power under section where subject to your lordship correction. If anything under the state acquisition is being done, there is under section 44 2A. The revision is to be done. Correction of record of right can be done if it is anything wrong, that is under section 44 2 capital A. This is not the, my lord, this is not the certificate that has been produced.
And 54(5), what is your take on 54(5)?
54(5) after publication of the finally record of right under the West Bengal Land Reforms Act. They are talking about, my lord, the arrest record right prepared under the West Bengal State
Correction effected in 2024 was done under 54(5), they're saying.
54(5).
And 54(5), the 2024 correction was done under
Well,
that.
54(5).
But the previous arrest records reflected that it's it is covered by section 6.
Kindly give me a moment, my lord.
Yes, absolutely. Section 54(5).
Yes.
If section 54(5), section 20, the 2024 correction was the first correction, we would be with you. Definitely, we were with you.
No,
but if in the arrest records it's reflected,
no,
was
kindly
reflected at the juncture when-
kindly see, my lord.
Let the tribunal decide this, Mr.
Kindly see, my lord. My way of understanding is this, my lord, that
Yes.
45 is not applicable in this case because notwithstanding anything contained elsewhere in this act, the state government may, on its own motion, correct any erroneous decision passed by the revenue officer or by any officer in an appeal under the foregoing provision of this section. And such
This is,
order.
you're right. You're right that they can correct a decision, but not the records.
My lord.
Very well. We take your word on that. Even if that be so, let us ignore the 2024 correction.
My lord.
If CS records, it was recorded in the CS records without any foundational basis of altering that, how could then in the LR records it could be changed?
My lord.
That question also has to be looked into.
My lord.
Then CS records would prevail. Unless you show a foundational fact.
Yes.
Of
that is my foundational fact. CS record of right. Now,
arrest records reflect. They say arrest records you don't deny. If the arrest records reflects, it's covered by 6.3.
Yes.
Then LR records cannot vary from that.
No, cannot vary from that. But that recording, only decision can be rectified under section 44(5).
They have not. We accept your point. You are right. We were.
So this cannot be done under section 44(5).
If this cannot be done, then 2024 correction is bad also. But the position remains that arrest records were already there reflected. In the arrest records, it was reflected that this is covered by 6.3 of the Estate Acquisition Act. If that was so, that was prior to your conversion order of 2018.
Yes.
If that be so, the conversion order is a nullity.
Now, my lord, kindly see, my lord. In our application, in the original application before the tribunal, we categorically dealt with.
You argued at length, Mr. Pan. You argued very well, but that was not decided by the tribunal. We are saying that instead of relegating to the BLLRO, let the tribunal decide this point, so that they both of you will lose one forum, the first forum, but let there be some balance be struck between that. If we decide, you lose both forums. If the BLR decides, you have both forums. But if you are directing tribunal to do that, both of you are losing one forum. So that's a bargain which we have struck with Mr. Bandhavardhan.
So, kindly do one. I am praying your lordship one indulgence.
Yes.
Kindly make it a time-bound program where time.
We will do that.
Yes.
Because
so that
you said your business is suffering, and we'll record that also.
Yes.
That will be the reason for our.
Kindly formulate the point also, my lord, so that they can decide. Kindly. Kindly do that, kindly. Otherwise, my lord,
Wait,
again,
in a
Yes.
discussion, a short discussion. My lord. Please take your seats, Mr. Pan and Mr. The scope of the present challenge to an order of the tribunal dated March 28, 2025 is limited. Full stop. The petitioner number one, the petitioner number one company applied for conversion of certain plots of land in LR Khotian number 4162 by 1. Full stop, by an order dated January 2, 2018, comma, such order of conversion was passed by the collector under section 4C, capital C of the West Bengal Land Reforms Act 1955. Full stop, subsequently, comma, when the petitioners approached the appropriate authority for effecting correction in the records of right pursuant to such conversion, comma, there was prolonged delay on the part of the authorities, and by a communication dated December 20, 2021, comma, the petitioner number one was intimated that a formal proposal for lease in terms of the amended provision of section 4 capital B of the 1955 Act be submitted by the petitioner number one company. Full stop. Next para. Challenging such action on the part of the state, comma, the petitioners preferred a challenge before the tribunal, preferred an application before the tribunal. Full stop. Next para. Before the tribunal, comma, the state took an objection to the effect that the order of conversion was a nullity in view of the collector not having any inherent jurisdiction to pass such an order in view of the plot in question being covered by section 6 within bracket 3 of the West Bengal Estates Acquisition Act 1953. Full stop. Next para. It was argued on behalf of the state at length as to the purported history of the land. Full stop. The state argued that the tenancy, that the land in question, that the tenancy in the land in question was within double inverted Malik's MALIKS double inverted close, the power double inverted Lakheraji LAKHERAJI double inverted close, as it appeared from the finally published records of rights, and that there was no documentary proof that such intermediary tenancy was put to a lawful end. Full stop. Next para. Accordingly, the state argued that section 6 of the West Bengal Estate Acquisition Act was applicable. Full stop. Next para. The petitioners, the present petitioners, comma, however, comma, controverted the said allegation and contended that the plot in question fell within the ceiling limit under either the under both the Estate Acquisition Act, West Bengal Estate Acquisition Act, and the West Bengal Land Reforms Act, and as such, comma, in any event, comma, would be outside the purview of section 6 within bracket 3. Full stop. That apart, comma, it was argued that the state never challenged the order of conversion dated January 2, 2018 under section 54 of the West Bengal Land Reforms Act 1955, and as such, the said order has attained finality, and the entire decision cannot now be reopened suo motu by the state merely by inserting in the LR records of right in the year 2024, comma, an observation in the remarks column that the plot in question is covered, that the Khatian in question is covered under section 6 within bracket 3 of the 1953 Act. Full stop.
And at the bottom.
Pardon?
And also at the bottom of the page.
Yes. Next para. The learned tribunal, comma, while recording the narrative of the argument of both sides, comma, without deciding the said issues, comma, straight away went into the question as to whether the state was justified in issuing the letter dated December 2021, thereby directing the petitioners to submit a formal proposal for lease in terms of Section 4 capital B of the 1955 Act, bracket A, as amended. Full stop. Next para. The tribunal observed that the same was done in advisory jurisdiction and it was optional for the petitioners to ignore the same or to abide by the same. Full stop. However, comma, the tribunal, comma, instead of directing the respondent authorities to straightaway correct the records of rights by reflecting the conversion of the land, comma, treated the application for rectification to be a representation and directed the BL and LRO to decide the same on merits upon giving appropriate opportunity of hearing to all concerned. Full stop. Next para. Upon carefully considering the submissions of the parties, comma, we find that there are two aspects to the matter. Full stop. Undoubtedly, comma, it is an admitted position that the conversion order dated January 2, 2018, comma, annexed at page 74 of the writ petition was never challenged under Section 54 of the 1955 Act, comma, nor was the said order reversed or modified suo motu by the state under Section 54 within bracket 5 of the said Act. Full stop. Next para. Viewed from such perspective, comma, the said order has otherwise attained finality and no option was left for the state but to comply with the application of the petitioners to correct the records of rights pursuant to the said conversion order. Full stop. Next para. However, comma, there is a second perspective to the matter. Full stop. Next para. The state has relied on several documents and claimed that those are the arrest records of rights, comma, where it was specifically observed that the Khatian and the concerned plots in question are governed under Section 6 within bracket 3 of the West Bengal Estate Acquisition Act 1953. Full stop. Such recording, comma, if actually existent, comma, would have been done much prior to the conversion order dated January 2, 2018. Full stop. As such, comma, in the event the Khatian and the plots were governed under Section 6 within bracket 3 of the 1953 Act, on the date of the conversion, comma, the order of conversion would arguably be a nullity, comma, in view of the collector having inherent lack of jurisdiction to pass such an order under Section 4 capital C of the West Bengal Land Reforms Act 1955, comma, in which case, comma, it would also be arguable that the said conversion order might as well be ignored. Full stop. Comma, even without a challenge to the same, comma, being a nullity ab initio. Full stop. Next para. The learned tribunal, comma, despite both parties having addressed the above issues, comma, failed to come to a conclusion and unnecessarily relegated the adjudication to the BL and LRO, comma, thereby shirking its responsibility in deciding the said questions on merits. Full stop. Next para. As such, comma, the ends of justice would be self-served and unnecessary litigation would be saved if the tribunal is directed to re-adjudicate the matter upon deciding all the issues as indicated above. Full stop. We make it abundantly clear that we are not undertaking that exercise by directing affidavits, comma, since in such event, comma, both parties will lose a forum and it would be inappropriate, comma, since the writ court would then convert itself to a fact-finding forum on questions of fact which are to be decided on taking evidence, comma, which is not permissible in law. Full stop. Next para. However, comma, insofar as the letter dated December 2021 issued by the additional district magistrate and district land and land reforms officer Hooghly to the petitioner number 1 vide memo number X/C/6 within bracket 3/99/5756 is concerned, the same was patently dehors the law, since even under section 4 capital P of the 1955 Act, there is no scope of a formal proposal for lease being sought, as in such event, the status of a lessee would be conferred by automatic operation of law. Full stop. Next para. In view of our above discussions, WPLRT 107 of 2025 is disposed of by setting aside the order, the impugned order dated March 28, 2025. Sorry, March 28. Yes,
27th March.
March 27.
27th March.
যেখানে যেখানে মার্চ 28 বলেছি 27 হবে, ওটা কভার পেজটায় 28 লিখেছে। March 27, 2025 passed in OA number 1608 of 2024 within bracket LRTT and remanding the matter to the tribunal for adjudication on the issues as enumerated above, upon giving fresh opportunity of hearing to both sides, without being influenced on merits on the observations made above. Full stop. Next para. However, insofar as the impugned memorandum dated December 20, 2021, whereby the petitioner number 1 was directed by the district land and land reforms officer, Hooghly, to give a formal proposal for lease is concerned, the said communication is hereby set aside, as there is no scope under section 4 capital B for such a formal proposal to be sought for. Full stop. Next para. In view of the long time which has elapsed in the meantime, and in view of the submission of the petitioners that their business is being hampered due to the pendency of litigation, the learned tribunal is requested to dispose of the matter afresh in terms of the above directions as expeditiously as possible, positively within 6 months will give the tribunal.
Kindly see,
It's hard pressed.
No,
6.
Can it not record it? Only the hearing function from 11:30 to 1. There is the only functioning. After
That is the reason
that,
we'll give them 6.
kindly make it shorter time.
Positively within 6 months from the date of communication of this order to the tribunal. No rest to cost.
One more thing, my lord. My lord, I am disputing that is the arrest record of right. Can you record that?
No, they have not
Otherwise,
disputed on pleading.
My lord, kindly see, my lord.
So after I argue the matter,
After line at Koda, it
Yes.
is made clear that this court has not entered into the merits of the contentions of the parties, and it will be open to the parties to raise all issues before the tribunal. And if so raised, the tribunal will be at liberty to decide those without being, we have already said that, independently on its own merits, on their own merits in accordance with law. We have already said that it will not be prejudiced. All issues can be raised.
grateful.
But issues, they will also be permitted to raise the issue that you did not take that point in your affidavit.
Yes, sir. That they may. Your record ultimately only the record which will speak.
Thank you.
Grateful, my lord.
Obliged.
I'm for the petitioner. Beg to represent the state lordship.
Yes. Yes, what is the matter?
It's a Bargadar issue now.
I Borga.
May I file the
So
affidavit?
what we are I Borga? Yes.
May I file the affidavit of service, my lord? I'm for the petition.
What is the matter, please?
My lord, in this.
All have been served. There are private respondents also.
There is a
Yes,
private
my lord.
report.
Has been served.
Yes,
Have you checked
my
up?
lord. Yes, my lord. Yes, my lord.
Check up. If you have any doubt, check up. Eta din. Just check up and then we'll start.
Private respondent, please check.
Lokhi Hasda. Just check up whether she has been served.
Please check now. Yes, my lord. She has received.
Very good. Hand up. Yes,
In-
please.
In,
what is
in
it?
this application, my lord, I have not challenged the order of the LRTT, whereby the respondent number 5 has been recorded as a Bargatan in respect of the said land. I am the owner of the land. What happened? Let me just briefly discuss, my lord, the background of the case. One, Hopna Murbu was the original recorded Bargadar of the land. That recording itself is disputed, my lord. The petitioner says that recording of Hopna Murbu was done erroneously. After the date of the Hopna Murbu in 2009, almost 1 year passed. Thereafter, someone claiming to be his son, one Budrai Murmu, came up with an application for recording his name as a Bargadar in respect of the said land as per 15A. Thereafter, my lord, that application was rejected. He was not entertained, he was not recorded as a Bargadar of the said land. Subsequent to that, after his date, he died in 2011. This respondent number 5 came up with an application saying that she is the husband of the said Budrai Murmu and requires to be recorded as a Bargadar in respect of the said land. That application, my lord, was allowed by BLRO. Subsequently, we challenged that before the SDLRO. It was
The husband's rejection, that order have you annexed here?
my lord, that order has not been. I
Do you
cannot.
know the challenge or whether on merits or not?
I have that. Means that is already there in the pleadings. I have asked the client.
Pleadings won't do,
I
sir.
have asked the client, my lord, to obtain a certified copy. But he is unable
It is
to.
not before both the forums below. Even if you obtain a certified copy, now no use.
I can understand, my lord. That is there. I asked.
So that is your primary ground of challenge.
I can totally understand that. That is the thing that I actually.
We are
Subsequently,
handicapped without that.
another thing, my lord, I just want to point out the name of the one Budrai Moon was never recorded in the ROR. So, my lord, on that ground, how can the respondent number 5 come up with an application? Because the heritable ground is inherent.
No, whose name was recorded? His father's name.
Yes,
I mean this lady's father-in-law's name.
Yes, my lord. Yes, my lord.
If that be so, by it's heritable, so she comes.
But respondent number 5 currently is not cultivating the said land, my lord, is being there for without any cultivation. He's not cultivating the said land. Is lying vacant.
Have you got the let us see the orders. The first order, BLLR order first.
Yes, my lord.
My lord, page 13, 1-3.
Thanks.
Under section 18.
The order starts from page 12.
12, right. You are given a hearing in this.
Yes.
What was your stand? Let us see.
My lord, here.
Admission. Analysis, page 13. The landowners stated at hearing that the legal heirs to the deceased Borgadar has been cultivating their possession.
You are Mr. You are Mr.
I'm.
What is your name? The advocate's name.
Satvik Rao.
Raut.
Yes,
Mr. Raut, what do you say to this? Well tried, but better luck next time. What can we say? You are handicapped. You tried your level best. You started with the right things. That much we can give you. But it had to end there ultimately. It's your admission before the Borgadar, right?
That
so
is
cultivation ground goes. You cannot improve your case. Might be these people are not, but you are not, may not be illiterate or something like that. The Borgadar may be.
Yeah, that I cannot.
So you admitted this, and it's a recording of fact. And the other ground that her husband's name was application.
That order, my lord,
that is not with you.
To
How do you get to know? It's maybe your figment of imagination also.
But otherwise, the order, the name should have been there in the ROR, my lord.
He did not apply, but his wife applied. They have been cultivating.
But
if they skip a generation, I mean, skip one person in the link, still it's heritable. A heritability remains. It is being inherited.
At present, my lord, the respondent number 5 is not cultivating the land.
Often it happens in electricity matters. Don't you see that the meter stands in the name of the grandfather, the grandson is enjoying. Never change. Grandson for the first time applies for change. Father never applied. So it's done. I mean, there's no difficulty in that. I mean, Mr. Galib, what is your we know that you would be fair on that. What is your instruction on this? That interim person's, the husband's rejection. Yes. Do you have any instruction on that?
No, I don't have. That Bhakchash case number 2 of 2010
Yes, my lord.
was opened on the application of this Budrai Murmu, the husband of Lakshmi Hasda. So it says it was rejected. What was the ground for rejection, my lord? I have not yet received. But
Where
it's
is
a
that? Where do you
heritable-
find that?
No, from the pleading I find.
That is there in the impugned
No,
order.
did you take this point before the
Yes,
first
my
forum?
lord. Yes, my lord.
Show us that. Away from all legal layers.
And in the appeal before the HDLRO, my lord, I have taken that point. That will, my lord, will find at page number 16. Point number 3.
Yes, but for the first time before the appellate authority.
That is not recorded, my lord, but I have taken that point. That is not recorded in the order. Before the first appellate forum, I have taken that point.
Can you do it for the first time? How was it dealt with by the appellate authority? Let us see that.
Lord, appellate authority's order
Yes, 16.
at page my lord 18.
Neighbor.
Page 18, lordship.
Is
Which
that
was
point
under challenge before
considered?
LRT.
They failed to- That is not dealt with by the appellate
That has not been dealt with.
No, you have not stated specifically that. Ground 3 have stated her husband never claimed himself as Borgadar. That's why. Page 16, ground 3 you relied on your
Can't
appeal.
claim herself, my lord, as Bargadar by her inherited, as her husband never acted as Bargadar. Means he has not been he's not been
Not been
recorded.
pleaded any order of rejection of his application. That is not pleaded here.
But
But
here,
record, my lord,
here it has
recorded
been said that her husband never acted as Bargadar on the ground that her husband has not been recorded as a Bargadar
It's
in the
not taken
ROR.
specifically here also.
That is,
Not recorded, yes. Not
Yes,
recorded, there is no
yes.
doubt on that.
yes.
They are not disputing that. But therefore, no, your first argument before us was on a higher ground. He made an application that was rejected. That is not taken even in your grounds here. In your ground 3 says husband never sought for being added as a Borgadar, recorded as a Borgadar, and he was never
No, no,
recorded.
my lord. Ground 3 says that she cannot claim herself to be a Bargadar because her husband was not recorded as a Bargadar. Saying
There's
that,
a qualitative difference between the two.
yes, my lord.
It's one thing saying that her husband was never recorded as a Borgadar, and another thing saying that he applied for being recorded but was rejected by an order. That's never pleaded even before the appellate authority. For the first time, you're saying here.
No, that is there in the before the tribunal. That pleadings was there before the tribunal.
Tribunal for the first time, you cannot take any point. Sorry. Sorry, Mr. Raut, sorry. The present challenge has been preferred against a judgment and order of the Land Reforms and Tenancy Tribunal, whereby the challenge preferred by the present petitioners to an order of the HDLLRO in appeal case number 80 of 2012, which arose from an adjudication that the private respondent number 5 was a Borgadar and affirming the same, comma, was turned down by the tribunal. Full stop. Learned counsel for the petitioner submits that the petitioners are the recorded owners of the property in dispute. Full stop.
Only one petitioner, my lord.
Sorry. Thank you. The petitioner is the recorded owner of the land in dispute. Full stop. Next para. It is contended that all the forums below failed to consider that although the private respondent number 5, Lakshmi Hasda, comma, the daughter-in-law of one Budrai Murmu,
No, daughter-in-law of Hopna Murmu.
of one Hopna Murmu, Hopna, Hopna Murmu, comma, was recorded as a Borgadar, comma, the forums overlooked the fact that the son of Hopna, comma, namely one Budrai, comma, the husband of Lakshmi Hasda, comma, was never recorded as a Borgadar. Full stop. Next para. It is argued that in view of the son of Hopna Murmu himself having not been recorded as a Borgadar, comma, his wife Lakshmi, comma, claiming through her husband Budrai, comma, whose name was never recorded as Borgadar, comma, did not acquire a right to be recorded as a Borgadar. Full stop. Next para. It is insinuated by learned counsel for the petitioner, writ petitioner, that an objection was taken before the tribunal to the effect that the said Budrai, comma, husband of private respondent number 5, comma, had applied for being recorded as a Borgadar, but such application was rejected by the authorities. For next para, secondly, comma, it is argued that the private respondent number 5 did not prove before any of the authorities as to her still cultivating the land in question and satisfying the criteria which are otherwise necessary to be declared as a Borgadar. Full stop. Next para. Learned senior government advocate, comma, while opposing the application, comma, contends that insofar as the second ground of challenge is concerned, comma, the landowner stroke writ petitioner himself admitted before the first forum that the legal heirs of the deceased Borgadar have been cultivating the aforesaid suit property since after the death of the recorded Borgadar.
So, my lord, Somar, in terms of section 21B, it goes against him. Kindly see the presumption in section 21.
As such, comma, the presumption under section 21B of the said act of the West Bengal Land Reforms Act operates, and the presumption is against the landowner. Full stop. Next para. It is further submitted that no order was produced on behalf of the petitioner stroke landowner before any of the authorities or even before this court to indicate the rejection of any application by Budrai, comma, the deceased husband of respondent number 5, Lakshmi Hasda, and as such, comma, there is nothing for the court to come to a conclusion that such application was dismissed on merits by holding that Budrai did not qualify as a Borgadar. Full stop. Next para, it is further argued that merely because the name of Budrai was not recorded does not preclude the private respondent of 5, comma, who also claims as a successor by way of inheritance, although through her husband Budrai, comma, but from Hopna, comma, the original Borgadar, comma, nothing in law prevents her from being recorded as a Borgadar. Full stop. Upon a careful consideration of the materials on record, we find that the argument that an application filed by Budrai, comma, the husband of private respondent number 5, for being recorded as a Borgadar was rejected by an order has been made for the first time before this court. Full stop. The materials on record do not reflect that before the tribunal.
Yes.
before the tribunal. Full stop. The materials on records do not reflect that such objection was raised either before the first forum or the appellate authority, comma, against which the challenge was preferred before the tribunal. Full stop. Thus, comma, such factual question could not, comma, in any event, comma, be taken for the first time before the tribunal. Full stop. Even otherwise, comma, there is not a scrap of paper to indicate as to whether any application was actually made by the said Budrai, and if so, comma, whether it was rejected or whether it was rejected on merits which might have precluded his wife, comma, the respondent number, private respondent number 5 herein, comma, from being recorded as a Borgadar. Full stop. In the absence of anything of such sort, comma, we are unable to accept such submission of the writ petitioner. Full stop. The mere fact that an intermediary in the chain of succession, comma, in the present case, comma, Budrai, the husband of private respondent 5, not being recorded as a Borgadar does not preclude a subsequent successor within bracket private respondent number 5, bracket closed, comma, who claims as the wife of the deceased Budrai, but as the daughter-in-law of the original Borgadar, recorded Borgadar Hopna, comma, from being recorded as a Borgadar. Full stop. The only test to be applied is whether the person applying as a Borgadar is a successor of the Borgadar by inheritance in any manner whatsoever, comma, the stage of succession or the degree of succession not being relevant. Full stop. Next para. Hence, comma, there was no error committed by the learned tribunal or either of the forums below in recording private respondent of number 5 as a Borgadar. Full stop. Next para. Insofar as the issue of whether the private respondent of 5 is still cultivating the disputed property, comma, since the petitioner himself, comma, before the first forum categorically admitted that the heirs of the deceased recorded Borgadar Hopna have been cultivating the suit property since after his death, comma, there is no scope of the petitioner resiling from such position at this juncture. Full stop. Accordingly, comma, we do not find any illegality or jurisdictional error in the order of the tribunal. Accordingly, WP LRT 115 of 2025 is dismissed on contest, comma, thereby affirming the impugned judgment and order dated December 24, 2024, passed by the learned tribunal in OA 247 of 2017 within bracket LRTT. Full stop, comma, thereby affirming the order recording the name of private respondent of 5, Lakshmi Hasda, as recorded as a Borgadar of the disputed property. Full stop. There will be no orders to cost. পুরো অর্ডারের আগে একটা করে দেবে affidavit of service filed to be kept on record. Despite service, none appears for the private respondent, although the state is represented along with the petitioner. Full stop. Accordingly, the matter is taken up for hearing ex parte against the private respondent.
Obliged, my lord.
Come back for the next matter.
But this writ petition is not directed against the order passed by the tribunal.
Yes.
Only point is involved, 2 points are there. First point is whether a proceeding once concluded finally, whether that could be again reopened.
Ms. Maiti, can you please come a bit closer to the microphone?
My lord.
Can you please repeat that point once?
Your lordship,
First point is concluded contract.
concluded proceeding could be reopened after lapse of about 25 years.
Proceeding under what? Which provision?
First of all, I shall place this document before your lordship to consult the matter. Your lordship kindly have a look to page 31. Page 31 is the order passed by the appellate authority at that time, my lord.
Page 31.
Page P1 starts from page 30 and the relevant starts, the order, my lord, actually starts from page 32.
Yes, 32.
State of West Bengal versus State of West Bengal, Sri Khetra Mohar Khatua. He is my client.
Yeah.
This appeal having been heard on 14th February 1963 in the presence of so and so, my lord.
No, who are the appellants?
At that time, appellant was, I was the appellant at that time. My predecessor in interest was
You are Khetra Mohar Khatua.
Khatua.
Both state and you have been depicted
No, I
as
have been made party by this way. I have been made party by this way.
They are the successors of Khetro Mohan Khatua.
Yes. Now
I was a respondent in this proceeding.
Because the original in the year 1957 the suit was. And this is based at
suo motu started below.
1961. At that time he was alive.
First order, which was passed under section 5A of
Gentleman.
Estate Acquisition Act, below, it is not produced here before your lordship from that is why I am
Section 55A.
5A.
Section 5 of the Estate Acquisition
Estate
Act. Lord.
And this is appellate authority before the district judge, being the special judge under the law.
Very well.
I am placing that, Lord, then that's of the matter.
Right.
The lordship kindly have a look to them. Page 30. Starts of page
33. Yes.
These top below your lordship. These 57 appeals under section 5A6 of the West Bengal Acquisition Act so and so were preferred by the appellants against the order of the revenue officer of Agra settlement on 30th December 1959, whereby he held that transfer of all the lands made by one Khetra Mohar Khatua in favor of 4 sons not bona fide and therefore cancel the same. The facts which are relevant for the purpose of these appeals, which were heard analogously on the prayer of the parties and for their convenience, may shortly be stated thus. Khetra Mohar Khatua, which we said
So
to
who are the appellant? You are the appellant.
But your
Khetra Mohar was the appellant.
Yes. As
He was wrongly referred to in the cause title of this.
only cause that there are 57 appellants there, including Khetra Mohar Khatua is the.
Or sons also preferred appeal.
No.
Khetra Mohar
At
himself.
that time, he was not alive. 1963.
No, the transfers had been effected in favor of the sons.
Yes, Khetra Mohar
wife.
transferred his
And
property in favor of his sons and
Yeah,
wife.
so Khetra Mohar, yes.
But I shall not place it all the things to consult the matter. You will also kindly come to the relevant page.
Page 36. Page 36.
Your lordship kindly have a look to page 35.
36.
A State Acquisition Act.
36, your lordship kindly.
State Acquisition.
Well, all regions are shown. Now,
30.
36, your lordship kindly have a look to. Thirdly, a deed of bottom, your lordship kindly. 2 regions have been shown earlier. Thirdly, a deed of settlement has not been mentioned as on the modes or transfer impugned under section 5A of the Act. A deed of settlement is not a deed of gift. It has some special meaning as defined in the Stamp Act. In the present case, the necessary elements of the deed of settlement are present because the transfer was made to the quarreling son and wife by old father before to settle this dispute among the son. In that view of the matter, the transfer of deed of settlement cannot come within the mischief of section 5A of the Act.
These were registered deeds.
Registered deed. There is sufficient evidence, for example, that the record of BC case number 2000 of 1955, which goes to show that transferee were in possession of the land from before and their names recorded in the settlement. as being the possession and show the transfer was bona fide. So, my lord, appeal was allowed. Preferred by the my lord, Khetrammohan and his other purchasers, subsequent purchasers were allowed. Now, your lordship kindly have a look to next page, page 38.
What were the other grounds? It started from the third ground. What was the second ground?
So, two grounds are there, my lord. Those are in favor of Khetrammohan.
Acha.
My lord, page 35, your lordship. Secondly, transfer was in respect of Rayati land, section 5A.
Did not originally apply to Rayati lands.
Consideration starts from my lord, page 34 bottom.
It was held as-
On four grounds, my lord, that was allowed.
This went against you.
My lord, no,
This-
it went
In your
in
favor.
my favor. So, my lord, thereafter the government preferred appeal, revisional application with the Honorable High Court. At page 38, your lordship.
One. No, it was held that it should apply from the date of the notification.
Notification.
10th of April 1956.
My lord.
Initially not applicable to Rayat, but
My
subsequently.
lord, grateful to your
Very
lordship.
good. 38, yes.
Now, page 38, your lordship, kindly page 38 P2. Lord, the 57 revisional application was filed with the Honorable High Court and obtained a rule at that time. And thereafter, my lord, some of the predecessors of the writ petitioner died, but they were not.
Abated.
Yes, it is abated. When, my lord, your lordship, kindly have a look to the order passed on 20th,
So therefore it abated.
20th.
So therefore if that
253.
rule abated, then this order of the
Appellate authority.
appellate authority would
Yes.
attain finality.
Attain finality.
And the date of this was appellate authority 20th February 1963.
But thereafter, my lord, applications were made by the petitioners before your lordship, petitioner in interest of the petitioner before your lordship, and that are not allowed, and no correction was made in their name. So, my lord, they moved the Honorable High Court. Next page, page 40, your lordship, kindly have a look to. 11th day of October 1982. 82, my lord, the application
Yes.
was filed with the Honorable High Court for a direction, and now your lordship kindly come to page 42.
Yes.
Bottom.
Direction
These
given to correct.
applications are disposed of by directing settlement officer concerned to correct the record of right to the to persons of the in persons of the judgment and degree passed by the courts below in the name of the petitioners as early as possible within 2 months from date. This was the direction of the Honorable High Court.
Yes.
By this, my lord, I just was sitting right over the matter, my lord, again and again, my lord, applications are made before the Honorable High Court. Writ petition, and second writ petition, 21st April 1992, page 33. 43, sorry, my lord. 43. There also a direction was there to consider the representation in terms of the order passed by the appellate authority. By this way, my lord, last order, my lord, at page, answer P5, page 47, there you will also find, my lord, interim order of maintaining status for till the disposal of the representation that is there. Lordship there was page 47. Now, my lord, after thereafter nothing has been done, my lord. So, my lord, again, London Tribunal was moved on 10th September 2003. Herein also, my lord, status quo order was my lord, directed to be maintained, and my lord, direction was given to the BLLR to correct the record of right. Again, my lord, 12 December 2012, there is an order. Now, penultimate paragraph is the second paragraph. The BLLR.
Which page?
My lord.
Which page?
Page is, my lord, 49. This was the last application moved with the Honorable Tribunal, and Honorable Tribunal held that has to be done by 3 months from the date of communication of this order after giving opportunity of being heard, petitioner and other interested parties and pass a reasoned order in accordance with law, if not already disposed of, failing which necessary action will be taken against the defaulting BLLRO. This was the Milord. Milord, herein your lordship will find miscase number 22 of 2003. As per the order of the Lagna Tribunal, miscase number 22 of 2003 was started, but that was not concluded. That is why next application was made for direction to conclude the proceeding.
Miscase 22 was started. Why again?
By the BLLRO regarding correction of the record of right.
Acha. All right.
In well, paragraph, second paragraph, instant original application has been filed seeking direction upon BLLRO to conclude the miscase number 22 of 2003, which was initiated in compliance of the order dated 10th September 2003, passed in OA number 469 of 2003. So initiated 22 of 2003. Your lordship will find from the record that again another proceeding. Well, now your lordship kindly come to the order passed by the BLLRO. Page 50. Although relevant portion of page 51, order number 9 dated 6/2/2014. Page 51, your lordship will find.
54.
Page 51.
Order
Order number 9 dated 6 February 2014. 6 February 2014.
This is by the LRTT.
No, this is the order passed by the regime order passed by the BLLRO.
This was challenged in LRTT. Page 51.
Yes.
Yes.
This was challenged with the largest tribunal.
All right.
Your lordship kindly have a look. What is the finding?
Was
A
initiated.
BR case number A391 was initiated against the Bigra, namely Khetro Mohan Khatua, the ancestor of the applicants of this case, where it is found that after having informed him twice, he has not submitted any B form. This case was disposed of on 28th of 1962 and vested an area of 53.38 acres were vested to the state, and land measuring 26.59 acres were given to the state Khetro Mohan. Date of vesting is then 6/2/2014. According to the BLLRO, that was vested by order dated 28 August 1962, but deed was executed in the year 1954. So that time that has already been distributed, settled with the sons and wife. This is very important. Secondly, your lordship will find this is started as miscase number 2 of 2013. 2 of 2013, but the honorable type accepted them to 22 of 2003. Again, new case has been started, miscase has been started. Now I shall go to the penultimate observation.
2 of 2013 started because the records of the 2003 case was missing.
My lord.
The records of the miscase number 22 of 2003 were missing.
Missing, right.
That's why new case was started under
Yes, that is
number 2 of 2013. Very well.
Number 2 of 2013. Now,
Yes.
page 52, your lordship kindly come. Page 52, ordering portion.
Yes.
First paragraph, that though learned tribunal directed to conclude the said miscase number 22 of 2003, said miscase remains untraceable and keeping the spirit of the said case intact as procured from the relevant documents. A new miscase is here drawn with the order of the learned tribunal that the honorable special judge, district judge, hold transfer bona fide, though no direction for record correction is there. That is why he has not corrected the record as in the year 1963, while the statutory appellate authority, that is district judge, allowed the appeals filed by the petitioner here, but there is no direction upon BLLRO to correct the record. That is why he will not.
This was the order passed in 1963, the original order.
Original order.
Since there was no direction in that order to.
There was no direction to correct the record order. That is why I did not. That being the position since 1982, that is going on. That BLLRO
What
is
does
sitting
it
tight
say?
over the matter.
It says something else.
Yes,
also.
yes, I am coming.
Yes.
Special judge district, third, that the transfer was made by virtue of registered deed 28 June 1954, which is compulsively lies within the mischief period as laid down in WBA Act 1953. Next, that the present case is basically originated from the judgment of the Honorable High Court dated.
So you say by virtue of this, the 20th of February 63 order is reopened.
My lord, virtually yes, my submission is this, my lord, and more particularly, my lord, that has been upheld by the learned tribunal, along with some other observation that has been
Because
upheld.
if that was not covered by section 5A, then automatically your name should be recorded. That is your case.
My lord,
If
no,
those transactions were not covered by the restriction of 5A, then your name should be recorded. It should be recorded in your name because of the deeds.
this is my submission before your lordship, and if it is at all within the mischief period, then that order was challenged with the Honorable High Court, and that has been
That was never challenged.
that was not challenged. Thereafter, no challenge.
One challenge was preferred, that abated.
That is abated.
Yes.
So,
So there
thereafter, no application or no
Right, right.
proceeding was initiated by the government. So now your lordship kindly have a look to the order impugned before your lordship at page 35 copies there.
this order was challenged before the tribunal.
Yes.
This order.
This order, page no, 35 copies there. Your lordship kindly have a look to 35 copies.
Page 51 was challenged before tribunal.
Right. Thank you. Certified copy, yes.
But laying the judgment, I shall place before your lordship the relevant portion of the judgment, and
What is the date of that? Entire order sheet is there.
Order sheet, page 21, order sheet, page 21.
Which order date should we look at?
Order dated 12th of February 2025. Well, top of the judgment. Top of the judgment.
Yes.
Now your lordship kindly come to order inner page 21. Laying the judgment, there now taking an overall view of our whole discussion. Page 20, inner page 21, your lordship.
Over 21 years.
Yes. Taking all overall view of our whole discussion, we do conclude that SRO2 and BLLR has disposed of the applicant's representation for correction of record of right by passing an order dated 6/2014 in which case number 2 of 2013. And such order request to the provision laid down in section 44(3) of West Bengal State Acquisition Act 53. And the instant original application being so and so under section 10(1) of WBA is not maintainable as a remedy is available under section 44(3) of WBA Act 1953 against the order number 9 dated 6/2014 passed in which case number 2 of 13. That is the observation of the learned tribunal. My submission would be whether after the proceeding attained its finality.
No, tribunal rejected only on the ground of non-maintainability because there's an appeal provided.
Yes, only on that point.
So you should have preferred an appeal instead of coming before us.
Proceeding initiated under 5A has been concluded when the appeal was allowed and the revision applications also had been abated.
Ms. Maiti, there are two aspects of the matter. One is that section 5A, that objection was taken. It was the transfer deeds were held to be not bona fide. That was challenged. That's a different proceeding. Under section 5A, you preferred a challenge, and whatever happened there, that attained finality. The second proceeding was on the basis of that, you asked for a correction of the records of rights. The present proceeding. Now, section 44(3) says any person aggrieved by an order passed in revision under subsection 2A may appeal.
Not 2A. No, tribunal said that the order passed, the regime order passed by the BLR to be treated as 44(2A and 44.
Let us see 44(2A once. Yes. But revision of entry in record of right is under 44(2A, and you asked for that only.
Yes. Now today, whether the person
should have preferred an appeal.
Passed the order, he has got any jurisdiction or not under State Acquisition Act.
But appeal lay before. You are right on merits. You are right that BLRO did not have that power to reopen that order. Even if you proceed on that premise, your remedy lay under section 44(3). Because at the end of the day, you had asked for a rectification of the records of right, which is under 44(2A.
No, I am not asking that.
So you are seeking for what?
I am seeking for correction of the record of a person to the judgment degree passed in the appeal.
Correction of record of right under which provision?
under the provisions of now today it is WBL Act, not under Estate Regulation Act. As you know, God knows, for 50 years is the limitation. Within 50 years from the date the Act came into force, that has gone in the meantime.
Let us see that provision. Land Reforms Act, which provision?
না তারপর পারবে না সেইটা 50 বছর আর পাবে না
কালকেও দেখলাম তো আমি
কোথায় আছে বলতো
50B or 51? Let us see.
Your Lordship, kindly have a look to the provisions of section 44(3). Any person aggrieved by an order passed in revision under section 2A may appeal in the prescribed manner to a tribunal appointed for the purpose of this section, and within such period and on payment of such court fee as may be prescribed. But that order was passed by the Honorable High Court, abated the revision application in the year 1963. Today we are in 2005, whether that can be reopened or not, this is my
No,
submission.
that question, whether that can be gone into by the tribunal for the first time. If an appeal is maintainable, you should have preferred an appeal.
Today, can I
Under section 54, why shouldn't let us just check up. Because you have now sought for a correction, revision of the record of right.
I have
Correction of entry in the record of right, actually.
in the year 1970, first I applied for, that is why.
That is under the Land Reforms Act.
Then I am coming, my lord. Your Lordship, kindly have a look to the order passed by the Honorable High Court first. 1982 again, I shall place before your Lordship.
Let's see.
High Court order that,
In any event, an appeal would lie against refusal to record.
It has also have been given. Well, page 42, your Lordship, kindly have a look.
42.
You have seen order.
এই
Your Lordship, kindly come to page 42.
42, yes.
That is page 42.
Yes.
Your Lordship will find these applications are disposed of by directing the settlement officer concerned to correct the record of right to in persons of the judgment and degree passed by the courts below. The petition as early as possible, preferably within 2 months from date today. Well, this order also it would be effective. Honorable High Court directed them correct the record of, unless this order is set aside by higher forum. How can I shall go there?
So you say there's no scope for applying under section 44. You applied under this direction.
Yes,
You say it should have been directly rectified under this direction.
my lord. Appellate authority passed the order.
So it's not a 44(2)A scenario.
No. This is my humble submission before your Lordship.
Very good.
Still remains in force.
All right. Let us hear Mr. Gali. Yes, Ms. Maiti, take your
Well,
seat.
two aspects of the matter. One is, my lord, section 5A, the pronouncement of
Would your Lordship kindly permit me to judgment division of the Honorable High Court?
Yes.
Lordship, similar and almost similar and identical.
Give the citation to Mr. Gali also. Give the reference.
2005 1 CLA 2005 1 CLA
78.
Lord, so far as the 5A proceeding is concerned, my lord,
No, this is on what point? She has not finished. Complete, you have just handed over the judgment.
Oh, your Lordship.
What is the proposition?
There, transferring some land was there. That's 5A.
Which paragraph and what proposition?
একই বলে হবে your Lordship, page 20, paragraph 23, your Lordship. 22, my lord, itself is, well, when this order was challenged before the London Tribunal, the proceeding was disposed of, directing the petitioners to prefer appeal under section 44(3). Each order, when was challenged before the division bench of this court in WPLT number 343, have your Lordship got it, my lord? Paragraph 22. by the order of the dated 21st June 2000, the matter was remanded back to tribunal for consideration. Accordingly, and dismissed the same, upholding the order of the revenue officer in case number 7 of 1994. This order of the London Tribunal is under challenge. Fact 23. Considering the aforesaid, we find that initiation of case number 7 of 94 itself was wrongful, as it was a purported compliance of a direction of the landed single judge in CO number so and so. So, no such direction was given by the said judgment. Moreover, while considering the order passed in case number 7 of 94, it does not appear that Brookline and Landsman's officer exercise power under the statutory provision. Admittedly, inquiry under section 44(2)(a) and the decision thereof dated 13 June 1966 has been held to be reached its finality.
That is a different context. There it has reached a finality and all.
Principle is according to my submission would be almost similar and identical. There was a direction to file appeal under section 44(3) below or E Act. Next paragraph below. Therefore, in such factual background, there was no power vested to block land and land in reopening the issues already settled. Order of the London Tribunal include having not considered the aforesaid aspect, the liability set aside.
Here, rather, it was under section 5A, it was the transfers held to be not bona fide and cancelled. And there was an adjudication which attained finality under 44(2)(a). For that, after that, there was a direction by this court. It was held by the court.
The principle is there.
It's a different principle. Here, 44(2)(a) had been.
Whether PLR has got any authority to decide.
You are raising a different question, Ms. Maiti. Here, 44(2)(a), admittedly inquiry under 44(2)(a) and the decision there was a decision and inquiry under 44(2)(a), which was completed. And that was challenged in a review proceeding.
Yes. Again, the tribunal directed to apply under 44(3).
There, 44(2)(a) was held, inquiry was held, order was passed, it was sought to be recalled by a review proceeding. And there it was held by the court that the PLLRO cannot reopen issues because it does not have the power to review.
Only difference is this was appellate authority.
This is on a different proposition.
Again, High Court in a petition directed them, all are in force now.
Yes, Mr. Galib, your answers.
My lord,
5A first.
Section 5A, my lord, was
finality
in the year 1963. Now, my lord, so far as correction or record of right is concerned, lordship knows 57B2 because the civil court cannot direct for correction.
Let us see
57B2. But 57B2's earlier avatar was section 46 because this judgment and decree passed under 5A2 was in the year 1963. So 57B2 of estate acquisition came into force.
Civil court cannot direct.
So that is, so now what the
court is not a civil court.
Learned civil judge
26 court is not a civil court.
No, here learned civil judge
it was pursuant to the direction of the High
comes to
Court.
the finding that these were not within the mischief period. Now comes the second chapter, correction of record of rights. Now, correction of record of rights, my lord, so far as the
High
RS
Court direction was that correct the record.
Thereafter, kindly see not only one order, kindly see, my lord, kindly see, my lord.
Yes.
Page 40, my learned senior friend has shown your lordship.
Let us get you color. Wait. Yes.
Page 40, my learned senior friend has shown your lordships.
42.
42 is the operative part. Now kindly comes, my lord, thereafter, my lord, kindly sees there is another order, my lord, of 21st April 90, at page 43 by the self and successors of Khatua. What does the Honorable Court says, my lord? Kindly say, my lord, at page 46. I dispose of this application by directing the said BLLRO to consider and dispose of the petitioner's application dated 14th October 1990
reasoned order.
By reasoned order. Now kindly comes to next page, another order in the year 1996, my lord, page 47. What does the Honorable Court say, my lord? Justice B. M. Mitra, my lord, kindly says dispose of the said representation in accordance with law. By a reasoned order, after giving the opportunities of hearing to the parties concerned within 7 days from date of communication during the pendency of consideration said, so and the status quo to be maintained. Again in accordance with law. Next comes, my lord, page 48, the first OA. Before the, my lord, LRTT, my lord. What does the OA say, my lord? Kindly see third paragraph, sorry, my lord. It has not been stated by the BLRO as to whether action has been taken in accordance with the direction given by the Honorable Justice B. M. Mitra in CO number 459, that is at page 47. Now comes the next, second OA. Milord, at page 49. Milord kindly says, Milord, what does it say? Third paragraph. Instant original application has been filed seeking direction of a BLA EGRA to so to conclude the miss case number 22, which was initiated in compliance with the order dated 10 September OA 469. 469 comes at page 48. Now comes the operation of this BLRO. What does the gentleman say at page 50, Lordship? He starts his proceedings. He starts 2/2013. Why? Because he gives the reason in order number 2 that I lost this and that, so I have started 22. There was no objection from the part of the parties. So he goes on and concludes the hearing at page 51, order number 9, 6 February. This is the subject matter of Milord. Challenge in OA, kindly sees the way. Challenge in OA, Milord, page 58.
No, but what is this order of the VLR? It cannot stand a moment's scrutiny.
So, Milord,
hence, considering every aspect, this case is disposed of without record correction.
Milord, my respectful submission on pure question of law, that if the correction of RS ROR is contemplated under section 44(2)(a), now, Milord, if 44(2)(a), I'm not happy with 44(2)(a), Milord, 44(3) has to be taken recourse to. Even the Honorable Supreme Court, Milord, has also had occasion, Milord, to deal with this issue, Milord. May I, Milord, respectfully hand over this judgment, Milord. Milord, so far as the correction of RS ROR is concerned, 44(2)(a) is the only provision of State Acquisition Act. Now, if I'm not happy with 44(2)(a), Milord, I have to take a recourse to 44(3). This is what the tribunal has said, Lordship. Kindly says, Milord, a very short question before the Honorable Supreme Court was there, Lordship. Lordship, the second paragraph. The only question that arises for our consideration is with regard to the interpretation of section 10(3) of the West Bengal Land Use Tenancy Tribunal. Now, quoted 10(3), the admitted position is that land reform so-and-so had entertained the application in the writ petition filed by High Court, out of which impugn order as it was held by the High Court that the appeal was not maintainable. It has been contained for the provision section 10(3) has not been correctly interpreted by the High Court and the subclause so-and-so. In our opinion, it is not necessary for us to go into the matter. The interest of justice would be served. The appellants are delegated to the remedy of availing an appeal under section 44(3) of the West Bengal Assistant. Accordingly, we permit the appellant to file an appeal before the appellate authority in the period of 1 month, so-and-so. So, Milord, in the perspective, if there is an operation, if there is exercise, if there is an exercise under section 44(2)(a), 44(3) has to be taken recourse to. Milord, Lordship knows, Milord, that, Milord, yes, 226 is not barred, but exceptions are 4, Lordship knows, Milord. Violation of natural justice, ultra vires under challenge, violation of part 3 of the Constitution, and when the authority passes an order is without jurisdiction. So it does not come within any of the four exceptions contemplated starting from 1990 Whirlpool till 2024.
We exercise our powers under 226 and look directly into the, since it has merged, directly look into the order of the DLLR.
Lordship,
we are directly, because everything has merged in the order of the tribunal. You are in season over a challenge against the order of the tribunal. BLLR order has merged in the order of the tribunal. Whichever way, we'll say that we are looking directly into the legality of the order of the BLLR and set it aside. 5A is there. How can there's a direction of the High Court? Correct the records of rights.
No, but
there was never a challenge to the order of the High Court, the first order of the High Court, correcting the record of rights.
Subsequent orders have merged.
Subsequent orders, the reasoned orders have to be within the periphery of that first direction. You cannot go beyond that. There cannot be a re-adjudication under section 44.
No, not re-adjudication. Lordship,
44 draft and publication is...
Kindly sees the 5A scope. 5A scope is only with regard to transactions if done within which period.
In terms of that, Leonard Singlejab, this court had directed the authorities to carry out the correction.
In terms of the very first order, but subsequent orders,
subsequent orders, a reasoned order. You have to pass a reasoned order.
And thereafter, in accordance with law, Lordship kindly sees another order I have shown you, Lordships.
That is the law.
In
226 order is law.
No, law means, Milord, that
under 226 we have the power to pass directions.
In my humble understanding, Milord, in accordance with law means, Milord, the law which has been contemplated for correction of finally published record of rights of RS, in my humble understanding, Lordship. So it should be, Milord, section 44(2)(a).
This should be a case of revision of record of rights, not a final publication.
Revision.
So let us come to the revision provision. Where is that? Because it was already recorded in someone's name. Section 44 is modification.
has been, may I, my lord,
Must be after the intervention.
has been invited your lordship to section 44 of the EA Act, lordship.
44 of the EA Act you are saying is no-
Yes, 44 2A also says revise. Kindly see the language, lordship.
44
2A, my lord. An officer specially empowered by state also revise and entry in the finally published record of rights. So revision power, my lord, is contemplated in section 44 2A. Yes, so for LR record of
provided it is an order under section 2 A.
no, since my lord, the BLLRO, my lord, has
Oh, so revise and entry. Yes.
this point has also been clarified, taken care of by the learned tribunal, that since the BLLR has not stated in so many words that my proceeding is under section 44 2A, he has not stated anywhere. No, that does not ipso facto mean that it is not a proceeding under section 44, supported by Supreme Court judgment. Lordship knows that, lordship. May I
So what
place
is
that?
the reason furnished by the BLLR in refusing correction? Give us one reason. How can you support the BLLR order apart from the appeal challenge, appeal bar?
My lord, then my lord, lordship kindly may relegate.
What inquiry was required further after the 5A adjudication?
No, there may be, my lord, some other properties or, my lord, what not only correction of record of rights, not relates to only those, my lord, decretal properties. Maybe some other, my lord. We know that we don't know the issues, my lord, what were there, lordship. Kindly relegate the matter, my lord, so that time frame and lordship kindly.
Relegate to whom?
This
BLLR.
lordship kindly frame the issues so that he could let him do the exercise, so that, my lord, that the one forum will not be lost. Please.
See what is later.
This 44-3 till today can be formed before the honorable district, before the learned district judge. Till date it can be formed. 44-3. May I place, my lord, some judgments? Lordship, it is a very settled proposition at a cost of castigation, if I may.
What is that?
Proposition statutory remedy not to be bypassed.
Statutory
remedy not to be bypassed.
Cite at least one of the landmark judgments.
My lord, 10-4, my lord. SCC, my lord. Page 772, my lord. My lord, paragraphs 29 to 31. I'm just quoting the paragraphs, lordship.
Wait. Paragraph?
Proposition is statutory remedy not to be bypassed by invoking Article 226. Paragraphs, my lord, 29 to 31. My lord, 33, 34 and 36.
Okay, judgment set করবো তোমার judgment একটু পড়ো না ভাই এখন পড়াশোনা করছি
Period.
My lord, the last, my lord, is wrong quote or not quoting the provision. Wrong quoting or not quoting the.
That is not quoting provision is not a problem here.
Not sure. So since the BLR has not quoted any section that I am.
No. We'll consider under which provision the BLR was exercising his powers.
Lordship.
Non-quoting in the order is not.
And in the year 2012, the world full revisited. May I place this, lordship? 2012.
Yes.
This last one, lordship.
But how can you look at that? Because we are speaking about an order passed much before these judgments. And that judgment stood final. The first judgment.
The first judgment of the Honorable High Court. Where the Honorable High Court directed you act in terms of the.
Oh, you are saying, speaking about our the jurisdiction, we are exercising now. Oh, no, absolutely. Please. Definitely, you have a right to.
No, my lord, this is world full revisited.
Yes.
1211 SCC 651. 12, 11 SCC, 651,
You know,
paras
yes.
4 and 11. And Miller, the other one at the very outset, I cited Miller, the unreported one, where one was.
No, Whirlpool has not been deviated from.
So Miller, we are no.
Whirlpool has not been deviated from.
No, Whirlpool revisited. That is what I said.
Self-imposed restriction.
Sorry,
yes.
sorry. It was following. Yes, following suit and para.
Visited has a connotation that.
Sorry, Lordship. He visited.
Might have been.
It's followed, sure. It should be
It
followed.
has been reiterated. Rather.
Yes, reiterated. So, Milord, according to my understanding, it does not come within any of the exceptions. So, Lordship, the alternative remedy and the unreported judgment, Milord, we have at the very outset, I have, Milord, cited with the Lordship.
Ms. Maiti, only one question to you. 5A will make it clear that 5A stood final. No doubt on that. But regarding the first direction of the High Court, it was the settlement officers were directed to correct the records of rights in pursuance of the judgment and decree passed by the courts below. Past judgments and decrees passed by the courts below were not on correction of record of right, but 5A. 5A consideration. Now, High Court for the first time, High Court for the first time says that let that correction be recorded in the record of right. Subsequent orders of this court modify that in a sense, elaborate that and say that should be, yes, correct, but in accordance with law.
For implementation of the order passed by the learned court below.
Yes, but something else is added there. Both the orders after that, it is added that should be representation. Your representation should be considered in accordance with law and upon giving opportunity of hearing and placing relevant documents.
Yes, that is true.
Now, then in view of the subsequent orders, this first direction was read in context and the subsequent benches directed, these also have attained finality. These have interpreted the first direction to say that yes, they will correct, but if they say that, then 44(2) comes into play. Because the appropriate opportunity ought to have been given to the parties. In this case, BLLR, did the BLLR before passing that order give an appropriate opportunity? Page 51, where they heard was
yes,
everybody.
Yes,
opportunity was given of
representation. Yes, they represented.
Pradeep Shankar and such certain Messrs. Khatua were given. They also appeared.
Yes.
Achha, they are parties here also. The Khatuas. They have been served properly.
They are Khatuas.
Oh, achha, you are the Khatuas.
They want the benefit.
No, it was already recorded in the name of whom? The father. Then there is nobody to object. Who should be given a notice to? We have heard you. You are the state. You can only object. Where is the question of further giving opportunity of hearing? Why compel parties to litigate on and on? Nobody else was to be served. Their father's name, father deceased, father sold property to them.
I don't know, Miller, but only father had gifted the property to
the BLLR also did not serve anybody else.
No, I find Miller. 4 sons and 1 wife. I don't know whether the original Khatua had more than 4 sons or not.
Achha.
57 appeals were there. They are subsequent purchasers. They were not so notified.
Yes.
Other heirs are there.
No heirs, but they are subsequent purchasers. 57 appeals were there.
So let them
along with others also preferred an appeal. Those appeals in number 57.
57 EA appeals was there under section 5A3.
In the
5A3
proceeding.
Now
after 5A3.
That is under in respect of different causes of action.
For the transferees.
For
subsequent transferees.
We have 12 in number now.
So all you are not concerned with the other 56.
No, but Khetro Mohan had gifted only to his 4 sons and wife. Whether Khetro Mohan had any other sons or not, they also should be put on notice. Khetro Mohan had only 4 sons.
Only 4 sons and their predecessors are there, successors are there. I don't know.
So now those original Tonis might have died, so their successors should be put on notice.
12 petitioners, all of them are Khatua.
All of them may be Khatua, but whether they are the Khatuas we are speaking of. Were there any other heirs? Have you stated anything in this petition?
No, Milord, they are restricted to only those success of those 4 sons only. They are concerned.
Shall submit one provision of law, Milord, as Estate Acquisition Act. My
In
lord,
the
whether,
correction of
whether,
record of rights,
Present,
entire,
my lord, whether in the 2025, that BLO has got any power.
The BLR already gave a notice to whoever was to be given.
The-
Sir, Gali, BLR had given a notice and passed this order.
And
So
that
where is the question of further reopening this issue? This was done under, because now we'll have to be relegating, tribunal did not interfere because it said that 44(3) is there.
simple.
But 44(3), this is a palpable error by the BLR. There was no scope of any further anything else to do but to record the name in terms of the deeds of settlement. Because there is no challenge to the deeds of settlement.
So kindly appreciate one thing.
Secondly, we have to appreciate that also, because if the deed of settlement was challenged in some court of law, civil court, we could have understood. There are registered deeds of settlement. 5A proceeding was drawn up, 5A was ultimately turned down, and High Court says since 5A has been turned down, deeds of settlements, this property stands in their name only, let their names be recorded.
Now, my lord,
If anybody has a civil suit, that's a civil dispute, they could have challenged the deeds of settlement. It's a natural, logical corollary of the deed of settlement that it has to be corrected in their names. Why should we reopen the issue again?
when the
Why should the other heirs be served? What will their case be? Deeds of settlements are admitted by the state. Registered deeds of settlement are there. That was the premise of 5A proceeding.
lordship.
That was cancelled by 5A, under 5A.
So, my lord, 5A was restricted only to those 4 instruments. Now, my lord, when
Those 4 instruments cover certain properties. They are seeking correction of their names only in respect of the properties covered by the 4 instruments.
that is, my lord, the question whether the Khatua, original Khatua had only
If
that-
he had other heirs also, registered deeds of settlement, by virtue of those registered deeds of settlement, they are the owners. By default, they are entitled to have their names corrected.
But my lord, when a correction of record of right exercise is undertaken,
Yes.
my lord, in that particular plot or those plots, whose interest appear to be, my lord, they are relevant, my lord.
That exercise was completed by the BLR. We don't find any notice to any other party or any contest by any other party.
He has simply dealt
Sir,
with
this
that.
is my last.
That stage was over. That stage was over. 44(2)A notice hearing stage was over, and then the BLR says, surprisingly, that considering every aspect, case is disposed of without record correction, without giving any reason. Because no order for record correction has been made herein. What order should be made? He will make the record correction. This case was initiated under
No,
44A.
because he is making one observation. Kindly sees, my lord, at page 52, last
Yes.
of Roman 2, my lord.
Yes.
He says that no case is found to have been ever initiated by this office under section 14T5 read with 14T829.
That is why
No.
it was they had to approach the BLLRO, and the High Court directed the BLLRO to do that, to make the correction. That is the specific reason, because
Did
the district judge have power to direct record correction under 5A?
Certainly not.
Then
Certainly not.
this-
He will have to do it.
This finding is perverse.
He will have to do it.
He
But
will
my
have to do it. He has been approached. He has given notice. At the conclusion of the hearing, he records everything and then says, no direction for correction was given, therefore I will not correct. He is the authority to correct, even if it's a section 44(2)A proceeding. He is the authority. He is to correct. Peculiar approach. This is what happens when you give these powers to these people. A person who is not so trained in law. Not their fault. Not their fault. He may be highly educated also. We don't know, for all that we know. But these people are laymen in law. And they're adjudicating. What is this? Can't read the section properly. He has the power. That's why the miscase was initiated, Mr. Gali.
Lordship,
And
he
it
has,
says no order for record correction has been made in the writ petitions or in the district judge's order. Therefore, I won't correct.
or in the CO or in the way, that's why I don't.
And the district judge in two.
I fully, my lord,
So
lordship,
therefore, we'll look into this. I mean, we won't relegate the parties. These are unnecessarily, they are litigating for so long.
no, my lord, but other, my lord,
We'll
so-
consider your
no, but
worldful
the
judgment.
division of record of rights, my lord. Other may be interested, my lord.
That
apart
exercise
from-
was completed. This was the final disposal by the BLLO, Mr. Gali.
This,
If we reopen this proceeding, then we could have directed that. Proceeding has been concluded by the BLLO upon giving notice, complying with whatever. There is no allegation by anybody, it was not complied. At the conclusion, he says this. Why should he reopen that exercise again?
lordship.
He had no other option but to correct, Mr. Gali. After this, no objection was taken. There is nothing reflected in the order
If my
sheet.
humble as a correction has to be done in respect of the decree holder, no way out for him. But if, my lord, there are other, my lord, interested parties
consider that.
of, my lord, this
We are setting this.
Kshetra Mohan Khatua,
Yes.
they should also be, my lord, taken care of, lordship. This is my main understanding, lordship.
Let the Khatuas live in peace.
Lordship. Lordship.
Enough trouble you have given to them.
Lordship.
Take your seats, both. There is something some gross mistake we are committing, then jump up. Otherwise, if minor mistake, just stand up.
Lordship.
And if don't make a mistake, then এই করে দিচ্ছি সেটা করে দিচ্ছি ফালতু এদের আবার ওখানে অ্যাপিলে পাঠাবো না। The matter has a checkered history. Relating back to the year 1954. Push up on May 28, 1954, comma, the father stroke predecessor in interest of the original applicants, comma, Gaur, comma, Nityanando, comma, Bonkim and Kanai, and the wife of the settler Kshetra Mohan, namely Kaushalya, by transferring the disputed property in the latter's favor. Full stop. The present writ petitioners are the said transferees and stroke or their legal heirs. Full stop. Next para. Pursuant to the said transfers were sought to be challenged in a proceeding under section 5 capital A of the West Bengal Estates Acquisition Act 1953, and the deeds were cancelled in such proceeding. Full stop. A challenge was preferred thereto, which succeeded. Full stop. The appeals preferred by the transferees were allowed, comma, thereby holding that the transferees were in possession of the lands from before their names were recorded in the settlement as being in possession, and so the transfer was bona fide. Full stop. That apart, comma, it was also observed by the appellate authority that a notification dated April 10, 1956 came into force subsequent to the deeds of settlement. Full stop. Previously, the rigors of section 5 capital A were not applicable to riots, but only by virtue of the said notification was the notion notion of section 5A extended to riots. So as such, comma, the appellate authority held that the notification was not applicable to the transferees, comma, who were riots. Full stop. Next para. The matter came up in challenge preferred by the state before this court in a writ petition. Full stop. The writ petition, comma, however, comma, abated in view of no steps for substitution having been taken on the demise of opposite party number 2 therein. Writ petition na kore civil divisional application. Civil division. Full stop. Next para. Thus, comma, the setting aside of the order passed under section 5 capital A attained finality. Full stop. Next para. Subsequently, a writ petition was moved by the transferees, comma, giving rise to civil order number 9495 within bracket W of 1982, which was disposed of by an order dated October 11, 1982, comma, directing the settlement officers concerned to correct the records of rights in pursuance of the judgment and decree passed in the proceeding under section 5 capital A as early as possible, comma, preferably within 2 months from that date. Full stop. Next para. Such order not being complied with, comma, another writ petition had to be preferred by the transferees, giving rise to civil order number 3413 within bracket W of 1992, where, comma, which was disposed of by an order dated April 21, 1992, where the learned single judge observed that the representation of the writ petitioner in that regard should be disposed of within a period of 2 months from the date of communication of the order. তারপর ডাবল ইনভার্টের মধ্যে after giving the petitioner an opportunity of hearing and placing relevant documents by passing a reasoned order. Double inverted close, full stop. Next para, in similar tune, comma, another learned single judge, comma, by an order dated June 7, 1996, passed in CO 4597 within bracket W of 1996, reiterated such direction by directing the BL and LRO to dispose of the representation of the transferees by a reasoned order after giving due opportunities of hearing to the parties concerned within 7 weeks from the date of communication. Full stop. The saga SAGA of the travails TRAVAILS of the petition of the transferees did not end there. Full stop. Miscellaneous case bearing miscellaneous case number 22 of 2003 was initiated by the directions of different benches of this court for correction of the records of right. Full stop. The said proceeding however, comma, subsequently the records of the said miscellaneous case went missing, comma, which prompted the Land Reforms and Tenancy Tribunal, comma, by an order dated December 12, 2012, to direct the miscellaneous case to be concluded comma, which, comma, however, comma, could not be complied with in view of the records being missing. Full stop. Accordingly, a fresh miscellaneous case bearing number 2 of 2013 was initiated. Full stop. In the present writ petition, comma, the entire order sheet of the case has been annexed, from which we find that the miscellaneous case was treated as a proceeding under section 44 within bracket 2 small a bracket closed of the West Bengal Estate Acquisition Act 1953, and upon compliance of due formalities and service of notice etc., comma, by an order dated February 6, 2014, comma, the BL and LRO came to the conclusion that the case was disposed of without record correction as applied by the applicants therein. Full stop. By way of reasons, comma, the BLLRO cited non-recording of any such order for record correction in any of the orders passed by this court or by the appellate authority while disposing of the proceeding arising out of the section 5 capital A application. Full stop. Next para. Section 5 capital A cancellation. Next para. Being aggrieved by the same, comma, a challenge was preferred by way of OA 803 of 2014 before the concerned Land Reforms and Tenancy Tribunal. Full stop. By the impugned order dated by the impugned judgment dated February 12, 2025, passed in the said proceeding, comma, the learned tribunal, comma, despite spending 22 pages in narrating the entire perspective of the case and judgments cited by all parties, comma, disposed of the proceeding, dismissed the proceeding as not maintainable in view of availability of an alternative remedy of appeal under section 44 within bracket 3 of the West Bengal Estate Acquisition Act 1953. Full stop. Next para. The present writ petition has been preferred against the same. Full stop. Next para. Learned counsel appearing for the petitioner argues that after the proceeding under section 5 capital A of the 1953 Act culminated in setting aside of the cancellation of the deed of settlement executed by Khetrammohon Khatua, comma, there was no scope of reopening the said issue after a quarter of a century. Full stop. Next para. It is further argued that in terms of the directions of different benches of this court, comma, it was the incumbent duty of the BL and LRO to effect the necessary corrections pursuant to the order of the court. Full stop. It is argued that the proceeding ought not to have been treated as one under section 44 within bracket 2 small a, and as such, comma, should have been by way of a compliance of the directions of this court. Full stop. As such, comma, no appeal lay under section 44 within bracket 3 of the 1953 Act. Full stop. Next para. Learned senior government advocate, while opposing the writ petition, comma, submits that there was no other option before the BLRO to take up an application for correction or rectification of the records of right apart from section 44 within bracket 2 small a of the 1953 Act, comma, since that is the specific provision which confers such power on the BL and LRO. Full stop. Learned senior government advocate draws the attention of this court to the subsequent orders of the learned single judges of this court, where the representation of the petitioners were directed to be considered by passing a reasoned order after giving due opportunities of hearing to the parties, comma, as such, comma, in consonance with section 44 within bracket 2 small a of the 1953 Act. Full stop. Next para. Thus, comma, it is argued that the proceeding was one under section 44 within bracket 2 small a, and an appeal was maintainable under section 44 within bracket 3. Full stop. By placing reliance on the judgment of the Supreme Court in Rajkumar Shivhare, such and such, reported at 2010 4 SCC 772, comma.
First judgment is Kartik.
Pardon?
First judgment is Kartik on the proposition that 44(3) will lie.
Learned senior government advocate argues that the jurisdiction of the High Court under Article 226 is not barred by availability of alternative remedies, semicolon. However, comma, it is equally obvious that the court would take note of the legislative intent manifested in the provisions of the Act and would exercise their jurisdiction consistent with the provisions of the enactment. For sub next para, learned senior government advocate also places reliance on Union of India versus such and such, reported at 2012 11 SCC 651, where it was observed, comma, by placing reliance on the previous judgment passed by the Supreme Court in Whirlpool Corporation versus Registrar of Trademarks, comma, reported at 1998 8 SCC 1, comma, that the High Court has imposed upon itself certain restrictions, one of which is that if an effective and efficacious remedy is available, comma, the High Court would not normally exercise its jurisdiction. For the next para, learned senior government advocate also cites an unreported judgment in the matter of Kartik Chandra Mondal and others versus Badal Kumar Das and others, where the Supreme Court, comma, inter alia, comma, observed that the provision of section 10 within bracket 3 of the Act has not been correctly interpreted by the High Court in the said case, and that subclauses small a and small b of section 10 within bracket 3 should be read disjunctively. Full stop. It was opined by the Supreme Court that the interest of justice would be served if the appellants were relegated to the remedy of availing an appeal under section 44 within bracket 3 of the 1953 Act. Full stop. Next para. It may be noted here that learned counsel for the petitioner has relied on a coordinated bench judgment of this court in the matter of Basudev Mondal and others versus State of West Bengal and others, reported at 2005 4 CHN 184, inter alia, for the proposition that if there has already been an adjudication under section 5 capital A of the 1953 Act, comma, the said issue cannot be reopened under section 44 within bracket 2 small a within bracket close of the said Act. Full stop. Upon a careful consideration of the arguments of the parties, comma, we find that the issue as regards the cancellation of the deed of settlement executed by Khetrammohon Khatua in favor of his 4 sons under Section 5 capital A of the 1953 Act being set aside by the appellate authority has attained finality, comma, with the abatement of the challenge filed against the same by the state. Full stop. Thus, comma, the said issue cannot be reopened at this stage. Full stop. Next para. We also do not find any mention in any of the proceeding as to any challenge being thrown before the competent civil court against the registered deed of settlement in question. Full stop. Thus, comma, by dint of the said deed of settlement, comma, which was not cancelled under Section 5 capital A of the 1953 Act, comma, it is the transferees and their heirs who have attained an indefeasible right in the property in question. Full stop. Thus, comma, there does not arise any question of there being any further interested party to the proceeding for correction of the records of right pursuant to the deed of settlement, comma, in the absence of any challenge before a competent civil court and or any other forum known to this court or apprised to this court. Full stop. Next para. The first direction by the writ court pursuant to the Section 5 capital A setting aside order was passed in WP in Civil Order number 9495 within bracket W of 1982 on October 11, 1992, whereby the learned single judge straightaway directed the settlement officers concerned to correct the records of rights in pursuance of the judgments passed in the Section 5 capital A proceeding, comma, without leaving it open for any further adjudication to be done. Full stop. However, comma, learned counsel for the state has a point in arguing that the scope of the said direction was interpreted by the subsequent orders of 2 learned single judges of this court, comma, respectively in Civil Order number 3413 within bracket W of 1992 and in CO 4597 within bracket W of 1996, whereby the BLLRO was directed to consider the representation of the petitioners to correct the records of right by passing a reasoned order and after giving due opportunity of hearing to the parties concerned. Full stop. Next para. Such direction, comma, even if construed to be in the light of Section 44 within bracket 2 small a of the 1953 Act, comma, was duly complied with by the BL and LRO in miscellaneous case number 2 of 2013 as evident from the order sheet of the said proceeding. Full stop. Only upon due communication and notice being served, comma, the matter was taken up finally. But the BL and LRO, comma, acting entirely divorce jurisdiction, comma, merely observed that since there was no specific direction by the writ court to correct the records of rights or any observation in that regard in the appellate authority's order under Section 5 capital A of the 1953 Act, comma, the BLLRO refused to carry out such correction, comma, thereby giving a go-by to the tenor of the repeated directions of different benches of this court and the fact that the Section 5A cancellation was set aside, comma, which has attained finality. Full stop. Next para. Even if the proceeding was considered to be one under Section 44 within bracket 2 small a of the 1953 Act, comma, nothing was left before the BLLRO, no option was left before the BLLRO, comma, in view of the registered deed of settlement staring at his face, and since the cancellation under Section 5A of the said deed was set aside, which has attained finality, and there is no challenge before a civil court to the said registered deed of settlement from any corner, comma, but to correct the records of rights in the name of the transferees. Full stop. Next para. Having not done so, comma, the BLLRO committed a palpable jurisdiction error. Full stop. Next para. Since the order of the BLLRO has merged with the order of the tribunal, comma, we are in seizing of the order of the BL and LRO as well. Full stop. Undoubtedly, comma, it is right law that Article 226 of the Constitution of India is a power of judicial review flowing from the Constitution, comma, and all statutory rights or bars of jurisdiction under statutes subservient to the Constitution cannot circumscribe or curtail such right of judicial review, which is a part of the basic structure of the Constitution. Full stop. It is also equally true that the High Court imposes self-imposed restriction in the event it so feels necessary if an alternative remedy is available. Full stop. However, comma, such self-imposed restriction should not become an excuse for the High Court to shirk its duty and shut its eyes where there is a palpable error of jurisdiction and the parties are suffering for more than a quarter of a century. Full stop. Relegating the parties to an appeal under section 44 within bracket 3 of the 1953 Act at this stage, comma, when all the rights of in favor of the writ petitioners has been conclusively decided by several forums, comma, it would be a gross injustice if this court relegates the parties to an appeal without exercising its jurisdiction under Article 226 of the Constitution of India. Full stop. As such, comma, in order to correct the error, the ex facie error committed by the BLLRO, comma, we decide to invoke our jurisdiction under Article 226 of the Constitution of India and set aside such order. Full stop. Accordingly, WPLRT 123 of 2025 is allowed on contest, comma, thereby setting aside the order of the judgment and order dated February 12, 2025, passed by the West Bengal Land Reforms and Tenancy Tribunal in OA 803 of 2014 within bracket LRTT, as well as order number 9 dated February 6, 2014, passed by the BL and LRO, comma, EGRA hyphen Roman 2, comma, Purva Mednipur in miscellaneous case number 2 of 2013 and directing the said BL and LRO to immediately correct the modify stroke correct the records of rights by reflecting the name of the transferees in the deed executed on registered deed of settlement executed by late Khetro Mohan Khatua on May 28, 1954, and stroke or the heirs and legal representatives of the said transferees, comma, in the event of demise of any of the transferees in the meantime, comma, being the writ petitioners herein, within a period of 3 weeks from the date of communication of this order to the concerned BLRO. Full stop. All parties, the parties as well as all concerned shall act on the server copy of this order for the purpose of compliance without awaiting unnecessarily a certified copy of the same. No rest to cost. Affidavit of service file to be kept.
Item number 23. My lord, I believe your lordship has a different bench in the second half. My lord,
do we?
Fixed matter from at 2
Fixed matters, yes.
Yes. My lord, I was only beseeching your lordship. My lord, I would be away from tomorrow for a personal reason. So that trademark matter, Mr.
Bhattacharya, whenever that is taken up, ask somebody to ask for time, we will grant it. We don't know whether this bunch of matters will flop. I mean, never know anything.
I am appearing on behalf of the alleged contemner. I am just now told that the special
কাগজ পাওয়া যায় পোকা একটা কাগজ দেন একটা স্পেয়ার এটা তুলে নিন এটা তুলে নিন এটা তুলে নিন ওটা তুলে নিন ঘুরে বেড়াচ্ছে কোথাও আপনার দিকেই যাবে বোধহয় নিন সরি yes alleged contemner
I am just now told that the special leave petition was taken up by the Honorable Supreme Court today. And in course of hearing, my learned senior friend's client, has given not an undertaking, has made a submission that, they are not going, she is not going to press the contempt application anymore. That's what, I am told.
No, that's completely false, because that's an undertaking given by him that he's going to comply with the order, my lord. That is why.
Just now I am told.
Unbelievable.
Now, I have.
If whoever's given you that instruction should be put to jail right now.
Now, I have told my client, just now, I had a conversation. I told him that, it's between me, as alleged contemner and the Honorable Court. Whether they have given an undertaking or not hardly matters, because, it's court's order. I have to comply with the order unless.
Is it correct, Mr. Banerjee? Please ask him that he has said that it has been given out to the court, Supreme Court, that he will comply.
The Supreme Court, on the contrary, said, my lord, we have been directed to file affidavits. Supreme Court has said that he will go on continuing payments. If the Supreme Court then feels that something is needed to be adjusted, it's only after the final hearing.
Mr. Strategy, should it be uploaded by tomorrow? I mean, Supreme Court order.
My lord, both of us were present there. Not both of us. I mean, our counterparts were present there. And this is what has transpired. It's unbelievable that he says something like this.
Second, সুপ্রিম কোর্টে তুই যেটা বললি যে ওনারা গিয়ে দাদার যে কাউন্টারপার্ট তিনি বলেছেন
we'll see a copy of the order and pass necessary direction
করবে না সেটা অন দ্য বেসিস অফ ওয়ার্ড বলেছেন নিশ্চয়ই আমরা বলেছি যে আমরা টাকা দেব
Mr. Chakraborty online? Is Mr. Abhilal Chakraborty on?
Yes.
My lord, I am yes, my lord, I was physically present before the Honorable Supreme Court. My lord, am I audible to?
Don't get too excited. It's okay.
Your video is being disrupted actually. Yes, Mr. Chakraborty, please repeat.
No, my lord, am I audible? My lord,
yes,
I was
continue.
physically present before the Honorable Supreme Court. My lord, they have given us undertaking, my lord, that they will continue to pay. The Honorable Supreme Court also said they has to comply with the order and we have to continue to paying. And only, my lord, if they pay, my lord, then only, my lord, the contempt has to be stayed. We shall not press the contempt subject to their payment.
All right.
Fine. I go by what.
When we make the payments, Mr. Banerjee?
Yes. Now, 17 lakh was in ADR. Since by 15th of this month, I was to pay another installment, which has also fallen due. Today, it's 20 lakh.
Agreed. 21.
2021. That's my instruction is 20. My learned senior friend says
I've given
21.
a chart of the payment.
I have insisted upon payment of 5 lakh beg borrower still by today. Balance 3 installments along with the current dues. If my learned senior friend kindly allows me to pay that in 3 monthly installments.
Sir,
I will issue PDC as was suggested by.
We'll keep it day after tomorrow. You take instructions.
But let him at least bring in something that
the 5 lakh has to be paid by today.
By today that he's going to pay.
Learned counsel for the
And
response.
I have a chart of whatever the payments are required.
We'll record that you are handing over a chart. Learned counsel for the respondent, at the outset, gives an impression to this court that the appellant stroke petitioner in the contempt application has given an undertaking to the Honorable Supreme Court, where the challenge at the behest of the alleged contemner against the parent order is pending, that the petitioner shall not proceed with the contempt application. Of learned senior counsel appearing for the appellant stroke petitioner seriously opposes such contention and submits as per instruction of the learned advocate for the petitioner who was present before the Supreme Court and is present online virtually during the present hearing, that the context of what transpired before the Supreme Court is completely otherwise. It is submitted that in view of the specific submission made on behalf of the alleged contemner before the Supreme Court, that the alleged contemner will go on complying with the order of this court, the Supreme Court made an observation that in the event of such compliance, the petitioner shall stay its hands from the contempt taking up this court shall petitioner this court shall stay its hands from taking up the contempt application. Full stop. Learned senior counsel appearing for the petitioner also hands over a chart regarding the arrears of alimony due in terms of the order of this court from the respondent. Full stop. Next para. Learned counsel for the respondent submits that the respondent shall, to show his bona fides, pay an amount of rupees 5 lakh in part settlement of the dues during the course of today. Full stop. Next para. Learned counsel for the respondent seeks liberty to pay the balance arrear amounts by 3 equal monthly installments and expresses that the alleged contender shall also go on paying the current alimony every month as per the direction of the parent order of this court. Full stop.
My lord, kindly add a single line, my lord, subject to, my lord, the outcome of the special.
Subject
the Supreme Court's order itself.
Subject to the outcome of the challenge pending against the parent order before the Supreme Court. Full stop. Next para. The learned senior counsel for the petitioner is requested to take instructions from his client as regards such offer of payment by 3 monthly installments. Full stop. Let the matter be listed next on August 20, 2025 for being taken up at 2 p.m. Under the same heading. Full stop. It is expected that the alleged contender shall pay the undertaken amount of rupees 5 lakh to the appellant during the course of the day. Full stop. It will appear on 20th, day after tomorrow, for further order. If you can get a copy of the Supreme Court order, bring it to
yes, me. May it be, my lord, at in the first half, my lord, at 10:30, because, my lord, I'm told, my lord, he's supposed to leave, my lord, day after.
My lord, he can't. Will kindly ensures that he doesn't
not unless my lord's permit. He cannot.
Kindly ensures that he doesn't.
2 p.m. না করে 10:30 এই ওটা 10:30 করে দিন 20 তারিখে কি 10:30 অরিজিনাল সাইড নিয়ে আগে আমরা
was also praying.
Then we'll keep it tomorrow.
Keep it tomorrow.
20th না করে tomorrow, that is 19th.
And my lord, I was
August
also-
19th at 2 p.m.
I was also praying, my lord, that the appeal
2 p.m. tomorrow 2 p.m.
The main
তো ওনার
appeal is
presence তো
pending.
দরকার নেই।
The determination is with your lordship, matrimonial appeal. My lord, your lordship hears out the appeal also. My lord, I have no problems at all.
No, আরেকটা লাইন অ্যাড করে দাও, the alleged contender shall be present tomorrow at the time of call as well.
Yes.
Personally present tomorrow at the time of call as well.
Tomorrow in the second half, he is to be, my lord, cross-examined, my lord, in the same matter before, my lord, the trial court.
Cross-examination?
তাই তো বলছেন আমরা।
Kisha cross-examination? In the domestic violence.
So then 10:30 tomorrow.
10:30.
কালকে 10:30 কোনো ইয়ে নেই তো অ্যাপেলেট সাইডই তো সরি তাহলে ওটা 10:30 কালকে 10:30 tomorrow at 10:30.
My lord, may I point out one thing? My lord,
Yes.
The Honorable Supreme Court, the direction that was given, my lord, it was verbal. Despite our request, it was not recorded in my lord's order.
You try to find out take out a server copy of the order by today
My
by
lord,
tonight.
What he wants to say is that all these directions that your lordship has recorded are all verbal. Whether it will go down in the order or not, that we don't know.
My lord, I go
But
by
he
what
sounds-
Mr.
whatever.
Chakraborty says.
He
My
was
lord, he's
there
an
in-
officer of the court.
Yes, yes.
Whatever
And
he
I'm sure
says,
they can,
I go
by
by
the
that.
time they go back home, they can talk to their counterparts, my lord, in.
If it's not that we shall independently consider
Yes, Lord.
some order has been passed by the
Has
Supreme
to
Court. We
be.
look into the order and
My-
pass our own
And
direction.
also with respect to the appeal, my lord, it's beneficial for both parties that the appeal may be, my lord,
It is
disposed of.
appearing in our list,
It
the
is,
appeal,
my lord, it's
as a contempt application.
as a contempt, it's appearing.
The
main-
appeal, the client did not be present, his client.
No, that's why I'm
We'll
saying.
fix it early. No
Yes,
difficult.
Lord. Madam.
We'll fix the appeal for hearing
Just
at least.
after the
At least we'll direct it to be listed.
Yes, Lord. Absolutely.
And my
The
lord, the
paper
talks,
books and everything, my lord.
But let this contempt this thing be over.
Yeah, absolutely. Madam.
and my lord, I'm also told the talks of settlement, my lord, failed.
Yes.
My lord,
What
we-
talks of test settlement? You are in contempt.
No, my lord,
my
I
lord
we
wanted
indicated, my
us.
lord, both of us
My
that,
lord
my lord, they, my lord, sat together. My lord,
Failed,
had a
failed.
So
discussion.
there's been a lot
You
of.
will not record anything on
No,
that?
there's no need to record, but
It was
because
not official.
না না এখন মিডিয়েশনের আগে লাস্ট বিদেশ যাবে কিনা দেখুন না আগে তার জেল যাবে না বিদেশ যাবে সেটা ডিসাইড হোক নেক্সট ম্যাটার
so great.
Grateful to us.
কন্টেম্পটে তো মিডিয়েশন হবে কন্টেম্প রয়েছে তো
Grateful.
Grateful, my lord.
ইয়েস
I appear for the petitioner.
I am appearing on behalf of the respondent. on the
breakup of
draft-
arrears of alimony, yes.
Yes.
Have you exchanged? Do you agree on that? Give us a breakup.
Lord, I had prepared a supplementary affidavit, Lord. So it is in the form of a supplementary affidavit. I will be affirming it, Lord.
the course of it.
Do you agree to this breakup? Have you given a copy
But
to them?
Difference is 2 lakhs. What they have done, Lord, they have given us a calculation, Lord.
You had to give the breakup today.
Yes, Lord.
Time of hearing. Why are you not ready with that?
I have calculated it, Lord. The calculation is here, Lord.
I have annexed payment receipts, my lord.
Have you gone through the receipts?
I have gone through
You
the
have given a copy today itself.
Yes, yes.
When did you give the copy? Today.
Yes.
Today morning.
You exchange copies of this and agree on the amount because they have annexed the receipts.
These receipts are, Lord, in pursuant to the direction that has been passed in a 125 application, Lord.
Maybe the amount is adjusted.
It is adjustable.
Then?
But here the amount was
Which was the higher
7,000.
amount? Which is the higher amount?
10,000.
10,000 is the higher amount.
Civil court's amount is the higher amount.
3,000.
And that is to be paid from March.
No, they have calculated on 3,000 basis for all these months.
Yes, my lord. And also the one whole year we haven't paid.
That also you have calculated.
Yes.
Yes, what is the scope of disagreement on this?
Not
on the arrears also you cannot agree on facts.
On arrears, I am also the total amount of arrears are also not tallying, Lord.
Their breakup, my lord. But
So you give a hand over your breakup. Why should it be in the form of a supplementary affidavit? We have just asked for breakups as they have given.
But then I'll be preparing on the basis of that, Lord.
My lord, if you
We directed you to exchange. Why didn't you exchange copies of this?
I have handed over a copy to
My lord,
them.
Now.
No, in the morning, Lord. Today morning.
Today morning is today morning. It is unfortunate that despite our specific direction to the parties to exchange their breakups as per the respective versions of the parties to be exchanged, copies thereof are being exchanged only today. Full stop. A copy of such breakups as per the version of the respondent husband is filed in court today and kept on record. Full stop. Since learned senior counsel for the appellant seeks to use a supplementary affidavit to give such breakups, the matter is adjourned till tomorrow for filing of such supplementary affidavit. Full stop. The matter shall be listed tomorrow under the same heading.
Lord, can it be taken up day after tomorrow, Lord? Because if supplementary affidavit.
Affirm it today.
But she has to come from Asansol, Lord. She will be coming from Asansol.
You said you will be having it affirmed today.
Lord, in the course of tomorrow, Lord, kindly make it.
We directed you to do it today.
In that case, Lord, I can exchange in the form of an informal one, Lord.
Advance copy give to her right now.
I have given an advance copy.
Get it affirmed today and file it tomorrow. It will be tomorrow. Yes. আমাদের টাকা পয়সা You're for the respondent?
Yes, my lord, I'm appearing for the respondents.
You have sought for a recall of them?
My lord, I have sought for a recall.
What was the order?
My lord, I'll just hand over the affidavit service. My lord.
You are for the appellant?
Appellant, yes.
The opposite party in this application?
Yes.
Right. You have got a copy of this application? Yes. What is your matter?
My lord, by order dated 4th of November 2024, my lords were pleased to pass an order injuncting the suit premises from being transferred. Thereafter, we had filed a recalling application, my lords, on the ground that determination was not there before my lords on that day, and hence my lord had referred the matter before a special bench, which has been answered, and subsequently, my lord, we filed that recalling application along with the order, which I'd like to place before my lord.
Yes. What was the point of reference to the special bench?
Just my lord, the
Was
question.
our order referring the matter?
Yes, my lord.
That is also annexed here?
Yes, my lord. It's annexed as annexed.
That's very well, yes. Let us see, page 21 is that question, the reference.
Yes, my lord. My lord had posed the question whether an order passed by the bench.
Yes, nullity or not.
Nullity or not.
It has been held to be a nullity?
Yes. Yes, my lord, it has been. My lord, the reference part, my lord, is on page 34. My lord, para 24, para 25. From page 33, my lord, if I may just put before my lord.
Yes.
However, the question is whether, due to the Honorable Chief Justice not allocating the requisite determination.
Whatever be the reasons, so past a nullity. It has been held to be a nullity.
So, my lord,
So
I
if
just
it's a
pray
nullity, we have to recall them. Yes.
My lord, I pray for recall on that basis.
Definitely. Yes. Then it's we're recalling them. The present application has been filed for review for recall of an order dated November 4, 2024, passed by this bench in connection with an application for injunction. Full stop. Next para. The matter came up before this court for recall of the order dated November 4, 2024, when, vide order dated November 20, 2024, this bench had formulated a question and referred the matter for resolution to a larger bench. Full stop. The said question is as follows: colon দিয়ে নিচে double inverted মধ্যে, whether an order passed by a bench B capital of this court C capital not being conferred with determination by virtue of the roster ROSTR fixed by the Honorable the Chief Justice is vitiated by inherent lack of jurisdiction so as to render the order so passed a nullity in the eye of law or void italic say ab initio double inverted close full stop. Next para. The reference was answered by a larger bench constituted by the Honorable the Chief Justice by an order dated July 3, 2025, whereby the reference was answered in the positive, by holding that such an order, by a bench not having determination is vitiated by inherent lack of jurisdiction so as to render the order so passed a nullity in the eye of law and void ab initio. Full stop. In view of such answer, the order dated November 4, 2024 by this court was a nullity ab initio. Full stop. Accordingly, Can 4 of 2025 is allowed, thereby recalling the order dated November 4, 2024 passed by this court in connection with FMAT 269 of 2024 along with Can 1 of 2024 and Can 2 of 2024. Full stop. Liberty to the parties to mention the matter before the appropriate division bench having mention the main matter before the appropriate division bench having determination.
Grateful, my lord.
Thank you. আচ্ছা প্রথমে একটা হয়ে যাবে affidavit of service certificate. Please give your names both sides. Give your names both sides.
My lord.
Yes.
I appeal for the respondent number 6, KMD. Lord, my appeal was dismissed for default for which an application was filed for restoration. Appeal is ready for hearing because we have already submitted paper book.
This is the restoration application?
Restoration application. Paper book, we have to file it, but ready. Copy was served on them. Copy we can serve. This is restoration appeal, restoration of the appeal.
Restoration file within time?
Within time.
Yes, Mr. Talukdar, what do you do? Mr. Mukherjee?
I am appealing. There are 3 appeals. In one of the appeal, I am for the respondent. Now, subject to correction, possibly this is not within time. Because 30th April dismissal order and 9 June is the applicant for restoration.
No, my lord. Within time, within 30 days.
Subject to correction. What I understand from the post-title.
No, Mr. Banerjee. 9th June affirmed.
9th June.
Affirmed on 9th June, order is dated 30th of April.
Oh, then immediately after the vacation, on the date of after the vacation. 19th June. Not 9th June.
30th April. So 30 days expires on 30th May.
9th June. No, it is in my copy.
30th May was within the vacation. Yes, 9th was the reopening date.
Reopening date, my lord, it was filed.
Yes.
19th June.
In our copy, 19th written that
No, 09. That's 09.
But it is 19 in our copy.
Oh.
However, Mr. Banerjee also stated in the application for after condonation of delay. If your lordship see the cost title,
No, that is another appeal, another two appeals, my lord. Practically, that appeal, my lord, cannot be pressed before your lordship. But that was dismissed for default.
sir, আমি একটাই আছে
Section 5 was allowed in that case.
Two appeals were preferred arising out of two writ petitions.
My lord,
The
my-
appeals themselves were dismissed for default by the same order.
By the
So-
same order, right, my lord.
So you have to file two applications then.
Two applications we have filed.
In the two appeals?
Yes.
আরেকটা কোথায়? আরেকটা ফাইল? 1780 দুটোই আছে এখানে?
Lord, total 4 appeals, my lord, 17, 18, 19 and 20.
But by these two are dismissed.
Yes.
For default. No, both are ninth. Both are ninth.
I am only appearing in item number 19.
Indicate in your appearance that.
I am appearing on all.
And
Have you
paragraph-
draft copies on all?
Yes,
I'm-
my lord.
I'm
4,
item
5
number
and
20.
6. 4, 5 and 6, my lord, paragraph we have
Sir,
said.
নাম দিতে বললেন
The reasoning,
Affidavit of service you have filed. Affidavit of service.
affidavit of
একই matter analog.
Filed in both the matters.
receipt are there, my lord. We have given affidavit
That
of
will do. That will do. You file the receipts in
Receipts
both the
are
matters.
সব কটার আছে
আচ্ছা আমাদের গরমের ছুটি বললো হবে
আর দুটো দিয়ে দাও সব কটাই আছে Yes, my lord. This is
The receipts of service filed today be kept on record. Full stop. Heard learned counsel for the parties. Full stop. What is the reason given, Mr. Banerjee?
my lord, is in paragraph 4, 5 and 6.
illness of the learned advocate.
Same
Illness
advocate
of the
is
learned
there.
advocate for 3 days.
Your ground.
Yes,
Same advocate is
yes, advocate on record.
uh, the two applications bearing can 2 of 2025 in connection with FMA 1342 of 2024 and can 4 of 2025 in connection with FMA 1336 of 2024 have been filed for restoration of the said two appeals which were dismissed for default by a common order dated April 30, 2025. Full stop.
33.
The order was passed on April 30, 2025. Full stop. Thereafter, comma, the
Can dispose of.
limitation period of 30 days for preferring a restoration application expired on or about May 30, 2025, comma, during the summer vacation of this court. Full stop. The summer vacation of this court ended on June 8, 2025, and the applications have been filed on the very next working day, that is on June 9, 2025. Full stop. As such, comma, the applications were filed within time. Full stop. Next para. Upon perusing the amendments made in the applications, we find that sufficient reason for the absence of the appellant on the relevant date, comma, that is the illness of the learned advocate for the appellant, comma, has been made out. Full stop. Accordingly, can 2 of 2025 in FMA 1342 of 2024 and can 4 of 2025 in FMA 1336
Including
of 2024
applications, Lord, including applications. Including applications. We
Are-
are read for.
allowed, comma, thereby recalling the order dated April 30, 2025 and restoring FMA 1336 of 2024 as well as FMA 1342 of 2024
cancel.
along with the connected applications to their original files and numbers. Full stop. Since was there an interim order subsisting?
No, my lord, there was no interim.
আর
order.
কিছু না। The applications, the restored applications be listed for here. This arise from matrimonial suit.
No.
Acha, liberty to the parties to mention the main matter before the appropriate division bench having determined.
Lord, including can 2 and can 3. Can 3 are the applications.
But only thing if you are
Appeal and
taking one,
applications are
Order
different.
says including connected applications, we have said we restore appeals along with the connected applications. Whatever was the language
Lord,
used there.
whatever is here.
here only it has been mentioned MAT such and such are dismissed for default. Regarding can, nothing has been
Yes, stated, and all pending connected applications.
Subject to correction.
In the order, 30th April order.
না ওটা হচ্ছে ম্যাট
In FMA, in can 4
ম্যাট দুটোই তো তাহলে ওটা
30th April
Application
2025
কবে?
order. If you are permit, I can read, my lord. None appears for the appellant in both the appeals. Respondents are represented. MAT
কত
MAT 2132/24 and MAT 2134/24 are dismissed for default.
Lord, that is another two appeals.
and 20.
That is 19 and 20.
Separate order.
They
They
are
are
not
not yet
yet
called
19
19,
and
20. These are 17, 18.
Yes.
They
This
require
is 17,
specifically
18.
recorded applications.
Yes, applications.
You are on some other file. We looked into the annexes to the applications.
So
And it's
17, 18. recorded.
17, 18
Recorded.
we have passed an order right just now. 17, 18 records with connected applications.
But 18, 19.
1 minute.
19, 20. 19, 20 does not record. 8 or 19.
Can 2 এ দেখবি লেখা রয়েছে? 1920, yes.
1920 does not record it.
Yes, that's not. This
Apart
is
from
not only.
else everything same.
Yes.
Same order
Right.
pass করে দাও 1920 তে or date everything same.
Only exception. Lord, only exception is in those two matters applications are there.
Can number
Here
গুলো
no
অনিন্দিত লিখে
application.
নাও।
Only
Can
appeal
2
or
of
dismissed for
2025 টা ওটা দিন।
Same, 1920.
দুটো তো 18, 19 টা।
ये देखिए, can
2132 of 2024 আর MAT 2134 of 2024 দুটোতেই can 2 of 2025 বাকি সব এক শুধু লাস্টে যেটা বললাম and restoring recalling the order হ্যাঁ connected applications-টা হবে না
Lord, appeal
you
is.
also file the receipts in the
Yes,
1920
yes.
you have filed the receipts in 1920 also
Yes, yes, all the three matters, my Lord, all the four matters, we have filed it.
I mean, all these.
20 and.
Nah.
And my Lord, only another thing, my Lord, can I mention it for the purpose of fixation of hearing short matter? Very
no,
short
we don't
matter.
have determination regarding this
Because all the.
we have only matrimonial appeals we have only matrimonial first appeals
Oh, no land appeal.
land appeals yes
Land appeal. Land appeal.
this is a land appeal
Land appeal.
then we have determination group 1 the appeals are ready for hearing
Lord, land appeals, my Lord,
So are directed to be.
you prepare the paper books let the appeals be ready for hearing mention it when it is ready
yes.
yes next 21 22
না না দিতে বলে দাও মেনশন করে দাও কি দরকার তোমার মেনশন করো
22
I'll be praying for a week's time. My
Oi.
service is not yet complete. And we can see the status report because of
Lord,
the
this is
technical-
a problem that we are facing, my lord. No track report is available for last 2 weeks, my lord.
Yes, my lord. So
no track report at all
Yes, my lord.
We all are facing, my lord.
obviously everybody's then you have to write to the postal authorities
This is a difficulty in all matters we are facing.
write to the postal authorities and to take some reply and put it in an affidavit of service we used to that sometimes it happened pre postal speed post era also
Yes, yes.
same thing nothing is returning we wrote to the postal authorities got a reply
That will.
and you can collectively move through the bar also
Yes,
this
my
is
lord.
a problem
But
you are appearing if everybody is appearing will if you are not ready we'll take up on some other day but if everybody is appearing we'll dispense with the affidavit of service
But I'm for the respondent number.
who has not been served
9 to 45.
who has not been served
The original read petitioner and the respondent, my lord, who is responding in the present case.
these applications are filed by the respondents
The respondents in the original case are the petitioners here.
all right are the appellants here
We are the appellants here, my lord.
right so read petitioners have not been served
No.
you have any of
I am for one of the there are two.
one of the matters you are for the read petitioners
Some of the private respondent, I'm for seven.
no read petitioner what about the read petitioner in the other Majid Khan and Chandan Bodal arising out of similar matters
Yes, similar, my lord.
you are appearing for Majid Khan and others or Chandan Bodal and others
My lord, in those in both the matters, my lord, I am the private.
oh sorry Nane Khan and
Alam
Faisal Hussain
Two read petition.
you are for Nane Khan and others so ask your client to obtain a wakalatnama from Faisal
the
Hussain.
relation is also very hostile because
Between them also. Excellent.
they are not on the same boat, but
Learned counsel for the appellant submits that due to certain glitch in the website of the postal authorities, no track report can be obtained in respect of service on the respondent stroke writ petitioners in connection with FMA 939 of 2025. Full stop, next para. It is expected that the postal authorities shall immediately rectify the issue. Full stop, let a copy of this order be forwarded to the which should be the authority to whom it should be served. GPO.
GPO, my lord.
To the GPO at the earliest by the learned advocates for the parties. Full stop, the postal authorities shall act on the server copy of this order without insisting upon prior production of a certified copy. Please serve a copy of this, either of any of you, on the GPO.
আমি কিন্তু এনে চাই আপনার সার্ভিস হয়ে গেছে আমি তো গাড়ি যাচ্ছি আমাকে একটা কপি দিয়ে নাও
My lord, the returnable date.
Pardon?
Returnable date of this
Oh,
application.
acha, the matter shall next be listed. Yes, thank you. The matter shall next be listed on. Should we keep it in September? 2 weeks.
My lord, next week would
The
suffice.
matter shall be listed next on August 25, 2025.
Grateful, my lord. আপনার নম্বরটা দিয়ে দিন। Grateful, my lord.
Yes, Mr. Bhattacharya, today you have no problem.
Today I have no problem, Mr.
Tomorrow you will be.
Mr. Bachawat was addressing your lordship.
Yes.
My lord, I can only give the reply on the 28th.
But only thing is, my lord, that is what Mr. Bachawat had, my lord, checked with my learned friend. My lord, he had, my lord, suggested, my lord, because he can't give a reply, therefore, so that the continuity is not lost.
Tell us when.
My lord, let Mr. Bhattacharya.
28.
He wants it on the 20th.
Very well. On the prayer of learned senior counsel appearing for the appellant, let the matter be adjourned till August 28, 2025, when it will be listed under the same heading.
Grateful, Your
Thank you.
Continue to the.
Here for the respondent. Appellant. Where is Mr. Bhattacharya? You are Ms. Ghosh.
Yes, ma'am.
So you can start. You were arguing. You had finished arguments? No. Mr. Bhattacharya had finished.
My lord, he has something more to address.
Part had matter, no time. You have to start.
Your lordships can leave, may I conclude those appeals?
Yes.
Two writ petitions. One was under group 1, one was under group 5. Those two writ petitions were heard by the honorable single judge
Analogously.
analogously.
Since you have determination regarding one, we have allowed both.
One.
That single order, we cannot segregate the order. So that's why you have recalled the order, automatic effect is both are restored.
I told that group 1, I subsequently find that the.
No, very well. We have not directed the main matter to appear before us. If it's too hard together, you have to get it assigned before either bench. Because one has group 1, the other has the other determination. So you have to get it assigned before the other bench, preferably before the other bench. Preferably get it assigned before the other bench. Yes. Yes. Yes, Mr. Bhattacharya. Your learned junior bought you some time. Yes.
Nothing more is required to be.
Just remind us in a nutshell. Section 6 proceeding. The Pension is that
Chica tenancy.
you are the tenant or the or the
Plaintiff landlord.
Plaintiff landlord.
Defense
struck out. Yes. Both reasonable requirement.
Reasonable requirement, default, MOP.
Notice and reasonable requirement. MOP was not held in a.
We could not prove it.
Could not prove it. So trial
notice was held to be good. Now, landlord-tenant relationship, since 7172 application was not filed,
Milord, defense was
struck out at the judgment, in the judgment
in
itself.
the judgment itself. And now, Milord,
But they were permitted to cross-examine and all these things.
all these things. Now, Milord, my point was whether Milord Thika tenancy point, Milord jurisdiction issue can be looked into at all, Milord.
Yes.
Now, Milord, I had Milord already Milord cited Milord one decision, Milord, on the last occasion.
Give us half a second. Yes, one decision. Yes, Justice. Oh, that's two decisions you had cited.
Yes, Milord.
One was you cited the unreported version, but it's
2009 volume 2 CLJ.
Yes, you gave
Milord.
596.
596.
96. There, what was held? There, it was
Milord,
there.
kindly see the last two
Yes,
lines
yes,
of
they
that.
rightly pointed out.
Considering, Milord.
Saving clause 27 does not get one. But that was on saving clause.
Yes, repeal and savings clause. Why, Milord? Because here also another point, Milord, my lord. On the last occasion, I had showed your lordship section 27 of the act.
Yes.
Why 27? Because, Milord, here the learned trial court has specifically found that in our plaintiff case, it was the case that the suit is, Milord, they are defaulters since, Milord, 1991. Now, Milord, that's why, Milord, if your lordship would kind enough to take up, Milord, the act once, Milord, paragraph, Milord, the section 27.
West Bengal Thika tenancy যেটা Thika tenancy act. আচ্ছা, premises tenancy একটাও লাগবে এক্ষুনি। West Bengal premises tenancy act 1997. Thank you.
Right.
Premises tenancy act. Yes, 27.
Milord, kindly see with effect from the date of commencement of this act, the Kolkata Thika and other tenancies and lands acquisition and regulation act 1981, West Bengal act.
So to A and B, you are saying?
A, yes, notwithstanding the repeal of the said act, such repeal shall not A, affect the previous operation of the said act or anything duly done or suffered
A, B and
thereunder.
C, all three.
B, affect any right, privilege, obligation or liability acquired, accrued or incurred under the said act. Therefore, Milord,
but this, Mr. Bhattacharya, is not some right or privilege or obligation arising out of that act. So this is not something accrued or incurred under the previous Thika tenancy.
No, Milord, if your lordship would kind enough to appreciate two things. One, Milord, right to evict, Milord, is there, Milord, and in the 81 act, and also, Milord, in the 2001 act. But, Milord, in the two acts, Milord, the forum is different. And while, Milord, when the forum, Milord, the 2001 act says the Premises Tenancy Act 1997 will apply in this case for eviction of a bharatia by a Thika tenant. Therefore, the mode is prescribed, the forum is prescribed.
Why not? Because your right to evict is circumscribed by section 6. You cannot evict the tenant if he is a premises tenant unless section 6 operates. Section 6(1) probably speaks about default. So therefore, 1 or 1A or whatever before the first ground. So therefore, your right of eviction is circumscribed
1B
by a rider 1B. You cannot evict. It says you cannot evict unless these are satisfied. So therefore, your right to eviction is subject to any of these provisions being satisfied. And when they commit a default, if there are premises tenants under this act, then that provision is attracted. Therefore, the right you get is under this provision. Because suppose this act, I mean, if the act was not there, if it was a transfer of property case, then it would be contractual. I mean, that right would be contractual forfeiture. Statutory, but had a contractual flavor also. It's a mixed question. statute as well as contract. Forfeiture under the contract or expiry under the contract. But it's a good argument. We'll record that. You say the right to evict flows from common law. But the statute fixes the forum.
Forum, yes. Where will I go? And that is, Millard, 2009 volume 2 CLJ, Millard, that unreported version, Millard, which I had, Millard.
But what right or privilege or what right or privilege do you speak of? Then what is the right of privilege? To evict?
To evict.
Even that does not flow from the previous Calcutta Ticket Tenancy Act. Your right to evict is in common law then.
If that, Millard,
nothing flows from the previous Ticket Tenancy Act regarding eviction, neither the right to evict nor the advantage of default, nothing is available under the Calcutta Ticket Tenancy Act.
Millard, only, Millard, the only thing, Millard, if your lordship would kind enough to once come to, Millard, that judgment, Millard, of Justice Bhattacharya in single bench, Millard,
will just now look at. Yes, this judgment.
Yes, Millard, kindly see, Millard, before concluding, Millard, the last three.
Before concluding,
Yes.
that is the relevant part.
This court wants to keep it on record that this court does not feel it necessary to consider the contention of Mr. Gupta regarding maintainability of instant suit before the civil court seriously, as the said point was neither raised by the petitioner before the trial court, nor the same was decided by the learned trial judge. Though it is rightly pointed out by Mr. Gupta that Section 8 of the West Bengal Thika Tenancy Act provides for trial of such suit by the controller appointed under this act. But in my view, the repealing and savings clause contained in Section 27 of the said act, which in my prima facie view does not create any bar in maintaining the instant suit before the civil court as the plaintiff's right to evict. Well, this is, Millard, evict the defendant has arisen under the 1981 Act due to default committed by the defendant in paying rent during the time when 81 Act was in operation.
Mr. Bhattacharya, two things. First, in view of the rider that it's a prima facie view, this is not even a proposition of law laid down.
This may be obiter.
One. Secondly, that is the way to save this judgment from our differing, which I don't want to do. But we differ from this view. And probably the learned judge was conscious, that's why it was a prima facie view, he did not go into this. At the time of passing of the judgment, this came to his mind, he put it in, obviously in open court. So it was his prima facie view, his lordship expressed. But the right to evict, you satisfy us, being the successor in interest of this judgment, you satisfy us on law that any provision of the Thika Tenancy Act, previous Thika Tenancy Act, Mr. Bhattacharya, which confers right to evict.
My lord would kind enough to see 27D.
You are fishing out statutes. 27D. Achha, wait. D, yes.
Affect any investigation, legal proceedings or remedy in respect of such right, privilege, obligation, liability.
You don't get it, Mr. Bhattacharya.
Yes.
Whatever it relates back to such right.
Such right.
Right arising out of said act.
Therefore, Millard, whatever is
there in 27.
It relates back to A, 27A.
Yes. It relates back to Thika Tenancy Act. That right or privilege or obligation, liability, sufferance has to arise out of 81 Act. 81 Act does not do that.
No.
It's a special statute for some other purpose. If 81 Act gave you the liberty to have an eviction, yes, definitely. Rather, it's the 80 or either 81 Act or 2001 Act. Rather, the 2000 these acts designate the forum.
Yes.
Purely forum. Section 5 of this act and section 8. Both are purely on forum. Adjudication of two things. So this is a forum clause as far as eviction suits are concerned. But this is a special statute regarding ticket tenancy. That is the difference. And Premises Tenancy Act is a special statute regarding eviction. If it is not there, then transfer of property being a general act would be a special statute in regard to lease.
No, my lord,
If it's a transfer property eviction, then transfer property act would be the statute, it would be a special statute regarding, as opposed to suppose some other statute governing some other things.
No, my lord, here in that case, my lord, perhaps I cannot take that point because in view of 3F, my lord, more than 5,600 and my lord, the rent is lower. My lord, TP Act, my lord.
No, TP Act is not. This is just hypothesis, hypothetical discussion. But it's a very interesting argument. But we feel that we feel against you on this. And the other question is, we have to spend one night at least on that.
Defense,
when
defense has been struck off, it was, my lord,
because the difficulty, otherwise inherent lack of jurisdiction, everything your learned friend was absolutely correct. Difficulty lies in our dilemma is because the language used in any dispute. Dispute cannot be raised without there being two side issues. Like Akhate Talibajana concept. There cannot be a dispute between one party and a vacuum. There have to be two parties whose pleadings must be on record. Dispute cannot be raised by way of a something lesser than a pleading also. Here they did not also file section 7.
7.2 was not
filed. That is my last thing. We could have the best view, the most liberal view in their favor, because otherwise civil court did not have jurisdiction. We would take the most liberal view against them and even take into consideration in section 7 probably. Because the dispute was raised. Maybe not in the pleadings, but in the suit. Here is nothing from their end on record. Written statement we cannot look into.
Written statement, only one stray, my lord, line has been given. This is governed under this is we are Thika tenants and
that is sufficient. That would be sufficient to raise a dispute.
And proceedings are pending and they have, my lord.
The question only remains then without the written statement whether we can look into this. There is no cross objection as such to that 13.
No, my lord, they have preferred a regular appeal. Now, in this appeal, there is no cross objection.
That regular appeal is before us also.
No. Regular appeal was the title appellate court before the city civil court. The suit was decreed. They had no occasion to file cross objection. They have filed a regular appeal against the decree.
No, that has merged into this one single judgment.
One.
Sections and 7.3 we cannot look into because they actually were in default. So there cannot be any dispute on 7.3 operating.
And
7.3 does it require an application?
7.3 does not require an application, my lord. My lord, on this aspect, my lord, I tried to, my lord, search out some judgments.
What is the language of the state? Does it speak of any application?
No.
If the tenant fails to deposit, civil judge shall order the defense.
That is the only consequence.
And 7.3 does not require an application. We have argued when we at the bar, we have also decided. 7.3 is
7.1 also does not require application.
No.
7.3 also does not.
Perfectly right. But 7.1 probably last night I saw something on live law.
Oh, no, 7 days.
I have application is required.
No.
We'll have to apply your skills in distinguishing on facts.
I could not, my lord.
But live law I don't rely on.
I agree with that, my lord. It says that 7.1a, 1b, 1c are all mandatory. My lord, if there is landlord-tenant relationship, my lord, which is in dispute, my lord, still he has to file, my lord, deposit, my lord, the admitted rent, arrears of rent, my lord. This is something, my lord. I have brought that judgment, my lord. Or for the other purpose, for the other purpose, my lord, I have brought it, my lord, for some other, my lord.
In this matter,
for other observations. I brought that.
Very well, but for the timing, yes.
Then, my lord,
but no, they have argued in this case.
Yes.
You are in rejoinder. So you cannot cite.
They have not started, my lord, my argument.
He indicated, your learned friend indicated.
He has shown, my lord, my
cite whatever else you have to see.
Yes, my lord.
So the first question is this. Defense whether that can be looked into, and second is section 7.
Jurisdiction ওই পাতাটা কোথায় গো?
Very well.
Before the first appellate court, my lord, we had relied upon, my lord, Modula India's case. কেটে গেলে না কালটা
Why did you cite the other judgment? This Deepchand Hirawat or something?
Oh, Deepchand Hirawat, yes. Kindly comes to the appeal court's judgment, my lord. Appeal court has, my lord, made, my lord, kindly see, my lord, lordship with para 52, page 152.
What was the proposition laid down here?
Yes, that even if, my lord, landlord-tenant relationship is in dispute, my lord, section 7.1 has to be complied with. Us. 1.7, then kindly see, my lord, paragraph 52, my lord also, my lord, Justice Sarkar's judgment.
Yes.
Yes, kindly, yes, for this proposition, kindly see page 152 of the paper book.
Yes.
Kindly see, it is to paragraph 52. It is to be kept in mind that that in the said suit, the defendant has claimed him as a Thika tenant under the state and not a premises tenant under the West Bengal Premises Tenancy Act 1997. Here, my lord, my point is, my lord, when the suit was pending and when the appeal is pending, where there is no, my lord, conclusive adjudication of the Thika tenancy right. Even after the, my lord, appellate court's judgment, my lord, the order, my lord, has been.
Because the language is the defendant in a suit under this act has to file that application. No, but what if the admitted amount is 0? 0 is also a valid number.
That is a valid
in
number,
mathematics.
but adjudication is necessary.
If I say my admitted amount is 0 to you,
adjudication is necessary.
What will be the admitted amount you deposit? That is what we are asking you.
No, in that.
Suppose I take a point that you are not my landlord. You are a busybody, third person having nothing in the property. I was inducted by X. I have been paying rent to X. So I owe nothing to you. What would be the admitted rent then? The admitted rent paid to X, I'll pay that double.
10%. Something has to be admitted by the defendant.
Admitted rent for the premises.
Even for adjudication. Idea 140, 141 আছে হয়তো।
No 7.2 was filed by them. Then the relationship was not disputed even. They had to comply with 7.1.
Yes.
Very well. Yes, what else?
Yes, kindly see, my lord, why I referred Deepchand Hirawat for, my lord, paragraph 52 to paragraph 54.
Understood.
My lord, now this is, my lord, what, my lord, the learned appellate court has clearly stated that since relationship in dispute, they need not file it. They need not file it. Or need not deposit it. Need not file, need not deposit the admitted. So that is not, my lord, that is not, my lord, Now, my lord, kindly see on the last occasion, my lord had, my lord, posed a question to me whether, my lord, an interlocutor for striking of a defense, whether an application is necessary. My lord, application is definitely not necessary. That is not contemplated in statute. Secondly, whether, my lord's next question to me was whether it can be, my lord, defense can be struck out in the judgment itself or by an interlocutory order. But I could not get any direct proposition on this issue, but there is one judgment, this is also a single bench, but
single bench does there is a difficulty in a single bench. I mean, it can be a single bench, other high court also.
Here is also, the one of your lordships, colleague appeared, in the matter,
দিন বসে আছেন?
আরেকটা
কি মনে হলো ওটা এমনি বাড়ি ধরে আছে?
অরুণ প্রকাশ 2017 volume 1 ICC 721.
Yes.
Here, my lord, kindly comes to my lord, paragraph, my lord, 11 and 12. Ten, 11 and 12, rather. In ultimate conclusion, if your lordship kindly see paragraph 12, it says, in case of Bina Devi Binani, this court, following the ratio of the decision of the Supreme Court in the case of Nasiruddin, has held that the word shall used in section 7(3) of the Act is imperative in nature. Therefore, in absence of any provision for extension of time to deposit the area of rent directed to be paid by the court under section 7(1) of the Act, with the default on the part of the defendant tenant to pay such area rent together with the statutory rate of interest within the time stipulated by the order passed by the court, a right accrues in favor of the plaintiff landlord under section 7(3) of the Act for striking out the defense of the defendant tenant against delivery of possession, and the court has, my lord, this is the, my lord, line, has no discretion.
No, that is correct.
An order directing striking of the defense
No,
of the
that's
defendant
mandatory.
tenant against delivery of possession.
That's mandatory. That's as per the statute. And here, the court adopted a fair approach in the sense that although it withheld that adjudication till the final judgment, but it permitted them to cross-examine and do everything and lead evidence also probably. They were permitted to lead evidence also.
Yes.
So therefore, pending adjudication, he kept it pending. If ultimately he had not struck out the defense, then those would be on record. So he reserved his right to strike out the defense at the final. They were not prejudiced by that. We are putting this for you also because they were not prejudiced by this striking out of the defense at the final stage. They were permitted to do everything: written statement, leading evidence, cross-examination. And when the defense was struck out, court had no other option as per you, as per this judgment, as per the statute. So therefore, everything goes very well.
And now, my lord, the parent judgment, my lord, of your lordship.
Because it may happen that after I frame an issue, seventh stage occurs. So issue is already there, but that issue will be decided in the...
No, issue will be then, my lord, will be very limited.
No, issue has already been framed on the basis of the written statement.
But
what happens if subsequently defense is struck out?
No, then, my lord, at the time of final argument, it is the discretion of the learned trial.
It may be resettled.
What extent he will permit.
No, the issue may be resettled, or that issue may be decided against them.
Recasted.
You just decided against them, even without recasting. Suppose this question is raised with a landlord-tenant relationship. In view of striking out of the defense, this is decided in...
Yes. Now, my lord, then, my lord, the Bina Devi Binani's judgment, my lord, 2015.
And don't cite all the judgments which have been cited in Bina Devi.
No. 2000.
So that is the reason. This is the reason of this.
Yes.
So don't cite everything which has been recorded in Bina Devi Binani.
2015, volume 3, ICC 460.
Bina Devi Binani is the same judge's judgment. That's why I ask you repeatedly not to cite my own judgments before me. This is what happens. One tends to rely on one's own judgments. And if you go on backwards, you'll see the same judge probably.
Yes.
So it's a bit, anyway, whatever. Bina Devi Binani is the same judge, so just same view, the language.
No, what my argument is, my lord, basing on...
Give the paragraph.
Paragraph 18 to, my lord, the 18 to 25.
And in the other judgment, which paragraph?
My lord,
just now,
10, 11 and 12.
10 to 12, right.
My lord, if it is, my lord, court has no other discretion, my lord, why, my lord, these judgments came? Bina Devi Binani, lordship would remember, in, my lord, the old 56 Act, there was a provision under 17(1)(a) and 1(b) for extension of time to, my lord, to deposit.
That's why Khemka's case, everything.
Nasiruddin, all those were there. Now, my lord, it's specifically stated that no, since those provisions are not there, court has no other option but to strike off defense.
And proviso is very clear now, in a negative language.
If, my lord, that is, my lord, the mandatory duty of the court, whether by interlocutory order or by, my lord, on the final judgment, but it's by operation of law. It's by operation of law. And the next judgment is Seventh-day Adventist Church, my lord. I have several reservations, my lord, but some of the paragraphs are in my favor.
এইসব জাজমেন্ট গুলো সাইট করে তারপর ডিসটিংগুইশ করতে হয় তারপর নিজে কেস করে পরশু দিন তখন বুঝুন Cite the judgment, Mr. Bhattacharya. No difficulty on our part. We adjudicate. You have to answer your clients.
তোমায় কপি দিচ্ছি SLP সিভিল নাম্বার 10900 of 2024 আমি দিচ্ছি না কপি দিয়ে দিচ্ছি 10900 হ্যাঁ হ্যাঁ that's it.
Yes.
Kindly see my lord paragraph 35 onwards. Here my lord the view taken by
You are very fast. You keep yourself abreast. Very good.
I my lord utilize this long weekend my lord.
For these unnecessary frivolities, instead of doing something more worthwhile. Yes.
My lord, here my lord the view of Deepchand Hirawat my lord which I relied upon Justice Sarkar's judgment has been affirmed. That view has been kindly see paragraph 35 onwards. Kindly see as concluded above, the applicability of the limitation is subject to the provision of West Bengal Premises Tenancy Act, meaning thereby if the limitation has to be prescribed to be to do some act, it cannot be extended by the aid of proviso, proviso to subsection.
So that was settled previously.
No, then it was my lord, the Chamaria was distinguished in Amol Boral. Then my lord, now it has been clear. Kindly see my lord, let me read the remaining part. As such, the inescapable conclusion of the facts and the law as discussed herein above is that the compliance as required to be done by the tenant in section 7(1)(a), B and C and the first part of section 7(2) regarding deposit of rent and filing an application within the same time is mandatory. Therefore, my lord, what I am, my lord, I hope, my lord, this satisfy your lordship's, my lord, query that 7(2), my lord, if there is, my lord, this dispute regarding landlord-tenant relationship, whether, my lord, he has to, my lord, deposit the arrears of rent.
He did not file a 7(2).
Did not. In a given case. My lord, it
No,
says
even if he filed 7(2) and did not comply with the timeline, then this would occur.
Even, my lord, no. It says 7(1)(a), B and C all are mandatory. Therefore, deposit of admitted rent is also mandatory, my lord, in case of 7(b) to maintain an application under section 7(2).
Yes, because 7(3) covers both 1 and 2.
1 and 2.
This judgment is not required for this proposition. I mean, it's lays down the same, but this is not a laying down of the law, is that?
Yes.
Because section 3 language is if the tenant fails to deposit or pay any amount referred to in subsection 1 or subsection 2. Subsection 1, ABC are included in subsection 1. So even if I don't file a section, I cannot not file a section 7(2) and say I need not, then I have to comply with 7(1).
7(1).
If I don't file a 7(2), I all the more have to comply with 7(1). Because that is the only provision which remains to protect my defense.
And here, my lord, by not filing, my lord, they have virtually, my lord, admitted, my lord, the landlord-tenant relationship. Because there has to be a prima facie finding.
Yes, in a sense.
There has to be a prima facie finding.
No, need not. Because
prima facie
finding. One may not find a 7(2) because there is no dispute as to the amount of rent payable by the tenant. Although we generally do it all the time. We file a 7(2) if the landlord
to be on the safe side.
To be on the safe side. But suppose hypothetically someone does not have a dispute as to the amount of rent. In the written statement, if the pleading is there, but here no written statement. So anyway, here these are becoming hypothetical because in any event they have not filed 7(2), 7(1), anything, not complied with anything. Thicker tenancy is not their last straw, is their only straw.
That is their only straw. And the, my lord, last judgment, my lord, it is also recorded, my lord, in the, my lord, the judgment of the, my lord, first appellate court, my lord, the Modula India's case, my lord.
Yes, right.
1988, volume 4, SCC 619. नहीं এই appeal court এ কোন জায়গাটা বার করেছো পাতাটা একটু বার করে নাও
Which paragraph?
That's the ultimately, my lord, paragraph 24 and 25. That is the, my lord, ultimate. The honorable judges are laying down the ratio.
Yes, absolutely. This is the absolutely settled law on this subject. Absolutely. Modular India is the right judgment to cite on this. And don't cite offshoots.
My lord, kindly see, my lord, page 136 of the paper book, paragraph 20. Page 136.
Yes.
120. Kindly see, Modular India was referred to.
Yes, yes.
Kindly see after the B, A and B. Kindly see, my lord, how, my lord, the learned appellate court is discussing Modular India. Kindly see, to the defendant would not be entitled to lead any evidence on his own, nor can
No, this is a quotation from Modular. Modular also says this. Just see after AB, this is an exact quotation of.
Yes.
Modular, it's a quotation. Italics are missing. As in some of my judgments.
Thereafter, my lord,
Italics are missing, I could.
then, my lord, what is the effect of this judgment is also not discussed, my lord, by the appellate court on the latter part of the judgment.
Why was it remanded? You have forgotten that by now.
Kindly see, my lord, the last page of that judgment at page 155. To wait till the conclusion of the proceedings before the Thika controller.
Now, Mr. Bhattacharya, what is the effect of the Thika controller having already adjudicated? It has already adjudicated.
Adjudicated, we have, my lord.
Now, appeal is a continuation of a suit.
Wait,
You also argue on that.
I thought, my lord, since, my lord, it has gone, my lord, in their favor, they would have filed an application under Order 41, Rule 27 of the court and bring it in your lordship. As of today, nothing is before your lordship except issuance of notice by the Thika controller, that is Exhibit G. Exhibit G at page 337. Therefore, as of today, what both the parties are saying before your lordship, it has been decided that this is a Thika property is from the bar. Nothing is before your lordship. One. Number two, even when the trial court or the first appellate court was dealing with the matter, the Thika controller, order of Thika controller is even after that.
Mr. Bhattacharya, what will be the effect? Just let us, it's an academic discussion, but might have an effect here. You are wanting to explore the borders of these theories, the margins. Now, what would happen if suppose the decree is passed, execution is proceeding. During execution, Thika controller holds that it's a Thika controller. Would the decree be rendered a nullity? Wouldn't the decree be rendered a nullity? It would be without inherent jurisdiction.
That in that case, my lord, section 47 is there. When it question comes, my lord, we'll see.
So the appeal court tried to save that by sending it on remand.
But he could have, my lord, kept it before it also, because the appeal court has all powers of the suit court. The written statement could have been amended. Order 41, Rule 27, my lord, why, my lord, remand to my lord appeal court? Order
It's
41,
a very vital
24.
fact, Mr. Bhattacharya. If it has been decided, we cannot shut our eyes to it.
Decided, we have also challenged that before the land tribunal.
Very well.
This is what I think.
So that's all. Let us hear. To the point argument. Thank you. Yes. Yes, sir. What is your argument?
Lordship, kindly have to see Section 9 of the Code of Civil Procedure, read with Section 5(3) of the 1981 Act. This is a case of expressly outside the jurisdiction of the Civil Code. Section 9, your Lordship, kindly have to see, barred by any other law for the time. Now, this title suit has been initiated, ejectment suit has been initiated. Prior to that, TICA proceedings has been initiated. Initiation of TICA proceedings is earlier and the civil suit is later.
Is there anything on record to suggest that? You have brought those materials before the court. Those are your adversary is saying, so no need. Fair enough.
Page 337.
Thank
you. Now, if your Lordship can look to see in the plaint, the schedule, the disputed portions has been described as 150 square feet.
Tenancy proceedings were initiated before filing of the suit.
Before filing of the suit. But the judgment has been delivered after the
no objection. All right. So we should look at the schedule of the plaint.
Yes. Page 9.
Page 9, yes, schedule.
Land measuring about 150 square feet. But the TICA controller, while adjudicating our rights under Section 5(3), it has been specifically after taking into inquiry report 540 square feet.
That we cannot look into.
No, Lordships. Now the point is that
express bar Section 9 read with Section 5(3).
Now the lot of questions, factual points, it has been adjudicated by my clients. I have to cite some judgment on this particular point. First judgment, my lord, I have cited before losses 1998, volume 1 CHN 387. 387.
Yes.
Paragraph 11 and 12. This is the division bench judgment, my lord. I am placing before losses.
Yes. Paragraph 11.
If a defendant asserts that he is not a tenant at all under the plaintiff, he is, however, under no obligation to file an application under Section 17(2) of the Act, inasmuch as Section 17 speaks of the obligation of a tenant and not a defendant. But for non-filing of such an application, a plaintiff may very well come up with an application under Section 17(3) of the Act for striking out the defense of the defendant on the ground of non-compliance with the provisions contained in Sections 17(1) and 17(2) of the Act. To protect such a defendant, several division bench decisions of this court referred to in the judgment of N.K. Bhattacharya have categorically held that defense of a defendant cannot be struck out under the provisions of 17(3) of the Act if he raise a dispute as to relationship of landlord and tenant between the parties, unless issue as to relationship of landlord and tenant between the parties is decided against the defendant. Otherwise, if without deciding the aforesaid issue, the defense is struck out, in that case, the defendant will not be able to lead evidence in support of his plea that he is not a tenant under the plaintiff even at the time of trial. Therefore, the consistent view of this court for about last 40 years is that if any dispute is raised by the defendant to the aforesaid effect, even without filing an application under 17(2) of the Act, before striking out his defense on the ground of non-compliance of 17(1), the court must decide the issue. This is, I think, that too much relevant for your active consideration before loss. Now, the next decisions your losses can look to see 2013 SEC Online Calcutta 4147. Although it is a division bench, but pat on the point, what it happens in this particular case, this is also the same. Single bench. 2013 SEC Online Calcutta 4147. My lord, first page of the judgment, 2 pages judgment.
Yes.
First page, second paragraph. In a suit for eviction under section 13 of the West Bengal Premises Tenancy Act 1956, the defendant in the written statement disputed that the defendant has not taken out an application under 17.2 of the Act, raising a dispute as to relationship of landlord and tenant. Several attempts were tried to be made for framing a preliminary issue and filing of an application under Chapter 7, Order 7, Rule 11. What it happens in our case, it has been rejected. Of the court relating to maintainability of the suit, but the defendant
in your case also 7-11.
But the defendant petitioner could not succeed. Since an application under section 17.2 of the Act was not filed, the plaintiff opposite party filed an application under section 17.3 of the said Act, praying for striking out the defense of the petitioner. The petitioner in the written statement to the said application reiterated his stand. There is no existence of the relationship of landlord and tenant as they are Thika tenant under the state of West Bengal.
In this matter, no 7.3 application was filed by them.
No.
Court of its own structure. Which it can be, I mean.
This court in case of Boidonath Kundu versus Josna Rani Kormokar reported in AR 1972 Calcutta 443 held that even if a defendant tenant has not filed any application under section 17.2 of the Act, but can certainly raise such dispute in an application under section 17.3 of the Act, and the court is obliged to determine the same before passing any order striking out the defense of the tenant. Now in the next paragraph, next page.
But the latest judgment of Supreme Court cited by your friend goes against this. You'll also have to distinguish that.
Lordship.
This is Maheshwari's judgment. That
My
was
lord,
what
I am saying, my lord, before your losses, if your
this was the view, consistent view of our High
if
Court.
your losses kindly to consider Vijay Kumar Singh, Maheshwari's judgment latest. This is admittedly a relationship between landlord tenant.
It has been the consistent view of the Calcutta High Court, and it's a West Bengal statute.
But our case is that we are not admitting the relationship of landlord tenant. This is distinguishable.
No, but
in case of landlord tenant relationship between the parties, Vijay Kumar Singh, Amol Boral, or your Maheshwari's judgment, this is perfectly a fit case for adjudications, my lord. But in our case,
no,
this appeal is a
Justice
continuation.
Maheshwari's judgment, landlord-child relationship was not admitted. And that is
7172. This is a case where the relationship between landlord tenant is exist. All these decisions are distinguishable because we are totally denying, and our rights has been crystallized by delivering judgment of the Thika controller. Consistent view is that we have not filed any application as a 7172. We have filed Order 7, Rule 11. That has been rejected. We have taken plea in WS. In spite of that, the court below assumed the jurisdiction of this controller and passed judgment.
So you say, despite the judgment cited by your learned friend, Justice Maheshwari or otherwise, this proposition has not been changed.
Yes.
That even at the 7.3 stage, 17.3 or 7.3 stage, the court has to consider the relationship. But wouldn't that be reopening the 7.2 stage?
Yes.
Justice Maheshwari's order says that 7.2 advantage cannot be taken at the 7th stage. That is the precise finding.
I say that in view of section 9, laid with section 5.3.
These are all High Court judgments.
This suit is ought to be dismissed. This is without jurisdiction.
Provided there is a dispute on record. The previous judgment which you cited, we can appreciate that division bench judgment. The one which you just cited, where it has been said that yes, this if an issue is decided first, an issue is formulated, that has to be decided before striking out the defense. That we'll consider.
Lots.
But this application, this probably has been diluted by the latest judge. Anyway, we'll consider this.
Even Dipcha Dhirawat.
The effect of the Justice Maheshwari's judgment on this we'll consider.
Now, Lord, what it happens in this case?
In fact, this has been the consistent view of our court. We have several times held also this same proposition that at the 73 stage this can be done.
My lord, next decision, your lordships, on 14th November 2024, Your lawsuits passed a judgment and degree. And this has been affirmed by the Supreme Court. I am only citing 2 paragraphs of this judgment.
Division bench?
Yes, your lordship's order has been affirmed by the
So
Supreme Court.
affirming if SLP was rejected, that's
No.
there's no merger.
No. This is a detailed reasonings also has been given.
Oh, this is a full-fledged judgment.
Yes, full-fledged judgment, and it has been last paragraph directed that registered to circulate all over the India.
That is this bench's habit. The latest circulation was one judgment where my order was set aside.
Paragraph.
We're back to square one.
Paragraph 46 and 47.
Yes.
This is 2025 SSC online, Supreme Court 751. Paragraph 46 and 47. 45, 46. At this stage, we should take note of the submission canvassed by the learned counsel that the petitioner is not governed by the provisions of the West Bengal Premises Tenancy Act 1997, and therefore the entire discussion regarding 2G of the 1997 Act was unnecessary. In other words, the attempt on the part of the learned counsel was to persuade us to accept the argument that if Section 2G of the Act 1997 is not applicable, then in such circumstances, petitioner has a right to continue in occupation of the premises in question as the legal heirs of the original tenant. We are afraid, we are not impressed with the submission canvassed by the learned counsel as noted above. We take notice of the fact that this point was never raised or argued before the High Court. We wonder if it was at all argued even before the trial court. We called upon the learned counsel to point out from the reply filed by the petitioner to the application filed by the respondent under Order 12 Rule 6 CPC that this point was raised before the High Court. There is nothing in the objection reply to the petitioner to indicate that such contention was ever raised. On the contrary, para 9 of the reply filed by the petitioner herein, which we have incorporated in para 11 of this order, clinches the issue in para 9 of the reply to the application.
Why are you citing this judgment?
Because, my lord, that I have, in alternative way, I have supporting this, that we have raised the issue regarding the maintainability. That's why I am citing before laws. And 70 was not necessary.
This is not directly relevant here.
Please.
But issue raised means issue is defined in the CPC. Issue if whatever dispute comes up from the pleadings. Pleadings has been defined in Order 6. So pleadings includes plaint and written statement only. So if there is no pleading, how can there be a dispute? Because the issue has been framed in your case on the basis of the written statement, which has been struck out.
Now, one single bench judgment, my lord. I have
Pardon?
cited one single bench judgment, my lord. Additionally, I have cited before losses 2015, volume 5, CHN 175. This fauna rubber practice. Now, this argument is going on before the tribunal. I am arguing this case still continued.
That's
Now, your lordships kindly to see page 7 of this judgment. My lord, in page 7, paragraph, third paragraph, in the instant second appeal. Lordship got it?
Yes.
In the instant second appeal, the defendant appellant filed an application being canned for a direction upon the Thika controller Calcutta Thika tenancy to dispose of a certain matter admitted on May 17, 2010 and for adjourning the second appeal signed with liberty to the petitioner to mention after final order are passed in the matter which was pending before the Thika controller. The defendant appellant had also prayed for interim stay of all further proceedings in the instant second appeal and connected application. By order dated 25th April 2011, this court had disposed of the said application by holding inter alia that the hearing of the second appeal should be adjourned till the disposal of the proceeding which was pending before the Thika controller concerned, and thus adjourn the hearing of the second appeal till the disposal of the proceedings which was pending before the Thika controller concerned, or until further orders which was earlier, and the parties were given liberty to mention with regard to the hearing of the second appeal after disposal of the appropriate proceeding before the Thika controller concerned. This is the fact of the scenario of this case. Now, challenging this order, they have preferred on SLP before the Supreme Court. It appears now on this page, last line, the impugned order, last paragraph, impugned order passed by the High Court staying the hearing of the second appeal filed before the High Court at the instance of the respondent is set aside. The hearing of the second appeal shall now proceed in accordance with law. That proceedings in Miss Case number 30 of 2010 before the Thika controller under the provisions of the Thika Tenancy Acquisition Negotiation Act 2001 shall proceed independently and on its own merits. The Thika controller shall try to dispose of the proceedings expeditiously and shall not grant any unnecessary adjournment.
The next two paragraphs are relevant. In case any final order is passed in Miss Case such and such before the final disposal of the second appeal, it will be open to the respondent to take appropriate steps in the light of that order. And in case, yes.
In case, however, the second appeal is disposed earlier, then the Thika proceedings, and in case the judgment is adverse to the respondent, it will not foreclose the respondent remedy under the Thika Act.
So how is this even relevant?
My lord, page 28. Next.
Page
28.
Yes.
Last paragraph.
Yes.
The learned advocate for the respondent has submitted that as per the order dated 8th August 2011 passed by the Honorable Supreme Court of
Page
India.
28.
Page 28, last paragraph.
That is section 69(2) of the Partnership Act.
And there, the learned advocate for the respondent. Last two lines.
Yes, submitted that order for turn.
Yes. No, order. Page 28.
Page 28 is this page 28. We are following this page.
Yes. At the bottom.
At the bottom, the learned advocate for the respondent
Yes.
submitted.
That as per the order dated 8th August 2011.
No.
Huh?
How can it vary? Show us your copy once. Yes, same page. Last paragraph you are saying?
Last two lines.
Last two lines.
Sorry.
Very well.
That the learned advocate for the respondent has submitted that
Yes.
as per the order dated 8th August 2011 passed by the Honorable Supreme Court of India, the two proceedings, that is the instant second appeal and the proceedings before the Thika controller, must go on simultaneously and independently. It is true that as per the said order dated 8th August 2011, it was observed that the proceedings in the said Miss Case number 30 of 2010 before the Thika controller Kolkata shall proceed independently, and pendency of the second appeal shall not be a ground for staying the proceedings of the said Miss Case number 30 of 2010. But on perusal of the order dated 8th August 2011, it does not appear that the Honorable Supreme Court has been pleased to direct that second appeal should proceed independently, irrespective of the final decision in the said Miss Case 30 of 2010 before the Thika controller, Kolkata. On the other hand, the Honorable Supreme Court in the said order dated 8th August 2011 has been pleased to observe that in case any final order is passed in the said Miss Case 30 of 2010 before the final disposal of the second appeal, it will be open to the appellant herein to take appropriate steps in the light of that order. Honorable Supreme Court has also been pleased to observe that in case the second appeal is disposed of earlier than the Thika proceedings, and in case the judgment in adverse
Yes,
to
why
the
haven't you
appellant-
filed an order for 27? That is our question also.
My lord, I am cited. This is not necessary in view of your lordship's judgment. Your lordships can immediately ask me, so moto take
Which judgment?
the controller's judgment. In his judgment.
Have you got a certified copy of that order?
Yes.
Give copies to them also.
Chief of Controller order দিয়ে দাও।
Why do you say that is not necessary? Order for 2027? Certified copy should automatically go.
এইটা না, sorry, judgment. If your lawsuit such means I'll have to file tomorrow one order.
No, at the hearing stage, we have already heard if this was, when was this passed? This was passed before the hearing of this appeal, much before. You could have filed an order for 2027 much back, long back. দুটো কপি দিয়েছে এখন। ওটা অরিজিনাল সার্টিফিকেট কপি। ঠিক আছে, আপনি এটা রাখুন। Original, keep it with you for the time being. If necessary, we'll take on record.
Your lordships can tomorrow take cognizance by, if you are, I'm producing, this judgment has been said that order for 2027 is not necessary.
আচ্ছা, দেখি সার্টিফিকেট। Very well. So let us see the language of order.
My lord, this particular judgment says that
We will come to this. Give us half a minute.
paragraph one. Subrule 1A and 1A. So modo. 1B. Para 28, 35, 36, 37, 38. And relevant is para 35. Para 35 is relevant. (35) and 36 paragraph. May I please be?
Yes.
A deep reading of all the above judgments and the relevant provisions of the Code of Civil Procedure would leave no doubt that additional evidence, whether oral or documentary, can be received by the appellate court either at the instance of
No,
the.
we agree with this. No application is necessary. That's why I saw the language of for 2027.
Lords.
No application is necessary.
Lords.
Yes, maybe in if it was AA, then might be something ought to be brought on record.
Lords.
But B particularly, even A,
Lords.
A and B, that it was filed but not admitted in evidence, and B, no application is necessary. We agree with this.
And your lordships also held in separate judgment.
Subject to Mr. Bhattacharya's arguments.
The lordships also held your lordships own order that no application is necessary.
Our court's order,
Yes.
this court's order. So why are you citing Madras then?
This is the unreported judgment, my lord. I have collected it, my lord. The lordships can't receive paragraph.
NOC is also not reliable as. Do you know that NOC cannot be cited as a precedent?
Lordships, your lordships can't see your lordships own order paragraph.
No, we generally don't like our own judgments to be cited. But if there is nothing else, then our judgment would prevail over Madras.
Para 10 to 13. দিয়ে দেন ওকে কপি এটা নিয়ে নাও। Para 13 is very well.
No, this is on a different aspect. If there's a conflict between AA and B.
Para 13?
Yes, 13. If B is to, otherwise AA would prevail. If B is to prevail, there has to be a clear finding of the court.
Yes.
Very well.
And so far as with regard to the jurisdictional matter, the civil court jurisdiction and the TICA controller. This is the prime issue in this particular matter. Tomorrow I will have to lapses. Only takes 5 minutes time. 2024 volume 4 SCC 696. This is the last judgment.
Cite it.
I will have to not read it.
2024. 2024.
2024.
Yes.
Volume 4 SCC 696. Here the Supreme Court two separate jurisdiction. Degree has been set aside because this is the outside.
At least one copy you should have brought from your learner, brother.
I am just at the tipping time. I have collected it for study. Very sorry, my lord. I will to supply tomorrow.
Give us half a minute time.
2024 volume 4 SCC.
Give us half a minute. Barcode and share.
696. (696). Kindly excuse me, my lord. I have not details gone into this matter, my lord. Yes, sir.
Yes. Which paragraph?
My lord, I have not detail gone into this matter.
On what proposition?
On what proposition is that the most probably this has come from different state acts where the land land revenue court has special jurisdiction, where the jurisdiction of the civil court has been explicitly excluded by this particular special statutes. In spite of that, judgment and degree has been passed. That's why the Supreme Court set aside the judgment and degree. And here
there's something interesting here.
And there has been jurisdictional issue, pecuniary jurisdictional issue. All has been considered, both fact and law. Detailed discussion has been made by this judgment.
Here, one of the defendants did not file written statement. Other defendant had filed a written statement. Maintainability issue was raised. Absolute necessity of pronouncing at least prima facie maintainability of the suit. But in your case, written statement defense has been struck out. That is his point. Otherwise, you took the point. Even if you take half a line, that is sufficient. But everything is ultimately boils down to that you are striking out of defense.
Most striking atmosphere is that the learned court below, in spite of taking into consideration the jurisdictional factors in 5.3, and he has pronounced his own verdict by assume the jurisdiction of the TICA controller. If I say that this has not been highlighted before the court below, learned court below, after going through the detailed discussions of 5.3 TICA controller and assume the jurisdiction of the controller and passed his own judgment. This is totally without jurisdiction. And I am a TICA tenant, not Bharatiya. So 7172 is no manner of application. This is my humble submission.
All right. Yes.
And in written statement, page 12 of the paper book, your lordships can let to see.
You have taken the point.
Yes.
That is not in dispute also by them.
And I have handed over to lordships the certified copy.
Yes, Mr. Bhattacharya. Yes. Why shouldn't we look into this certified copy? Under 4127 B.
No, Lord. Ultimately, my lord, it boils down to the issue of striking of defense. Suppose your lordship has taken cognizance of this, and your lordship has read. Then, my lord, I can also produce, my lord, my copy of the application, my lord, which has been challenged before the land tribunal.
Please, pendency of appeal. does
Yeah,
not occur.
pendency of the decision is not been taken. It's fixed for hearing. Now, my lord, what happened, my lord? Today, my lord,
Pendency of the ticketency proceedings before the tribunal was known to the trial court. Can everything, all these things be ignored only on the ground that defense has been struck out subsequently?
Because
Just turning a blind eye.
here,
He has
my lord,
taken the point in written statement. There has been an argument on that.
here, my lord,
Evidence has been laid.
here, my lord, order 8 rule 10 becomes very significant.
Order
8 rule 10.
Yes.
Kindly see, my lord, the last judgment which my learned senior friend, my lord, just relied upon 2024 volume 4 SCC, my lord.
Order 8 rule 10.
Kindly see, my lord, where any party from whom a written statement is required under rule 1 or rule 9 fails to present the same within the time permitted or fixed by the court, as the case may be, the court shall pronounce judgment against him or make an order in relation to the suit as it thinks fit on the pronouncement of such judgment or decree shall be drawn up. Therefore, my lord,
how is that relevant?
Yes, kindly see, my lord, order. It says when, my lord, under order 8 rule 1, there is a time limit for fixation of, my lord, time limit
Beyond
given.
time not taken note of.
Now, my lord, they have not chosen not to file written statement.
Here they have filed written statement.
Here, my lord, they are filed written statement. But what is the, my lord, ultimate fate? Ultimate fate, they don't have defense. Written statement is on record. But what is the value of this written statement? In that case, court may, order 8 rule 10 says, court may pronounce a judgment against him. Court may pronounce a judgment against me also. Why? My lord, suppose, my lord, on mere reading of the plaint, my lord, court found, my lord, the suit is otherwise barred under section 34 of the Specific Relief Act. Suit is otherwise barred under Limitation Act. Court may pronounce judgment against me. And if, my lord, on the maintainability issue, I succeed, court will, my lord, pronounce a judgment in terms of order 8 rule 10 as if, my lord, here in case, my lord, the written statement was there, but we have to take it, my lord, his defense has been strike out, even if it is on record. Therefore, my lord, lordship will kindly consider whether order 8 rule 10 situation, my lord, covers here. Number 2, my lord, if your lordship would kind enough to see the next judgment. এটা দাও তো 15/5/15/175
Your cross-examination.
Yes.
Which are those pages? Page 51 or something like that of the paper.
Page 54. 54. Third paragraph.
And page 54, last line.
So you say this is a leading statement. This is beyond the plaint case.
Because there is nothing in my Millard plaint where I have stated they are tika tenants or Millard admitted they are tika tenants. Even if, let us suppose, Millard, I have admitted, Millard, that there is a proceedings pending before the tika controller. But evidence beyond pleading. Evidence beyond pleading. And this is where Millard Modula India Millard case applies.
But isn't a question of jurisdiction, inherent lack of jurisdiction, an issue pertaining to the maintainability of the suit also, which the court has to decide before it proceeds further? because Mr. Bhattacharya, we are telling you this because we are telling against you. Jurisdiction is drawn when a dispute is raised. So we are all relying on hinging on that. All arguments are on that. You say a dispute has not been raised in the suit at all, right? But Mr. Bhattacharya, why should we confine ourselves to a dispute being raised in the suit itself? The requirement of Section 5(3) of the 2001 Act is where there is a dispute as to whether a property is a tenancy property or relationship of tenancy. That dispute has been already raised when the suit was filed in a different proceeding. So a dispute has been raised that is brought to the notice of the court. If that is brought to the notice of the court, even if there is no written statement on board, why should the dispute being raised be confined to raised in the suit only?
Therefore, then my lord, there is no issue. If my lord, no, as my lord just
Issue
now,
of maintainability isn't it a cardinal issue in any suit? And here it was there also.
Maintainability, my lord, as my lord,
Maintainability is not confined in this case to the written statement only.
No, maintainability, as my lord, I just stated, my lord, it may be barred under Section 34 on a plain reading of the plaint. Court may reject under Order 711. Maintainable limitation, maybe. But my lord, here, my lord, kindly see what my lord fell from your lordship, my lord. This maintainability in the why it should be confined in the maintainability of the suit itself. Now, my lord, that is, my lord, again, my lord, I am repeating, my lord, my submissions, my lord, all, my lord, hinges to the fact, my lord, their defense is not there. Their defense is not there. Even, my lord, my cross-examination at page 54. Even I have admitted that there is a proceedings pending before the Thika controller. One, their Order 7, Rule 11 on this ground was rejected.
Obviously, because it's not in your plaint.
Not in my plaint. Rejected.
And so you say the plaint is only what remains.
Plaint.
So the same logic should
apply. Same logic. Ultimately, the same logic. My lord, if my learned friends, my lord, argument is to be accepted, my lord, now Modular India's case, my lord, virtually, my lord, gets diluted.
And one other thing, Mr. Bhattacharya, in this particular case, Order 711 is, yes, we understand your argument on that. But here, if the court had struck out the defense previously, because it's not automatic, 73 says court can strike out the defense. If you see the language, that's mandatory. Court shall. Let us see the language of Section 731.
That is the only consequence, my lord.
Yes.
As
that has to follow as per Justice Maheshwari's
judgment, my lord.
All these, yes. So let us come back to that. If the tenant fails to deposit or pay any amount referred to in subsection such and such within the time, the civil judge shall order the defense against delivery of possession to be struck out and shall proceed with the hearing of the suit. Now, therefore, it had to be before the hearing of the suit at least.
Here, my lord, kindly see, my lord, Justice Chakraborty's judgment once again. My lord, it says, if that is the only consequence, if that is the striking of defense is the only consequence, whether, my lord, whether by an interlocutory order, my lord, or by, my lord, the in a final judgment, my lord, does not, my lord, subject to correction here does not matter much, my lord. Kindly. That is what my understanding.
But court there has to be a positive act by the court. Now, in this case, court had not yet struck out. Every evidence was before it, written statement was before. On the date when it was passing the judgment, written statement was before it, and
court says it's by operation of law.
Yes, you have a point there that the court had no option but could the court still turn a blind eye to this its own jurisdiction?
No, if in that case,
Or you say retrospectively those every defense goes.
every defense goes. If your lordship would kindly see me, Lord, clause D of Order 7, Rule 11.
Yes.
You kindly see, my lord, where the suit appears from the statement in the plaint be barred by any law.
No, it is not applicable.
It is
Does
not
apply.
barred by, my lord. My suit is not barred under the Chica
Of
Tenancy Act.
defense is a stage further than Order 7 Rule 11 stage.
Definitely.
Because there
More
your evidence can be looked into, your cross-examination on the relevant points on your case can be looked into. So Order 7 Rule 11 stage is a bit, the rather defense striking out stage is a bit advanced than Order 7 Rule 11. Pure simplicity Order 7 Rule 11 would not suffice here. So even if it was not done in Order 7 Rule 11 stage, you have to consider whether it could be done later on. And how far this evidence of yours could be gone into. Because in your plaint, you must have claimed that they are ticket tenants.
No,
they are
no.
premises tenants, sorry.
No,
Monthly tenants.
No, monthly tenant.
It's monthly tenant. Obviously, ticket tenant you have not.
Even, my lord, we have annexed, my lord, the exhibited, my lord, the rent receipts under the original landlord. Those are also, my lord, made, my lord, exhibits.
That their tenants in respect of the suit premises you have pleaded in your plaint. So that's within the scope of your pleadings.
Yes.
So can't they ask you a question in cross-examination whether that's a ticket tenancy? Suit property is a part of your pleading that they are tenants in respect of these premises. So isn't that a lacuna in your case, a weakness in the plaint case as handled in Modulo India? But yes, Supreme Court is very careful on that, saying that in the garb of that, they cannot introduce a new case.
New case. That is B of paragraph 24.
So your weakness has to be also on your plaint.
Also, these are my weakness, the examples, my lord, I gave. Like limitation 34, my lord, which, my lord, which is palpable from the plaint itself.
And in your plaint, you have admitted something regarding you subsequently having acquired a property or something like that.
But those are, my lord, grounds of, my lord, section 6.
Seems to be an injustice to them and to law.
Now, my lord, the another judgment.
We try your level best to ensure that your client is defeated. But if law prevents us, we cannot. Because palpable lack of jurisdiction. Court was aware of it. Just because in the judgment it says defense is struck out, so everything goes. I won't look into it. I mean, this
So struck off from the very initial stage of the suit. Otherwise, my lord, Justice Chakraborty's judgment, my lord, loses its significance.
Court has to strike out the defense. Suppose the court does not strike out even in the final.
No, court need not strike out the defense. It says it is automatic. Court has to only recognize it. Kindly see, my lord, kindly see. Court has to only
the tenant fails to deposit or pay any amount. The civil judge shall order the defense against delivery of possession. Not that the defense of the defendant is struck out. No. No.
But
there we beg to differ.
But my interpretation, my lord, by the Honorable, my lord, Supreme Court and my lord, Justice Chakraborty's judgment, my lord, is...
Supreme Court says it's mandatory.
Mandatory, no. The defense, my lord, if my interpretation of the Honorable Supreme Court judgment is...
There Justice Bhattacharya's division bench, the other Justice Bhattacharya, the division bench judgment and Justice Tandon following that.
Those are all 56 Act. Why?
On 56, but the language in respect of the relevant aspect is the same.
Definitely.
Two things considered by Justice Tandon. One is tenant. The division bench considers, and Justice Tandon considers that it's a tenant who is to file.
Yes.
Not a defendant.
Yes.
And secondly, that at that stage also striking out also court has to consider whether there has been a...
My lord, kindly see those judgments. That's why, my lord, I was submitting. My lord, at that point of time, section 17 A and B were there. There was a, my lord, power for giving extension, whether extension taken, extension, my lord, acted upon. These were the factors which were, those are not totally deleted, my lord, in the new Act, 97 Act. These were the factors, my lord, which are to be, my lord, considered. That's why, my lord, it was a beneficial legislation, and, my lord, to some greater extent, protection was given to the tenants in the 1956 Act.
No, but division bench judgment is not on that. Division bench judgment says court several division bench decisions have categorically held that the defense of a defendant cannot be struck out under the provision of section 17(3) if he raises a dispute as to relationship of landlord and tenant. That has nothing to do with 1A, 1B, all those benefits. If he raises a dispute as to relationship of landlord and tenant between the parties, in this case, he has not raised.
He has not raised.
Neither
Another
7.2
advocate-
nor.
And my lord, that my lord view is
No
no longer available in view of my lord section 7 and my lord.
Section 7 is similar to section 17.
Deepchand Hirawat judgment.
Section 73 and 73 are similar. Court cannot consider whether in the meantime they want those 2AB, those exactly. Those cannot be considerations. But the relationship itself here they've not. If they filed a 7.2 also, we would have had some handle.
That is the. Now, my lord, another judgment which my learned friend was relying upon 2015 5 CHN, my lord, 175. My lord, facts, my lord, here, my lord, are completely different. Here, my lord, was a case, my lord, where eviction of a lesser of the lessee by the lessor upon termination of lease. There was no requirement of adjudication under section 7.2. Non-Miller defense was strike off, completely Miller distinguishable on facts. And I was reading from the Miller version, Miller. I had a cursory glance to Fonaraba. This is the Honda kindly.
No, he was on order for Rule 27.
No, my lord, but this is a completely on different facts. Here, my lord, the issue of my lord, defense strike-off was not there. If that is not there, whether my lord under order 41, rule 27, my lord, he could have my lord brought it because
he could not have brought it under order 18. I mean, during the suit, then whether we can permit them at the order for this stage.
That is
the defense is not there in the pleadings. So that will be proved beyond pleading.
That will be proved. Yes, yes. This is my lord,
all boils down to that striking out.
All boils down to sense. And again, my lord, 1998, volume 1, CHN 387, paragraph 11 and 2. This is also my lord 17.2. This is also
all the judgments are on 17.
Exactly, my lord. That is, my lord. That was the my lord view of our High Court, consistent view of our High Court, my lord. Now, my lord, these recent judgments have changed our notion in view of deletion of 17.2A and 2B.
No, but the division bench judgment and Justice Tandon's judgment, that proposition has not changed. If he took an objection as to landlord-tenant relationship, the division bench and the learned single judge Justice Tandon says that even at 7th stage, that has to be done. But you say it's mandatory. That it was all along mandatory.
It was all along mandatory, but kindly see, my lord, the Justice Maheshwari's judgment, my lord, it has to be considered. Kindly comes to paragraph.
Section 8. সবাই পন্ডিত হয়ে বসে আছে হাতুড়ি দিয়ে মারলে সাইড করে দিয়েছে করতে yes 34 right.
On perusal of the facts on the case at hand, the summons was served upon appellant on 29/9/2022. From the next date, that is 30th September 2022 to 27th October 2022, Durga Puja vacation in Kolkata started. As per the provisions of the General Clauses Act, limitation period of 30 days would start from the date of receiving of the summons, and it would complete.
Previously, there was a practice in the Supreme Court, Mr. Bhattacharya. Sometimes mostly it was followed that when a special statute is considered, one of the judges of that court is kept in the bench in many cases. Anyway, need not ensure that they know the law on the subject. Yes.
Prior to completion of Durga Puja vacation, therefore, the rent was required to be deposited within 30 days along with an application immediately on reopening of courts. But the application was filed with a delay of 17 days on 14 November 2022. Therefore, due to non-compliance of deposit and therefore Supreme Court is considering two situations and filing of an application within the prescribed period of 30 days. The consequences specified in subsection 3 of section 7 follow.
This is on a different proposition that the time limit cannot be extended. Previously, it could be extended.
No,
now it cannot.
It says, Milord,
Provision
the
will
consequences follow.
Therefore, consequences section 7.3. 7.3 language is equal to 17.3. But what these benches hold that if a dispute is raised even at that stage, I mean, this is not an adjudication on that.
No.
This says if something happens, they also say consequences must follow. Here it did not fall for consideration before the Supreme Court as to whether if there is a dispute, that question did not fall. Whether there is a dispute as to landlord-tenant relationship, then that has to be decided at the 7th stage also. That was not the question which fell for consideration. This was on the issue of whether the time limit could be extended or because that's a normal consequence. Therefore, due to non-compliance of deposit, if 7.1 or 7.2 is not complied with, 7.3 has to follow. That was the previous view also, unless 7.2a, those considerations were there. But the usual practice in these judgments, it was not a 7.2a scenario or extension of time or something like that. The question which fell for consideration was whether if there's a landlord-tenant dispute, whether that should be decided at the 7th stage even.
Yes.
This is not a judgment on that.
Then Milord, kindly Milord, look at the Milord how the issue was decided by the learned
It says
trial
automatically 7.3 will follow. But does not say that
At
that
what
necessarily
stage?
means
At
no.
what
That
stage?
necessarily means that you cannot look into a landlord-tenant dispute also.
No.
These have not been overruled even by implication. So this is on a different aspect. Here they are handicapped because they have not even raised that issue.
Raised that issue, virtually admitting the landlord-tenant relationship.
7.2 has not been filed.
And 7.2 is dependent upon 7.1.
No, 7.2 itself also mandates you have to put in that money.
That is,
and yes, 7.1 proviso. Even if you file 7.2, you have to comply with 7.2 itself says you have to deposit the amount and subsequent deposits governed by the proviso to 1. And if either of them is not complied with any of these, 7.3 follows.
7.3 follows.
No doubt on that.
Well,
now it's mandatory, proviso is there, negative couched.
Even Milord, kindly see Milord, Justice Sarkar's judgment, Milord.
No, we have held time. You are right. You are right. 7.3 has to follow. Otherwise.
Well, the learned appellate court has gone wrong, Milord, on that count also.
No.
Yes, specifically held he need not file at all.
Even when here there was no 7.3 application, so there was no scope of their objection to that.
No, that is not.
But application is not required.
Court shall strike it off. Court shall strike it off.
We are considering whether the court at the time of striking out should at least consider that if I am striking out a defense under section 7.3, do I have the jurisdiction to impose, invoke that provision?
No, if jurisdiction to invoke, Milord, if Milord, it is otherwise.
Jurisdiction to take up the suit. Whether that is also to be read into section 7.3. That was the context of this. The landlord-tenant relationship is not per se a section 17.3 scenario. That's a scenario of the suit itself, maintainability.
If a lordship would kind enough to see it in this way, if Milord,
like in an injunction, we also consider as prima facie case maintainability of the suit.
Yes,
exactly.
Yes.
You are saying something. Sorry.
No, the 7.3, Milord, if Milord the land, nothing can be cured, then Milord 7.3 has to be taken as automatic. Milord, at the 7.3 stage, Milord, suppose Milord your lordship, Milord, there is an interlocutory order striking out defense.
Court has to mechanically do it. I mean,
court has to mechanically
discretion.
Exactly. He cannot cure that. Whether, therefore, Milord, lordship would kindly consider whether, Milord, it's by an interlocutory order or at the final disposal of the suit, Milord, that will not improve the case of the defendant.
Yes.
He cannot remedy, Milord, he cannot cure the defects, whatever right he had, Milord, under 7.2 and 7.1.
Now we wouldn't advise that. We'll conclude arguments right now. And after concluding arguments, we'll say something. This is all. We are concluding.
Whatever.
We are concluding arguments. In one matter, Mr. Bhattacharya, something similar happened. I was for the tenant. No 7-2, nothing. Landlord decree passed by trial court. First appeal. In first appeal, we took out a 7-2 application, 17-2 application. Justice Anil Sen's judgment is there.
Yes, yes.
Maintainable.
Yes, maintainable. But those are all in 56
That's why we
Act.
concluded,
Those,
just after concluding arguments, we have said this.
those are all, my lord, on 56 Act, my lord.
Why not? Why not in this act?
But if he cannot, my lord,
But yes, 7-3 defense has been struck out, may be difficult. Now it cannot be reopened. Hearing is concluded, judgment is reserved in the matter, full stop. The certified copy and photocopies of an order dated April 18, 2024, filed by the Thika Controller, Kolkata, in miscellaneous case number 14 of 2013, is handed over by learned counsel for the respondent and kept on record. Full stop.
Only relevant portion your lordships cannot to mark it, because
this one,
yes,
need not.
So many returns has been considered. Our relevant return part.
We are not looking into the merits of this. We cannot. Full stop. In all fairness, comma, we also record that learned counsel for the appellant has submits that a challenge has been preferred by way of an appeal against the same by the appellant before the appellate authority, which is now pending.
Land Reforms and Tenancy Tribunal.
And there is no stay.
What did he say? Before the appellate authority? Before the appellate authority, Land Reforms and Tenancy Tribunal. Yes, that now.
And there is no stay.
Immaterial.
Thank you. উল্টে যাবে আমারটা কি জানা যায় Yes.
Lord, I appear on behalf of that.
Yes, sir.
For the state.
Yes.
Well, before my lord takes up, Lord, the impugned order, Lord, I was granted, Lord, a mining lease under the 2002 West Bengal minor mineral rules. The lease was for 5 years. But the 2002 rules provided for that a lease, Lord, is renewable. Renewable for a like period and, my lord, on the fulfillment of the preconditions. One of the precondition was that I need to propose for a renewal at least not before 9 months and not later than 6 months before the date of expiry. Lord, I made an application. Lord, I paid the requisite fee. Lord, in the meantime, the 2002 rules, Lord, were repealed. 2016 rules came in. The entire mode of grant of mining lease was altered. The present rules of 2016 now proposed that it would be through e-auction.
There was no saving clause in that.
There was a savings clause. I come to that. Now, when my application for renewal was not considered, I came up before this honorable court saying that I have filed an application for renewal. The authorities are not considering it.
That you did after the 2016 rules came into force?
Yes. My writ petition has been dismissed not on 2 grounds. First, that the fee of ₹500, which was required to accompany the application, I have nothing to show, Lord, that fee has been paid, although respondents did not take up that point. I have made a pleading that I have paid the fees, and my lord, now have my lord also affirmed my lord a supplementary affidavit, and before the coordinate bench, the supplementary affidavit my lord was filed along with the challan signifying payment of 500 rupees. The second point taken, my lord, was that section 60, rule 61 of the 2016 rule says that on repealing, only what is saved is not a pending action. No new applications not for mining lease sustained. I say that
Pending action.
Yes,
But an
pending applications.
Yours was a pending application.
No, my was an application for renewal. It is not an application for grant of mining lease.
Can you have a copy of the rules?
My lord, yes.
That is all important, apparently.
My lord.
Judgment of আর কি বাগেশ্বর একটা কপি আছে
2002 to? No. 60.
60.
Thank you.
Kindly see rule 61.
Yes, all applications for mining lease.
All applications for mining lease. Well, mine was not an application for mining lease.
Renewal.
Of minor minerals, including the reclassified minor minerals so and so, received prior to giving effect to the rules, irrespective of its duration of pendency, shall become ineligible.
What is the provision of renewal in this 2016?
There is no provision for renewal.
In the earlier rules, do you have a copy of that?
Yes, yes.
Is it there in this? Should be there in the same?
No.
Not there.
Now, finally sees.
The interplay between these two have to be seen.
Yes. And there is a mining lease which is not executed in terms of the then prevalent rules. I say that the state government extends a promise to me. A lease is executed. Whether the government can be held
Contractual also. Contractual also.
Yes. Whether the government can be held to its promise or not.
So far as the renewal is concerned, you are governed by the previous act.
Yes.
Which was contained in your lease itself, which was granted under that.
Yes.
So it's a promise coupled with the statute prevalent at that juncture.
Yes.
Very interesting point.
And my lord, this has been decided by a honorable division bench of our court. And that was when, in the 2002 rules, an amendment was brought identically to give away the then prevalent rules of granting mining lease on an application the DL and RLRO used to decide by omitting section rule 5 to rule 16 of the 2002 rules. The virus of those amendments was challenged before this honorable court. Division bench held that the rules are ultra virus, and also went a step ahead to decide that even if we hold that the rules are intra virus, the right of the petitioner therein to be considered in view of the contractual obligation of the state, that cannot be obliterated.
Your writ petition was for what? What was the relief sought in the writ petition?
Seeking consideration of my application,
that application
for grant of for renewal of mining lease. Kindly take up rule, the old rules, 2002 rules.
Yes, yes.
Kindly sees Lot Rule 12.
Yes.
An application for renewal of a mining lease shall be made to the state government or to an officer duly authorized by the state in this behalf in Form D at least 6 months before the date on which the lease is due to expire, but not before 9 months. So this was a window of 6 months to 9 months. From such date of expiry through the so-and-so in charge of the concerned area or officers as may be authorized. Then you are kindly sees sub-rule 2. No such renewal shall be granted more than once for a period extending the period.
This was your first time.
And then you kindly sees that sub-rule 6. If an application for renewal of a mining lease submitted to the receiving authority within the time is not disposed of before the date of expiry of lease, the period of that lease shall be deemed to have been extended for the period of 6 months. So it was not extended. I am covered by sub-rule 6. At that stage, I am approaching the court and saying that ask them to decide my application under the old rules.
When did you file your application, renewal application?
I filed it, on my challan is of 29th July. The rules came into effect on the 29th July. And my application, is filed on the 30th of July. Both, all this is in 2016. Now, coming to the applications which I have made. Kindly
A 62(2) is also there.
But
2016 Act.
Yes, I was coming to it a little later, but I can show it now.
Let us do this and then.
Yes. Now, kindly see 62. The West Bengal Minor Mineral Rules 2002 is hereby repealed. Notwithstanding such repeal, anything done, any action taken, or any prosecution started under the said rules.
So anything done, any action taken is that coupled with Rule 12 and the clause in the agreement should suffice.
Covers.
And now let us, yes.
Now, kindly see, my mining lease was granted. Kindly come to page 21.
Yes.
The 2nd March 2012. Kindly comes to page 58 of this lease deed. My lord would find
yes,
a renewal clause, which is clause 3.
Right.
Lord, may I please?
Please.
The mining lease shall be renewal for one period not exceeding the period specified in sub-rule 2 of Rule 12 at the option of the lessee. Page 58. Lord, kindly comes to page 87.
Yes.
This is, my lord, my application. But this is the challan, my lord, at page 87.
This was not a part of the writ petition.
This was not a part of the writ petition. My pleading is there. I shall show to my lord.
No
Pleading is there.
No
You
pleading.
craved leave.
No pleading.
No, but you pleaded that you had deposited.
That I have made an application with on compliance of all formalities.
And this is a part of that supplementary affidavit.
Yes, my lord.
No.
Before division bench?
Yes.
It was a division, not a single.
Yes, no. Single bench, obviously it was not there.
But kindly see, my lord, the endorsement.
Yes. 29th August.
My lord.
Yes, Mr.
My lord, kindly, lord, see page 19. Lord, this is 21st of February 2015. Lord, I make this representation that I have filed an application. Kindly see the reference.
This was the immediate cause of action for the lease, for the writ.
This is, Lord, this was a part of the writ petition.
This was the immediate cause of action for the writ petition.
Yes.
This was not considered, so you.
Yes. Now, Lord, may I take my lord to the impugned order?
Yes.
Lord, page number. Lord, kindly see, Lord, page 75. Lord, kindly see the last paragraph on page 75.
Yes.
There is nothing on record to indicate that the petitioner deposited requisite fee of rupees 500 with district magistrate.
Did they file an opposition to your writ petition?
Lord, this, Lord, possibly was disposed of at motion stage.
And while you place it, please ask your learned junior to find out and give us the paragraph in the writ petition where you said that all compliances were done. You can carry on in the meantime. You can just.
My lord. Lord, kindly sees there is nothing on record to indicate that the petitioner deposited requisite fee of rupees 500 with the district magistrate Burdwan for consideration of application submitted by the petitioner under the provisions of Rule 12(1) of the West Bengal Minor Mineral Rules. In the absence of production of documents showing deposit of requisite fee by the petitioner, I am unable to accept the contention made on behalf of the petitioner that the petitioner deposited requisite fee, but the document could not be annexed to the writ application. The West Bengal Minor Mineral Rules 2016 came into force on July 29, 2016. The present application was submitted by the petitioner under the old rules, which have been repealed by Rule 62 of the West Bengal Minor Mineral Concession Rules 2016. Moreover, the application for mining lease filed by the petitioner before coming into force of the West Bengal Minor Mineral Concession Rules 2016 has become ineligible by virtue of operation of law under Rule 61 of the application minor mineral concession rules. As a result, the application filed by the petitioner cannot be considered by the respondent. The application is dismissed. Now, my lord, Rule 61, my lord, I showed to my lord, it relates to applications for grant of mining lease would not be applicable in respect of.
So, according to you, three errors. One is requisite fees. Your best argument could be on this, that you pleaded in your writ petition that there were due compliances, there was no opposition at that stage. It was premature to hold that you haven't. And if this was to be held, you could have been given an opportunity to produce because it was at the outset threshold, and particularly in the teeth of no objection at that stage being filed by them, no opposition. One. Second ground is that Rule 62 was read, but 62.2 was not read. That can be another ground. And Thirdly, that application for mining use section rule 61 is not applicable. This is not a new application. This is not an application for mining lease. This is an application for renewal.
And
There
then
need
my
not have
fourth
been an
argument,
Yes, sorry.
I'm kindly.
No, please continue.
My fourth argument would be,
Yes.
Lord, taking all this into consideration, that I'm hit by 61 and 62. Blood, an incomplete application, blood, is curable.
Yes, that was what you said. If that be so, you could have been given an opportunity to file your
And that is held, my lord, in the said judgment as well. In the judgment which I say.
Curable defects are generally on those grounds even we don't dismiss suits or applications. If the defect is curable, technical defect,
yes,
we don't generally dismiss suits on curable defects.
Yes.
An opportunity is given. Even Order 7 Rule 11 is premised on that.
Yes. The pleasure before my lord, is that even my lord.
I was an advocate.
And even my lord, when I am my lord in writ jurisdiction, I get to hear so much my lord of correlation to the civil. Now, my lord, that decision my lord also holds that the defect was curable, and I could have been asked to deposit.
You can
And-
cite that, yes.
Yes.
And give that paragraph number in.
My lord, paragraph 6 of the writ petition.
Very well.
That your petitioner made the first. I'm sorry.
Writ petition is আমাদের এসছে এখানে?
Look, page 7 of the paper book.
Oh, paper, it's in the paper book?
Yes.
ছেড়ে দাও।
Page 7, paragraph 6, the first paragraph.
In accordance with law.
In accordance with law.
We'll continue tomorrow. We'll cite the judgments and you'll be arguing. So, hard in part for further hearing tomorrow.
I'm grateful.
The lordships leave the next matter.
Call the next matter. I go call 26. Yes.
An odd request.
What is the odd request?
Actually, I'm the respondent writ petitioner. I was successful in my application before the first court, but because of the pendency of the appeal, I was benefited with the order which granted me.
Come closer to the microphone.
I was benefited with an order which gave me a permission with regards to a real estate project. Just because of the pendency of the appeal, that permission has been held.
Appeal before us. This matter, yes.
By HITCO.
You want to withdraw it?
No. This matter, if a time could be fixed. I know your
Okay,
lordships.
no, fix it. We are taking up consecutively.
Aye, Baba.
Whenever Mr. Chaturvedi leaves us alone, and then we'll take. He has already. এটা ফেরত এই বইটা অনিয়ে নেবেন বলবেন 2002 রুলসটা স্পেসিফিক্যালি
matter, my lord. My client is 72 years old.
This is not the mentioning hour. This was the next matters, that's why